First respondent and second respondent is no more, my lord.
Already they have filed for memo for withdrawal, counsel. In subject to court may permit the petitioner to withdraw the above petition subject to return of following articles in the interest of justice and equity. What articles?
The house which has been laid upon, my lord. That is why, my lord, to permit the petitioner to take back the articles, the following articles from the house itself, my lord. That is the reason we have filed the memo with regard to the same, my lord.
Memo copy other side kottidira?
Kottide Swami. They have received
it
19.
Other side service madidira anda ee memo.
Service madide Swami. Service madide.
Yaar other side are counsel appearing for respondent.
Please, my lord, I appear, my lord.
What do you say? Any objections is filed with regard to the memo?
My lord, after the respondent passed away, they have taken all the articles. There is no article as such, my lord, only except a car which is lying outside the house. Let them come now only and take the car and go, my lord.
Yeah. Only
Father
car. But he has given the list. He has given the list.
That list.
He has given the list of 14 articles.
They have already taken and gone, my lord. The
It is-
first
it is-
respondent is no more, husband is no more, father is no more.
Right? Articles are taken.
Going on for the last
15 articles ನೀವು ತಗೊಂಡಿದ್ದೀರಿ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ.
It is taken back, my lord. Only with the car, with regard to car, my lord, not taken, my lord, because with regard.
ಏನ್ ಮ್ಯಾಟರ್ ಹೇಳಿ ಮ್ಯಾಟರ್ ಏನ್ ಹೇಳಿ. What is the matter?
Well,
Was there any earlier order regarding our disposal of these articles?
No, my lord, no such order.
Domestic Violence Act al case file ಆಗಿರೋದಾ?
please, my
Please, my
lord.
lord.
What is the order? Criminal
They agreed to settle the matter, my lord, and therefore I filed the memo in 2000.
filed a memo seeking withdrawal of the petition, so also simultaneously to return the articles as cited in the memo. Hence list these matters next week. None appears for the petitioner in.
Based on the set order, my lord, I filed the memo, my lord, along with the list of articles in return.
Alari, once the articles are with you, then why you filed this rider in the memo?
My lord, memo was filed in 2018, my lord. Later, after filing the memo, I recovered all the articles also, my lord.
Oh, except the car.
Except the car, my lord.
Told. Connected ಇದೆ. Connected ಅಲ್ಲಿ memo ಹಾಕಿಲ್ವಾ?
Connected al memo hakila because I was contesting, my lord. The petitioner is no more, my lord. That order will not survive, my lord. They are also to pay the value of the Santro car, my lord, which is lying outside the house. Now let them come. For the last 4 years, we have been telling, let them come and take that car and go. Now also let them.
ಆಯ್ತು ನಿಮ್ petition ಈಗ ಸರ್ವೈವ್ ಆಗಲ್ವಲ್ಲ?
ಇಲ್ಲ, both petitions does not survive, my lord.
ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು. ತೊಳಿ ಮೇಡಮ್. The petitioner counsel has filed memo for withdrawal of the above petition subject to return of following articles in the interest of subject to return of articles which is mentioned in the memo. The petitioner counsel submits that all other articles are received except the Santro car. That is serial number 1. The counsel appearing for the respondent also submits that the car is lying outside the house and at any time the petitioner can take the Santro car. The counsel appearing for the petitioner also ready to take the car. Udhenri,
Please, my lord.
ready to take the car. And then there is no dispute with regard to the parties. And in view of the memo for withdrawal of the criminal RP, the petition permitted to withdraw the criminal RP 538 of 2011. Next, in connected matter, the petitioner counsel would submit that the petitioner also not survives as the petitioner is no more. Correct, Allah? Petitioner is no more.
No more. We have the order passed by in the earlier petition, it will not survive, my lord.
ಅಲ್ಲ ಅವ್ರು ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ಮೇಲೆ ನಮ್ಗೇನು ಅವರೇ ವಿಡ್ರಾ ಮಾಡ್ಕೊಂಡ್ಮೇಲೆ ಮತ್ತೇನ್ರಿ? And hence
Please,
both, and hence the criminal RP number 322 of 2011 also dismissed.
ನರಸಿಂಹಯ್ಯ ಅವರು
Dismissed as not survived in view of the submission made by
ಸರ್ ಈಗ ಕೇಳ್ತೀನಿ ಈಗ
petitioner counsel. ಅಷ್ಟೇ ಆಗ್ಬಿಡಿ.
ಗೊತ್ತಿಲ್ಲ ಸರ್ ಎಲ್ಲಿ ಅಂತ ಹೇಳಿ ಇಲ್ಲ ಅವರು ಹೌದು ಗೊತ್ತಿಲ್ಲ ಸರ್ ಬಟ್ ಎಸ್
Serial number 4.
ಓಕೆ
Yes, counsel ಅಲ್ಲಿ memo for retirement filed by advocate for
ಹೌದಾ?
petitioner. Non filing of acknowledgement by counsel.
ಅದನ್ನ ಕಳ್ಸಿನಿ ಸರ್ ಈಗ ಜಡ್ಜ್ ಹೇಳ್ತೀನಿ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತೀನಿ ಮ್ಯಾಟರ್ ಇಸ್ ಕಾಂಪ್ರಮೈಸ್ ಅಂಡ್ ವಿಲ್ ಕೀಪ್ ದ ಪಾರ್ಟಿ ಪ್ರೆಸೆಂಟ್ at 2:30 ಅಂತ.
NK Aminullah, counsel Sri NK Aminullah undertakes to file wakalat on behalf of the appellate revision petitioner. ಯಾವಾಗ ಫೈಲ್ ಮಾಡ್ತೀರಿ? ಇವತ್ತೇನ? And if wakalat is filed, show the name of counsel Sri Aminullah and delete the name of counsel Shivagondappa, and counsel Shivagondappa is permitted to retire in view of the undertaking. 2011 matter ಏನಾಗ್ಬೇಕು next? Final hearing. Hence office is directed to post the matter for final hearing. Serial number 5. Non filing of application for bringing LR. ಅಲ್ಲ ಅದಕ್ಕೇನೆ ಇಂಪ್ಲೈಂಟ್ ಸತ್ತೋಗಿದ್ದಾರೆ ಅಂತಲೇ ಈಗಿರೋದು ಅಪ್ಲಿಕೇಶನ್ ಅಲ್ಲ ಈಗ ನಾನ್ ಫೈಲಿಂಗ್ ಆಫ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಬ್ರಿಂಗಿಂಗ್ LR sub.
I appear for the petitioner. Kindly grant me a week's time, my lord. I shall take steps.
ಏನ ನಿಮ್ಮ ಇವರು ಇಲ್ವಂತ ಪಿಟಿಷನರ್
ಇಲ್ಲ ಇಲ್ಲ ಅವರಿದ್ದಾರೆ ಅವರಿದ್ದಾರೆ
ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು ಟೈಮ್ ತಗೊಂಡಿದ್ರಿ ಪ್ರೆಸೆಂಟ್ ಅಂತ
ತಗೊಂಡಿದ್ದೀನಿ ಸ್ವಾಮಿ ಅದು
ಅಕಾರ್ಡಿಂಗ್ ಟು ಹಿಸ್ ಇನ್ಫಾರ್ಮೇಶನ್
I shall get it found out, my lord.
Petitioner is very much alive and press time to ಅಲ್ಲ ರೀ 2 days time ಅಂತ ತಗೊಂಡಿದ್ರಿ ನೀವು ಅಸರ್ಟೈನ್ ದಿ ಕರೆಕ್ಟ್
ಅಲ್ಲ ಅದು no in order to ascertain because that submission was made that petitioner is dead ಅಂತ so I wanted to ascertain.
ಆಯ್ತು ಯಾವಾಗ ತಗೋತೀರಿ
ಅಪ್ಲಿಕೇಶನ್? 2 weeks finally ಕೊಟ್ಬಿಡಿ.
2013 ಮ್ಯಾಟರ್ ರೀ
ನಾನು ತಗೋತೀನಿ ಇಮಿಡಿಯೇಟ್ ಆಗಿ.
ಆಯ್ತು. Petitioner counsel again seeks 2 weeks time to bring the LR sub respondent and hence 2 weeks time granted.
Much obliged.
Narayana Murthy G. Non compliance of office objection for third time. ಯಾರು ಇಲ್ವಾ? Petitioner counsel is absent. Matter is listed for non compliance of office objection third time and hence 1 week time granted subject to payment of cost of ₹500 payable at registry. If cost not paid, list this matter on 9th of March. Petitioner counsel 6 CGP 6 weeks time granted. Serial number 8.
My lords, I beg to appear matter, my lords. My lords, I must fairly concede the office objection must be sustained. My lords may kindly permit me to file a liberty for criminal sir.
Sir, yaro adu mic on ಮಾಡ್ತಿದ್ದೀರಾ? ಆಫ್ ಮಾಡ್ತೀರಾ?
Someone switched on mic. That's why
I believe my colleague Hiremat's mic was on.
ಹೌದಾ? ಮಾಡಬಾರ್ದಲ್ಲ. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ಹೇಳಿ ರಿಗಾರ್ಡಿಂಗ್ ಮೇಂಟೈನಬಿಲಿಟಿ.
My lords, I fairly concede that the office objection of maintainability must be sustained. My lords may kindly permit me to withdraw this petition with liberty to file a criminal petition, my lords, invoking the jurisdiction of this court under 482.
Okay. Petitioner counsel seeks permission to withdraw this petition with liberty to file appropriate petition. And counsel oral submission through VC is accepted and permitted to withdraw with liberty as sought.
And deeply obliged.
Yes. Serial number 9.
My lord, beg to appear for the petitioner in this case. 1 week time granted for to comply the office objection, my lord.
Petitioner counsel seeks to comply with office granted as sought.
Please, ma'am.
ಹಿಂದೆ ರೀ ಮೈಕ್ ಆನ್ ಮಾಡ್ಕೊಳ್ತೀರಿ ನೋಡಿ. Siddharth B. Bachchan. Serial number. Council says 1 week time to comply with office objection granted. Prithviraj VN.
My lord, I pray for a week's time.
Council 6 1 week time granted as sought. Gunashekar. Gunashekar.
ಯಾವುದು
Gunashekar absent.
ಸೇಫ್ಟಿ ಇಲ್ಲ ಅಂತ ಬರ್ತಾ ಇದೆ. ನಾವೆಲ್ಲ ಸೆಕ್ಯೂರಿಟಿ.
Serial number 13 Samartha S.
ಮೊಬೈಲ್ ಗೆ ಹಾಗೆ ಬರ್ತಾ ಇದೆ.
Modification of the order dated 5/4/21. What is that order?
It appears that the respondent number 2 has filed this modification for the petitioner and this.
Chandrahas Rai. What is the modification? Have you received the copy of the?
I have not received the copy, my lord.
You have not received?
I have not received the copy.
Additional counsel submits that he has not received the.
ಅಲ್ಲಿ
Copy of-
FFR.
And hence, respondent number 2 has filed
ಲೇಟ್ ರೀಚ್ ಆಗೋದು.
the petition.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಕ್ ಕಾಣುತ್ತೆ.
Date ಕೊಡೋಣ ಅಥವಾ ಏನ್ ನೋಡಿ?
A month's time maybe. A month's time is fine.
Month's time. We want month's time.
So they are only filing modification. This is a very recent order, my lord. Just to harass it, installed.
Madam ಒಂದು ಟೈಮ್ ಕೊಡಿ. ಆರ್ಡರ್ಸ್ ಅಲ್ಲ 1 month ಬೇಡ, 3 weeks ಕೊಡಿ. 21st of March. ಅದಕ್ಕೆ ಕಾಪಿ ಸರ್ವ್ ಮಾಡ್ಬೇಕು ಇನ್ನು. ಗುರುಸ್ವಾಮಿ BS. 1/2/22. What is the order? ಕಾಸ್ಟ್ ಹಾಕಿದಾರಾ?
ಕಾಸ್ಟ್ ಹಾಕಿದ್ರು.
15,000. ಅದಾ ಲಾಸ್ಟ್ ಟೈಮ್ 25,000 ಕಾಸ್ಟ್ ಹಾಕಿ ಮಾಡಿದ್ವಲ್ಲ ಅದ. ಏನ್ ಮೆಮೋ ಅದು?
Date of events. Date of events.
Date of events ಏನ್ ಕೊಡಿ ಇಸ್ಕೊಂಡು. Recalling the order dated 1/22 ನ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದಾರ ಅದರ್ ಸೈಡ್ ಗೆ.
My lordship, I am for the second respondent in the 14.1, my lordship.
When you files an application before the court, this is the order. ಈಗೇನ್ events ಏನಂತಿದ್ರು? First time complaint, second time complaint. ಏನಿದೆ?
Second time ಆಗಿದೆ.
ಆಯ್ತು, ಕಾಪೀಸ್ ಕೊಡಿ ಅದರ್ ಸೈಡ್, and then I will consider it. See, ತಗೊಳ್ಳಿ ಮೇಡಮ್, ಇದು ಇಟ್ಕೊಳ್ಳಿ. ಹಿಂಗೆಲ್ಲ ಕೊಡ್ಬಾರ್ದ್ರಿ, ಮೆಮೋ ಹಾಕಿ ಕೊಡ್ಬೇಕು ಕೋರ್ಟಿಗೆ ಕೊಡುವಾಗ. ಏನೊಳ್ಳೆ ಅಂಗಡಿಗೆ ಬಂದು ದುಡ್ಡು ಕೊಟ್ಟು ಸಾಮಾನು ಕೊಂಡ್ಕೋತಿರಲ್ಲ, ಆ ಪ್ರೊಸೀಜರ್. ತಗೊಳ್ಳಿ. ನಿಮ್ಗೇನ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲಲ್ಲ ಕೌನ್ಸಿಲ್?
ಈ ಹೊಸದಾಗಿ ಏನು ಕೊಡ್ತಿದ್ರೆ ಅದು ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಇಲ್ಲಿ ಮಂಜುನಾಥ್
I am for second petition.
ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ IA1 for 20.
ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. In 2579 I am for second respondent in this case.
2579 ಅದರ IA ಕೊಟ್ಟಿದ್ದಾರಾ?
ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. I have received the copy of the application.
ಅದ್ರಲ್ಲಿ ಸರ್ವ್ ಆಗಿದೆ, ಮೊದಲನೇದ್ರಲ್ಲಿ ಆಗಿಲ್ಲ. ಮೊದಲನೇದ್ರಲ್ಲಿ ಸರ್ವ್ ಮಾಡಿದೀರಾ? NV ಮಂಜುನಾಥ್ ಸರ್ವ್ ಮಾಡಿದೀರಾ? ಮಾಡಿದಿರಿ ನೋಡಿ ಮೇಡಮ್. 2 to 5 ಅಂತ ಇದೆಯಾ? ಯಾರು ರಿಸೀವ್ ಮಾಡಿದ್ದಾರೆ? ತ್ಯಾಗರಾಜನೇ ಮಾಡಿದಾರ?
I have received for one.
Yes, received in 2579.
Yes, my lord.
What about in 122 or 2567 ಅಲ್ಲಿ? Not found ಅಂತ ಮಾಡಕ್ಕಲ್ಲ. Advocate for respondent 2 to 5 not found ಅಂತ ಈಗ ಮಾಡಿದೀರಾ? ಮತ್ತೆ postal card. Memo along with acknowledgement. Posted on 18/2/22 for recall the order. ಏನಾಯ್ತು ಇದು ಜಾರಿ ಆಯ್ತಾ? ಈಗ ರಿಸೀವ್ಡ್ 15/2 ನ. ಏನ್ರಿ ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ತೀರಾ ಅಥವಾ ಏನಿದೆ ನಿಮ್ದು?
I will file objection, my lordship, in this to this application. Yes.
The counsel for R2 to 5 is absent. Petitioner counsel is present. ಸರ್ವ್ ಮಾಡಿ ಹಾಕಿ ನೀವು, ಅದಕ್ಕೆ ನಾನು ತಗೊಂಡಿಲ್ಲ. The counsel appearing for the R2 seeks time to file objections to IA1/22 in criminal petition number 2579 of 21, and hence list these matters on 14 March. 14th March.
Oblige.
My lord, 21st date was given.
Which one?
Wedding is there in the family, my lord.
21st ಕೊಟ್ಟಿದ್ದೀನಿ.
Wedding is there in the family.
ಯಾವಾಗ ಬೇಕು ಹೇಳಿ? ವೆಡ್ಡಿಂಗ್ ಯಾವಾಗ ಇರೋದು? 20th. ಆಯ್ತು ಹಾಗಾದ್ರೆ 21st ಅಂದ್ರೆ ಮೇಲೆ ಕೊಡಿ ಮೇಡಮ್. ಆ ವೀಕೆಂಡ್ ಅಲ್ಲಿ 25th ಆಯ್ತು. 25th ಆಯ್ತು. 25th. 15 Dalwai Venkatesh. IA 1 for 19 for suspension of sentence. AV Gangadharappa. ಹೇಳಿ. Then what is the matter, madam?
The petitioner company in for purchase of electronic components. They have misused the check for the total worth of 5,77,325 for payment of
Like now concurrent pending. ಹೌದಲ್ಲ?
25% we have paid already when signing the agreement. What is necessary? We follow all the and abide by all.
What is the main ground?
There is a defective notice also. The notice also is not properly issued. And
Both the courts held that notice is proper.
No, it was issued to secretary and later that person was deleted also. That party was deleted from the proceedings.
Yeah, now you pay 50%. Then I will consider it. ಹೇಳಿ.
The address given in the petition. The aspect of the petition.
Present petition.
Not correct. They have changed the premises. Their whereabouts are not known. That is number one. Number two, so far as the service of notice is concerned, first it was said that register was returned unclaimed, then it was said to courier service, returned refused, third time personally served.
But then madam, once it is served personally, how you claim that no proper service?
It was issued to the wrong person, secretary of the, there is no post of secretary in the company itself. And it was issued wrongly to the wrong person also. And that person who is the main person.
3 and 4 are the directors of the company. Number
and
3 is the managing director. Number 1 is the company. All of them have been served.
He had resigned before the proceedings initiated.
What is the finding of the trial court if he has resigned? What is the finding of the trial court regarding service of? Mere taking the defense is not enough. Whether defense is accepted by the trial court, anyhow, let them pay 50% of the amount.
The rest of the 50% will be deposited in the court. They will start to pay me. If I succeed, I will thank the money. For the last 10 years, the check was issued in the month of January 2012. They are unable to get even one file from the company as well as the director of the company.
But already 25% has deposited. 25% ಕಟ್ಟಿಲ್ವಾ? ಎಲ್ಲಿದೆ ಮೇಡಮ್ ದಾಖಲೆ? ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದಿರಿ.
I have the instructions that it is paid.
ಎಲ್ಲಿದೆ ದಾಖಲೆ ಕೊಡಿ ಕಟ್ಟಿಲ್ಲ ಅಂತ ಕಟ್ಟಿದ್ರೆ 25%. ಅಲ್ಲ ಈ 25% ಕಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ you would have executed this order.
Why not changing the address? It's very difficult to.
Then place the document regarding payment is concerned. The counsel appearing for the petitioner would submit that 25% has been paid in the appellate court, and the counsel appearing for the respondent disputes regarding payment of amount, and hence petitioner counsel is directed to place the material for having deposited 25% amount in the appeal. Yavaga 21. ಎಷ್ಟು ದಿವಸ ಬೇಕು?
10 days.
ಆಯ್ತು 14th. 14th.
Even assuming that they have deposited 25% of the amount, if they have deposited, definitely will be admitted. Number 2, as the honorable court was pleased to observe.
Now I am not considering any interim relief as sought. Then next time or produce ಮಾಡಿದ್ಮೇಲೆ if they produce us, then I will consider it. Next submission I will hear. Told this matter on 14th. LCR ಇದೆಯಾ? LCR ಇದೆ ಅಂತಲ್ಲ ನೋಡಿ ಹೇಳಿ ಹಂಗಾರೆ ದುಡ್ಡು ಕಟ್ಟಿರಿಲ್ಲ ಗೊತ್ತಾಗ್ತದೆ. ಆಯ್ತು ಲಿಸ್ಟ್ ಮಾಡಿದೀವಿ 14th ಗೆ ಅವತ್ತು ಅಷ್ಟೊಳಗೆ ನೋಡ್ಕೊಂಡು ಹೇಳಿ. LCR ಈಗ ನಿಮ್ಮ ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ LCR ಅಪಲೇಟ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ ಇದೆಯಾ ನೋಡ್ಬಿಡಿ. ಎರಡು ಇರುತ್ತೆ ನೋಡಿ, ರಿವಿಷನ್ ಬಂದ್ಮೇಲೆ ಎರಡು ಇರುತ್ತೆ ನೋಡಿ, ನೋಡ್ಕೊಂಡು ಹೇಳಿ ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ. 14th March. Next 16 Arun Kumar BR, non-filing of fresh wakalat for petitioner. IA1 for CD of 193 days in filing the criminal RP. 14%. Arun Kumar BR petitioner, non-filing of fresh wakalat for petitioner act ಬರೋದಿಲ್ಲ 14%. Permission ತಗೊಂಡಿಲ್ವಾ ನೀವು? 14% you have to take permission from the office. You make an application for, you have to seek the permission from the court, appear as in person. मतलब last time ಏನ permission ಕೊಟ್ಟಿದೆಯಲ್ಲ ನಿಮಗೆ, engage the counsel of your choice. ಮತ್ತೆ ಬೇಕಾ? ಆಯ್ತು. The petitioner Arun Kumar is present before the court and again seeks 2 weeks time to engage the counsel on his choice as directed by this court, and hence this matter on 14th March. 14th March.
My lord, appearing for the petition in this case, serial number 17, my lords. Well, the matter is compromised between the parties, my lords. Hence, my lords, the matter may kindly be taken at 2:30, my lords. I'll keep the parties present.
2:30.
Yes, my lords.
2:30.
Yes, my lords. I'll file live.
Petitioner counsel 6 time. ಏನ್ ಕಾಂಪ್ರಮೈಸ್ ಏನ ಮಾಡ್ಕೊಳ್ಳಿ, ಏನ್ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೋತೀರಿ? 498.
My lords, the matter had come up before the coordinate bench.
Mostly confirm ಆಗಿರೋ section 3 and 4 ಗೆ ಡೈರಿ ಪ್ರೊಹಿಬಿಷನ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಮಾತ್ರ ಸೆಂಟೆನ್ಸ್ ಆಗಿದೆ.
Yes, my lords, there was a maintenance matter, my lord, pending between the parties and the divorce proceedings also, my lords, and both the matters were closed.
Compromise ಅಂದ್ರೆ once for all ಎಲ್ಲ compromise ಆಗಿದೆಯಾ?
Yes, my lords.
ಏನ್ ಮೇಡಮ್ ನೋಡಿ, section 3 and 4 conviction was passed on section 3 and 4 confirmed also. Compromise ಅಂತಾನೆ ಹೇಳ್ತಾರೆ ನೋಡಿ, ಏನ್ compromise ಬರುತ್ತಾ ಅಂತ ನೋಡ್ತೀವಿ. 18 ST Bhagwan, NR Girish for R1, Rajaram Suryambal for R2, dismissal of complaint. ಇದೀರಾ ಇಬ್ರು ಇದೀರಾ?
I am ready.
Yes. Why you want time, Ray? 2019 matter. You are appearing for whom? 1 now 2 na? 1 R1. ನಿಮ್ಮ ಹೆಸರು ಗಿರೀಶ. Who is? Where is that Rajaram Suryambali? Suryambail.
So far as R2 is concerned,
not filed. Wakalat not filed ಅಂತಿದೆ.
I filed a memo saying that it's not a necessary part.
ಹಾಕಿದಿರ ಮೆಮೊ? ಆಯ್ತು. Then why you want time? ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ ಮೇಡಮ್. ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಎಷ್ಟು ಸರಿ ಬೇಕ್ರಿ ಟೈಮ್?
Going on ad nauseam.
ಲಾಸ್ಟ್ ಟೈಮ್ 21-2 ನಲ್ಲಿ ಬಂದಿತ್ತಲ್ಲ. ಹೌದು. ಅಲ್ಲ ರೀ, 2019 ಮ್ಯಾಟರ್ ಡಿಸ್ಮಿಸಲ್ ಆಫ್ ಕಂಪ್ಲೇಂಟ್. ಇಲ್ಲೇ ನೀವು 10 ವರ್ಷ ಮಾಡಿದ್ರ ಕಂಪ್ಲೇಂಟ್ ಗತಿಯೇನ? ಇನ್ ಕೇಸ್ ಇಫ್ ಕೋರ್ಟ್ ಕಮ್ಸ್ ಟು ಎ ಕನ್ಕ್ಲೂಷನ್. ಲಾಸ್ಟ್ ಟೈಮ್ ಕೇಳಿದ್ಮೇಲೆ ಟೈಮ್ ಇವತ್ತು ಕರ್ಕೊಂಡ್ ಬರ್ಬೇಕಿತ್ತು ನಿಮ್ ಸೀನಿಯರ್ನ. ಆಯ್ತು, ಯಾವತ್ ಬೇಕು ಹೇಳಿ? ಎಷ್ಟು ಡೇಟ್ ಆಗಿದೆ ಇದು?
ಡೇಟು ಹಿಯರಿಂಗ್ ಒಂದು 8 ಸಲ ಆಗಿದೆ. ಜಸ್ಟಿಸ್ ಸುಧೀರ್ ರಾವ್, ಜಸ್ಟಿಸ್ ದೇಸಾಯಿ, ಜಸ್ಟಿಸ್ ಶ್ರೀಶಾಂತ್.
ನನ್ ಮುಂದೆ ಬರ್ತಾರೋ ಅಥವಾ ಮುಂದೆ ಇನ್ನೊಬ್ರು?
ಅದು even in the presence of Mr. Nanaya, whose name my learned has suggested, I would have said he's empty Nanaya.
The counsel appearing for R1 would submit that counsel Sri MT Nanaya is engaged in the matter. ಹೌದಾ? ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ as senior counsel and seeks time and no further adjournment will be given. This matter on next Monday, date 7th of March.
One submission, not on merits are about the case. for any matter to come up before this honorable court with a list, it 2,500 rupees expenses for the High Court.
Once the matter comes, definitely, it costs about.
Yes.
All the services of the officers are engaged, including salary, everything, it is
Including
paper. Definitely. ಅದನ್ನೆಲ್ಲ ಹೇಳಕ್ ಅವ್ರು ನಮ್ ತಪ್ಪು.
This is what
ಹೇಳಂಗಿಲ್ಲ.
This is what
ಹೇಳ್ಬಿಟ್ರೆ ಅವ್ರು ಕೆಟ್ಟ ಜಡ್ಜ್.
This is what his Lordship Justice Anand Bhaira Reddy said in the open court.
Because we avail the services of court officer, our PS, judge, staff, posting of the matter.
Going from one place to other place.
I told you there. Serial number 19, Sharath N, 138, convicted, inadequate penalty, dismissed. ಇವತ್ತು ಇಲ್ವಾ ಪಾಸ್ ಓವರ್ ಮಾಡಿ. ವೆಂಕಟೇಶ್ ಪ್ರಸಾದ್ ಆರ್ ಇಬ್ರು ಇದೀರಲ್ಲ.
Compliance of interim order, condition imposed with interim order to pay 50% of fine. My lord, that has not been paid, my lord. Today I have received the DD, but my lord, they have taken DD, my lord, in favor to deposit before this court. That's my lord.
What is the order? Earlier order.
Earlier order, my lord, that is to deposit before the
What is the order sheet ಅಲ್ಲಿ ಇದೆ ಮೇಡಮ್?
Last time, my lord, they have short time that they want to say this.
Time to saying that if 5 days time is granted, the petitioner will try to settle the matter with the respondent ಅಂತಿದೆ. ಈಗ ಏನಾಯ್ತು, ಸೆಟ್ಲ್ ಆಗ್ಲಿಲ್ವಾ?
Interim order condition and comply ಮಾಡ್ಲಿಕ್ಕೆ 50% amount DD ತಗೊಂಡಿದ್ದಾರೆ.
ಅದಾಯ್ತ್ರಿ, ಫಸ್ಟ್ ಇದಕ್ಕೆ ಸಬ್ಮಿಷನ್ ಮಾಡಿ. ಲಾಸ್ಟ್ ಟೈಮ್ ಏನೋ ಟ್ರೈ ಟು ಸೆಟ್ಲ್ ದಿ ಮ್ಯಾಟರ್ ವಿತ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಂತ 5 days ಟೈಮ್ ಕೇಳಿದಿರಿ. ಏನಾಯ್ತದು? ಆಯ್ತು, ಸೆಟ್ಲ್ ಆಗಲ್ಲ. ಬಿಟ್ಬಿಡಿ ಈಗ. ಸರಿ, ಈಗ ಎಂಟ್ರಿ ಮಾಡ್ರಿ. ಯಾವಾಗ ಆಗಿತ್ತು? 2019. ಇದುವರೆಗೂ ದುಡ್ಡು ಕಟ್ಟಿಲ್ವಾ? ಈಗ ಡಿಡಿ ತಂದ್ರೆ ಏನ್ ಮಾಡೋಣ? ಈಗ ತಂದ್ರೆ ಏನ್ ಮಾಡದ್ರಿ? 6/12/2019 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರೋದು. He shall deposit 50% of the fine amount imposed by the court below, inclusive of the amount which has already been deposited within a period of 6 weeks from today, failing which his order shall stand vacated. ಆಯ್ತು, ವೆಕೇಟ್ ಮಾಡಿ ಆಯ್ತಲ್ಲ. ನೀವೇನ್ ಮಾಡಿದ್ರಿ? If they have not deposited the amount, no order at all. No order at all. This order shall stand vacated. It is not complied ಅಂತಿದೆ. Then why you have not taken steps against him?
Any further steps could not be taken because entire trial court records are before this.
ಆಯ್ತು, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ರೆಕಾರ್ಡ್ಸ್ ಹಾಕ್ಬೇಕು. ನಿಮ್ಗೆ ಆರ್ಡರ್ ತಗೋಬೇಕು, ಪ್ರೊಸೆಸ್ ಮಾಡ್ಬೇಕು.
For executing coercive steps.
Shall appear before the court below or before this court as and when he is ordered to do so. ಆಯ್ತ್ರಿ, ಹೇಳಿ. ಈಗ ನಾನೇನ್ ಮಾಡಕ್ಕಲ್ಲ, ಹೇಳಿ. ಅದು ಆರ್ಡರ್ ಅಲ್ಲ, ಆಲ್ರೆಡಿ ಆರ್ಡರ್ ಇಸ್ ವೆರಿ ಕ್ಲಿಯರ್, ಸ್ಟ್ಯಾಂಡ್ಸ್ ವೆಕೇಟೆಡ್. ತಗೊಳ್ಳಿ, ಹೇಳಿ. ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹೇಳಿ. ಹೇಳಿ.
But exactly the efforts concluded in compromise, I am not proceeding compromise. I'll make my submission, if not concluded by witness, I proceed.
ಅಲ್ಲ ರೀ, ನೀವು ಕೈಯಲ್ಲಿ ಡಿಡಿ ಇಟ್ಕೊಂಡು 2 ವರ್ಷದ ಆರ್ಡರ್ ಇಟ್ಕೊಂಡು ಈಗ ಏನ್ ಮಾಡಕ್ ಆಗ್ತದೆ ಹೇಳಿ?
It is my lord to compliance with the interim order. Respect of compromise.
ಕಂಪ್ಲೈನ್ಸ್ಗೂ ಟೈಮ್ ಇದೆ. ಆ ಟೈಮ್ ಒಳಗೆ ನೀವು ಕಂಪ್ಲೈಂಟ್ ಮಾಡಿಲ್ಲ, ಆಟೋಮೆಟಿಕಲಿ ಆರ್ಡರ್ ಸ್ಟ್ಯಾಂಡ್ಸ್ ವೆಕೇಟೆಡ್. ಆಯ್ತು, ಈಗ ಹೇಳಿ. ಹಿಯರ್ ಮಾಡೋಣ. ರಿವಿಷನ್ ಹಂಗೆ ಡಿಸ್ಮಿಸ್ ಮಾಡಕ್ ಬರಲ್ಲ. ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಹಿಯರ್ ಮಾಡೋಣ. ಏನ್ರಿ, ರೆಡಿ ಇದೀರೇನ್ರಿ?
Yes, my lord, I am ready.
ತಗೊಳ್ಳಿ. ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಸೀಕ್ಸ್ ಟೈಮ್ ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್. ನಾಡಿದ್ದು ಅಂದ್ರೆ ಸೆಕೆಂಡ್ ಅಲ್ಲ ಮೇಡಮ್, 2nd of March. Both the matters. ಹೇಳ್ರಿ. KBK Swami, V Chinnappa.
I am appealing for petitioner.
Respondent, petitioner.
I am appealing for petitioner. I seek for adjournment. One week.
No adjournment. ಅದಕ್ಕೆ ಬೋರ್ಡ್ ಹಾಕಿದೀವಿ. ನಿಮ್ಮ
ಇಲ್ಲ, ಕೈಲಿ ಸೀನಿಯರ್ ತಾಯಿಗೆ ಹುಷಾರಿಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರ ಊರಲ್ಲಿ ಇದ್ದಾರೆ. ಅದಕ್ಕೆ ದಯವಿಟ್ಟು ಐ ಆಮ್ ಎ ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್.
7.
Thereafter, my lord, they were directed to pay a fine amount of 38.55 lakhs. Compensation 38.5 lakhs. Thereafter, my lord, they have filed a criminal appeal.
The lower appellate court, my lords, had directed them to pay 20% of the fine amount. My lords, they have not done that.
They have not deposited the amount also.
The lower appellate court. Thereafter, my lords, the appeal can be discussed before the lower appellate court. They filed a special petition. They filed an IM, my lords, for suspension of sentence, my lords, on 13 December 2019. This honorable court, my lords, has allowed the right and directed them to deposit 50% of the amount within a period of 8 weeks. Thereafter, my lord, they filed an IA for extension of time. It was considered, my lord, on 14th February 2020. On 14th February 2020, my lord, they claim to have deposited an amount of only 2 lakhs before the trial. Balance amount of 17.25 lakhs was yet to be deposited. Totally 19.25 lakhs. Our Mela Prakara, 2 lakhs was deposited in one week. Thereafter, they were given a further period of time of 2 weeks in which they had to make the balance payment of amounts. They did not make that payment of amounts. Finally, my lord, on 23rd November 2021, when the matter came up before this honorable court, my lord, passed an order stating that no amounts have been deposited by them. And therefore, my lords, whatever, even though the conditional stay order, it was being vacated. My lords, we have been trying to take the necessary steps before the trial court as well, my lords, for execution of the judgment. Some difficulty there as well, my lords, because even though the court has issued the necessary warrants, my lords, it's unable to be executed as against the petitioner's hearing. Petitioner's hearing, my lords, in this matter, they have been constantly seeking adjournments for this matter.
Yes, counsel.
Kindly, I seek for adjournment. The senior counsel, Tai Gusharila Swami, is in out of station now. So kindly 2 days time may be given, Your Honor.
Order sheet last time 11/2 ನಲ್ಲಿ ಏನು ಸಬ್ಮಿಷನ್ ಮಾಡಿದ್ರಿ?
ಅವ್ರ ತಾಯಿಗೆ ಇನ್ನೂ ಹುಷಾರಿಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರಿಗೆ ಸ್ಟಿಲ್ ಶಿ ಇಸ್ ನಾಟ್ ಫೀಲಿಂಗ್ ವೆಲ್. ಅದಕ್ಕೆ ಅವರು ಅಲ್ಲೇ ಊರಲ್ಲೇ ಇದಾರೆ ಸ್ವಾಮಿ ಈಗ.
ಅಲ್ಲ ರೀ, counsel for the petitioner is present and prays for time as the senior counsel is not well. ಅವತ್ತು senior counsel is not well. Today senior counsel mother is not well. ನಂಗೆ ನಮ್ಮ ಕೋರ್ಟಿಗೆ junior is enough argument ಮಾಡಿ ಕೇಳೋಣ.
Kindly 2 days time may be given.
No date, counsel. Argue.
I am a proxy counsel. Kindly consider my sincere.
No, counsel. Every time comes and you have not complied the order of the court. Earlier order granted by this court for suspension of sentence and not complied the amount order passed by this court. Every time you comes with either senior counsel is not well or senior counsel mother is not well.
No, my lord. Kindly 2 days time may be given, my lord. Kindly. My sincere apologies, my lord. Kindly.
What is your good name?
My name is Krishna Patil.
Where is other two counsels? KBK Swami and Srina?
Yes, you know, my senior. I'm a proxy counsel. Kindly. Today is not
senior proxy counsel. I don't understand what submission you are making.
Counsel, Your Honor. I myself is proxy counsel. My senior is KBK Swami.
Your senior is KBK Swami.
Yes, Your Honor.
How you become proxy counsel? You are from the same office.
I'm not in the Vakalat.
Where other two persons who have filed the Vakalat? Ravi Kumar and also the.
They have left the office. They have left the office. They are not in the office. They are not in the office now. They are in my office. Kindly.
Where is KBK Swami now?
Now he is in his native place, Your Honor.
Native place. Let him be there. Once he has filed the Vakalat.
No, my lord.
Let him be there in the native place itself.
Personal inconvenience.
No personal inconvenience is a ground to seek for an adjournment.
My apologies, from kindly consider my 2 days time may be given.
You are in the same office. I will permit you to argue the case. You argue.
I am not
junior of KBK Swami.
I am not.
I will permit you to argue.
I am not aware of the facts and the total.
You read the file. You read the file. File itself will give instructions to you.
Time may be given.
You read the file.
I will only argue so me 2 days time may be given to see the file.
No, day after tomorrow. Day after tomorrow.
Much okay.
They have deposited an amount of 2 lakhs.
2 lakhs. Already they have deposited. Earlier, what is the order earlier? For release any order? No order. Anyhow, he will argue the matter on day after tomorrow. Right. The petitioner counsel again seeks time on the ground that senior counsel mother is not well. And the counsel appearing by the respondent would submit that the petitioners even they have not complied the order passed by this court to deposit the 50% of amount. There are no grounds to adjourn the matter. However, in the ends of justice, one more opportunity given, miss this matter day after tomorrow.
Much okay.
2nd of March. Counsel, if senior is not well, then you come and argue.
Yes, yeah.
Yes. Prithviraj BN.
My lord, I am for the petitioner.
Yes, counsel. P. Nataraj.
4,75,000 is the check amount. 5,50,000 is the fine amount. We have given a proposal to the respondent. I spoke to respondent's counsel yesterday. He said he will discuss with his client and get back.
Yavat settlement report ಮಾಡ್ತೀರಿ 1 week told
we'll have it on 15th ಅಥವಾ 16th ಹಾಕೊಂಡ್ರೆ we will report the
ಏಕೆ ಅವರು only reply ಮಾಡಬೇಕು ಅವರು reply ಮಾಡಕ್ಕೆ ಮಂಡೇ ಕೇಳ್ತಾ ಇದ್ದಾರೆ
ಅವ್ರ ಸೀನಿಯರ್ ಒಂದು 10 days ಟೈಮ್ ಹಾಕೊಳ್ಳಿ ಅಂತ ಕೇಳಿ
10-2 ನಲ್ಲಿ ಆಗ್ಬೋದಾ ಆಯ್ತು petitioner counsel seeks time on the ground that he has already given proposal and counsel appearing for the respondent also submits that they have given proposal and hence both seeks time and hence list this matter on 14th March.
My lord, 14th I will not be in session. Kindly have it on 15th
March. 15th March. 15th March. KP Bhuvan. Sanchan. Nadiger. Last time he took time. At the request of learned counsel, petitioner leave list this matter. What happened? This is also 138.
138. Check of rupees 3 lakhs. Taken by the accused.
ಅದೇ 5ನೇ ತಾರೀಕಿನ ಬಂದು ಹೋಗ್ತಾರಂತೆ
ನಾವು ಕನ್ಕರೆಂಟ್
ಇಲ್ಲೇ ಇರ್ತಾರೆ ನಾಳೆ ಶಿವರಾತ್ರಿ ಇದೆಯಲ್ಲ
ಪಾಸ್ ಓವರ್ ಮಾಡಿ ನೋಡೋಣ ಬರ್ತಾರೆ ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ ಡೇಟ್ ಕೊಡೋಣ 2 days ತಗೊಳ್ಳಿ petitioner counsel absent last and order sheet also reveals that last occasion petitioner counsel took time and hence list this matter on ಈ week ಅಲ್ಲೇ ಕೊಡಿ ಮೇಡಮ್ 4th of March. Serial number 25 Aditya S. Kumar. G. Jairaj.
This case,
Stake 40% ಕಟ್ರಿ ಅಂತ ಕಟ್ಟಿದ್ದೀರಾ
ಇಲ್ಲ ಸ್ವಾಮಿ ಯಾಕಂದ್ರೆ this already the petitioner has paid 20% of the amount in appellate court because he is not in a position to pay because of COVID and he is not in a position. That's why this court has given liberty to the respondent to execute the entire fine amount.
Entire fine amount.
Yes, Swami.
Where is that order? Where is that order?
Last order. Around this case, the trial court has failed to take the
liberty to execute the order passed by learned respondent has liberty to execute the order passed by learned trial magistrate confirmed by the first appellate court in accordance with law. Office is directed to return the lower court. Directed to return the lower court records. Post this matter for admission on 19/1/22. What happened on 19?
The trial court has not taken the 313 statement and there is no trial has been conducted.
No trial.
There is no trial and there is no 313 statement has been taken by the trial court and straight away passed the judgment everything. And the
where is the order?
Cannot see page number 33. It's very clear in the para number 5 of the page number 37. The present complaint is a summary trial, considered criminal in nature, like a recovery person. Hence, the recordings of a statement under section 313 of CR was
dispensed with.
And that's a 313 statement is the fundamental rights of the accused to give the this 313 statement, and this dispensation is a clear violation of the Article 21 also, because one thing is that in this case, without the trial, there is no possibility of being given to the
defense evidence. The accused failed to examine PW1. Have you cross-examined PW1?
ಇಲ್ಲ ಸ್ವಾಮಿ ಮಾಡಿಲ್ಲ ಮಾಡಕ್ಕೆ ಬಿಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ.
Have you cross-examined PW1?
No.
Why not allowed you
Because,
to
because
cross?
you didn't allow, and straight away it's passed the judgment. You didn't allow me because of non-payment of 20% of the amount.
20% of interim compensation you have not paid. Then statute says defense has to be struck down.
So it can be recovered as if the 421 of CRP says a fine. It can be because it's clear in the CRP version. It can be recovered as
Non-payment of interim compensation.
yes, it can be recovered.
What is the law?
If the
Counsel, answer to my question.
yes, my lord.
If non-payment of interim compensation, what is the law?
It can be recovered as a fine under section 421 of CRPC, my lord. It's clear.
Regarding defense. Regarding defense.
Defense has no, my lord.
In view of the amendment, counsel, in view of the amendment, the counsel for accused failed to appear before the court. Even you have not appeared before.
My lord, I have already filed a form 45 CRPC as well as
you never went to court for cross-examining the PW1.
I have filed already the application under section 145/2 for the purpose of
what happened?
at the time of itself for the time of filing mail application.
What
it
happened?
has not been considered, my lord.
What happened, counsel?
It has not been considered.
Further, even on 19/1/20, the counsel for accused failed to appear before the court. In spite of issuance of NBW from 2/1/2019, they have not filed any application under 145(2) for adducing defense evidence. Hence, defense evidence is taken as no evidence. Since accused has not at all crossed PW1, the evidence of PW1 is unchallenged one. And the accused has violated the mandatory provisions of section 143A of the NI Act. Hence, defense evidence is struck off. Hence, defense evidence is taken as no evidence. I am relaying the citation reported in so-and-so Supreme Court, so-and-so.
Yes, my lord, it's a fundamental rights to the, my rights has been denied. There is no 3-1 statement has not recorded because there is no opportunity has been given to me to the record such statement. In such cases, the straight away the court has considered the petitioner's complainant's view and passed the order against me 15/2/2019.
313 statement ಯಾವಾಗ record ಮಾಡಕ್ಕೆ counsel?
Samidharalli after the evidence, but evidence ಮಾಡಕ್ಕೆ ಬಿಟ್ಟಿಲ್ಲ.
Have you appeared before the trial?
Yes, definitely, but appears ನಮ್ಮ cross ಮಾಡಕ್ಕೆ ಬಿಟ್ಟಿಲ್ಲ because of this.
Hey, counsel, ನಿಮ್ ಕ್ರಾಸ್ ಮಾಡಕ್ ಬಿಡಬಾರ್ದು ಅಂತಲೇ section 143A ಇರೋದು. Defense has to be struck down if you are not complied with the order passing of interim order. That's what the judgment and that's what the act.
Yes, my lord.
ಮತ್ತೆ ನಿಮ್ಮನ್ನ ಹೆಂಗ್ ಮತ್ತೆ ಬಿಡ್ತಾರೆ 313 ಗೆ?
Even it's my lord, 313 is the.
You are arguing against the statute.
No, it's not because 313 is my right. No, that's why I'm arguing.
That's all. You are right. You are right.
Can you see, Lord? The 313 statement is my. See, kindly see the 7 judgments of honorable upper court in this. First one is Janay Yadav and others versus State of Bihar. Kindly see the page number 2 and 3, my lord.
This is in respect of the which offense?
That's it's not in connected with any other criminal case. It's
you are not answering to my question.
Yes, my lord.
What is the offense in this case?
Offense?
Janak Yadav and others. What is the offense?
It's there. It's mentioned in this case. It's a classification as mentioned.
You are not answering to my question, counsel.
Yes, my lord.
In this judgment, what is the offense? Is it 138 Act?
No, it's not under the 138.
No, then next. Under the 138 Act, there is a specific provision under section 143. Then another judgment.
All the judgments
don't try to fool the court.
No, my lord, apologies, my lord. If it is it's I apologize, my lord, because it's a person of this.
Any judgment in respect of section 138, which you have.
Nothing is there.
Nothing is there. Then why you are placing all this judgment?
Because it's connected also 313 statement. That's why I'm filing this.
That's all your argument.
There is no opportunity has been given to me to use my evidence, and there is nothing there. That's why I'm filed.
What is the finding of the trial court? Revision scope is very limited. Only if any illegality committed by the trial court, then you can consider it. Appellant accused failed to deposit 25 of check amount which was stipulated term, hence no compliance of mandatory provisions of 143 practice made by the accused. Complainant proved the ingredients required to be proved for offence punishment of 138 of an act, relying upon laid down in the judgment source of trial court discussed with personal affairs of the accused and pronounced statement, relying upon the directions issued by the Supreme Court of India in so Indian Bank Association and another association, trial court proceeded to pass judgment. Accused not even to raised any complaint before police against the complaint for misuse of this check. Accused not even filed private complaint against complaint before magistrate. Accused not even instructed banker to stop management and loan check was presented. Difficult to accept the contention raised by the appellant in this appeal that is not able to make payment on loan check. Enact ಕೊಡಿ ಮೇಡಮ್ ಇದೆಯಾ? That's all, counsel.
Yes, sir.
Good. This matter is listed for admission. What the counsel appearing for the petitioner? The counsel appearing for the petitioner would submit that the trial court has erred in stuck up the defense of the petitioner herein. And the same amounts to violating the principles of natural justice and also violates the Article 21 of Indian Constitution. And right to fair trial has not been given. And there is a presumption of innocence. Prosecution must prove its case beyond reasonable doubt. Case 143A of NA Act, except is being an interim compensation order for the trial of criminal cases. The same has been passed pre-trial. A serious prejudice has been caused to the accused division petitioner. And amended provision only helps the courts to take adverse inference against the accused persons in a pre-trial stage. Moreover, it will defeat the valuable right available to the accused. And it is not the meaning that the accused division petitioner has committed the crime or accepted the accusation made in the complaint. The same can be recovered invoking section 421 of Code of Criminal Procedure. Unfortunately, the trial court has not followed the procedure established by law. And instead of that, the straight away division petitioner is nothing but illegal and arbitrary. And hence it requires interference of this court. The counsel also, in support of his argument, he relied upon several judgments along with the memo with citations. And all these citations are not in pertaining to the 138 offense, invoking section 313 of statement of accused. The main contention of the petitioner counsel is that 313 is not recorded before the trial court. And the very approach of the trial court is erroneous. Having heard the petitioner counsel and also the counsel appearing for the heard the counsel and also the principal stated in the judgment, I have already pointed out that these statements are not in connected with offenses in 138 of Negotiable Instrument Act. The trial court in paragraph number 5 held that the complaint is a summary trial. And recording of statement 313 of CRPC was dispensed with. The defense also not adduced any defense evidence and also not cross-examined with PW1. It is also observed that even on 19/1/2019, the counsel for accused failed to appear before the court. In spite of what the NBWA has been issued, they have not filed any application under 145(2) for adducing defense evidence. Hence, the court has taken as defense as no defense evidence. And not at all cross-examined PW1. And the evidence of PW1 is unchallenged. And also mandatory provisions under 143 of NA Act is also not complied. Hence, the defense was struck off. While struck off the defense also, the trial court relied upon the judgment of Supreme Court reported in AR 2015 SC 2528. In Indian Bank Association and others versus Union of India and others. And also taken note of section 138, 143, 145, Designer of check is a summary trial. The trial court also, considering the material available on record, taken note of the documents which have been marked on behalf of the complainant. That is, documents exhibit P1 and 2 are two checks, and exhibit P1A and P2A, signature of the accused and bank endorsements, legal notice, postal receipt, unserved postal envelope, loan agreement, and renewed of loan agreement. And in paragraph number 11, 12, if really accused oblique petitioner had not at all borrowed the loan in question, he would not at all have issued the exhibit P1 and P2 checks. And also not cross-examined PW1 and not let any defense evidence also. And also there is no dispute with regard to the exhibit P1 and P2. It is also emerged in the records that the accused has not paid the amount as ordered by the trial court to pay the interim compensation. And hence comes to the conclusion that the accused has received the check, convicted the accused to pay the amount of this 20 lakhs 93,000 And the same has to be paid as compensation. And in default of payment of fine amount also ordered to undergo simple imprisonment for a period of 3 months. Being agreed by the said order, an appeal is also filed before the appellate court, raising the very same grounds. And the appellate court also taking note of the material available on record in paragraph number 18 comes to the conclusion that the documents which have been exhibited corroborates the case of the complainant. And also taken note of PW1 has not cross-examined, has not been cross-examined. And defense set up by the accused is that statement of accused under section 313 is not recorded. Matter shall be remanded to the trial court. The trial court also has considered the evidence adduced by the complainant and further observed that despite sustained opportunity, applicant failed to deposit 20% of the amount. And there was no any compliance of mandatory provisions of 143 of an act. The apex court also and taken note of the judgment of the apex court in Indian Bank Association and another case. And appellate court also comes to the conclusion that the petitioner herein has not availed the right to cross-examine the witness and also not complied with the order as mandated under section 143A, and taken note of even the quantum of compensation ordered to pay against this petitioner and confirmed the judgment of the trial court. Having heard the respective counsel, the scope of revision is very limited. The court has to take note of if any illegality committed by both the courts, then court can exercise the revision under section 401 of CRPC. If the material placed by the trial court is not considered and if the judgments of both the courts are perverse, then the court can invoke section 401 of CRPC. Having considered the material available on record, I do not find any perversity as well as any illegality committed by the trial court. The records reveals that the trial court has passed an order invoking under 143A to pay the 20% of the amount, and the same is also not paid. And also even not cross-examined the PW1 and defense was struck down. The very argument of the petitioner counsel that 313 statement was not recorded, and in support of his contention, he relied upon 7 judgments and those judgments are not in respect of the 138 Act and for the other offences. The very provision under section 143A is very clear that in a case of check bouncing case, the interim compensation can be granted up to 20%, and the very order has not been complied, and defense was struck down, and the mandatory provisions also not complied. The other contention of the petitioner counsel that the said amount could be recovered under section 421 of CRPC and cannot struck down the defense. And the said argument is against the principles laid down in the judgment of the apex court. Hence, I do not find any merit in the revision petition to interfere with the findings of both the trial court as well as the appellate court. You have the discussions made about revision petition is dismissed. Murthy.
Serial number 29, my lord.
26.
Sorry.
26.
Sorry, my lord.
Pasor. Dilraj. No counsel 21 matter really. What are the grounds?
Offense under section 138 of NIA. concurrent finding. Specific contention of the petitioner minutes that check was issued for the loan obtained for the year 2012 minutes and have misused by the complainant. So substantiate the same minutes. Page 21 minutes. Observation made by the first appellant.
What is the observation?
In the cross examination, there is 1/8/16. PWM stated that he is engaged in fish business and real estate business, and his income is 2 to 3 lakh per annum. PWM submitted about filing income tax returns providing 2 to 3 persons by cash. PWM submitted since the last 10 to 15 years, himself and accused are known to each other. Submitted that he does not remember period in which for the first time lent money to the accused. However, during the 2014, finally lent money to the accused. PWM submitted that about 20 to 30 times money might have been lent to the accused, and during 2014 lent rupees 8 lakhs. Not so, but para number 9. PWM submit that accused repaid cleared earlier loan by way of cash and check. PWM submitted that no documents have been collected while lending rupees 8 lakh to the accused. Now, question of submitting check does not arise. Here he says he has not collected any documents while lending rupees 8 lakhs.
Any documents means check other than check kanta.
Yes,
you are not disputed the issuance of check.
Yes, we are saying that we have.
But what is your defense?
We are saying that we have issued the check for the year 2012, loan obtained in the year 2012. Same was misplaced by the accused, by the complainant. Not so by writing the amount of rupees 8 lakh and claiming that he has obtained the loan in the year 2014. Any contention what we have taken before the trial court. Page 14.
Concurrent finding, Ray, what is the illegality committed by the trial court? Scope of revision is very limited. Concurrent finding is given by the trial court. What is the error? What is the error in appreciating the evidence? Any illegality? Any perversity? Any perversity? Are you challenging the propriety of the order? Partly allowed and from the firms of support convicted accused by any act with respect check mark is thereby confirmed. Sentencing to suffer for a period of 1 year to pay fine of rupees 16 lakh. In default of to suffer for a period of 1 year is modified. SI for a period of 1 year in default. What is the error?
Further says that he has lent money to 2 to 3 persons.
DW submitted that except the signature made on the check, he never wrote contents of the check marked as D1 submitted that he received notice sent by the complainant. However, never sent any reply. Reply no kuda kottilla. Notice receive ಮಾಡಿದ್ರಿ. ಈಗ ಬಂದು ಸ್ಟೋರಿ ಹೇಳ್ತೀರಿ. ನಾನು 2012 ಲೋನ್ ತಗೊಂಡಿದ್ದೀನಿ. But inquired the complainant when inquired the complainant about notice, informed that wrongly notice was issued. DW submitted that he never due to pay any amount. In the cross examination also, engaged in money lending business in 7 to 8 years, any complainant who maintained a money lending shop. Submitted about availability of the documents to show borrowing money during 2012. ನೀವೇ ಒಪ್ಕೊಂಡಿದ್ದೀನಿ ನನ್ನ ಹತ್ರ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇದೆ 2012 ತಗೊಂಡಿದ್ಕೆ ಅಂತ, but no such documents are produced before the court. DW1 submitted that subsequent to 2000 never borrowed money from the complainant. DW1 submitted during 2000 purchased a tipper and denied the suggestion that during 2014 borrowed some of the complainant to purchase tipper. DW1 submitted he never recollected check given to the complainant as a security and admitted the check marked as bears his signature. These are the findings. Even you have not relayed any reply also you have not given. Yes, exhibit D1 what is that exhibit D1?
Statement of account
Statement of accused.
Page 27. Para number 18.
No.
In the case shows that since 2/3/2012 to 3/9/2012, accused from his account transferred totally 22,85,000 to the account of the complainant. That's wherein I have made the payments. Since I have not disputed, my lords, the contents of exhibit B1 to B5.
That's all.
On the other hand, my lords, the complainant says he has lent money to 2 to 3 persons. My lords, however, he has not furnished any document to show that he has a money lender. My lords, and he has lent money. And we have also questioned the financial capacity of the complainant, my lords, wherein he says he has sold his property worth rupees 15 lakhs and he has made the payment of rupees 8 lakhs.
Even the main defense, you know, you have availed the loan in 2012, not in 2014. Oh, the law. Have you placed any document for having received an amount of in 2012?
Complainant himself has admitted, my lords.
What he says?
On earlier occasion, he has made the payment.
Earlier occasion, but not in 2012.
But further he says prior to 2014, he does not remember particular date of lending of money.
No, SK Acharya ಬರ್ತಾರೆ ನೋಡೋಣ pass out. Discuss ಮಾಡೋಣ.
Kindly have it next week, my lords.
No, counsel, I have already heard. Let him come. ಅದೆಲ್ಲ ಮುಂಚೆ ಕೇಳ್ಬೇಕು. ಈಗಲೇ ಇಟ್ಟಿದ್ದೀನಿ ನಿಮ್ ಸೀನಿಯರ್ ಕರ್ಕೊಂಡ್ ಬನ್ನಿ. I will hear you. Senior answer. No, counsel. Otherwise you already argued. No, counsel, no date. ಒಂದ್ಸರಿ ಪಾಠ ಮಾಡಿದ್ಮೇಲೆ. 28 Shankarachar Kasol Murthy DL.
For the petition this matter, my lord. Concurrent findings, my lord. 138 of NIF.
What is your defense?
My lord, before the tribunal they have not produced any loan documents, my lord. After
loan
the
documents, check ಹಾಜರುಪಡಿಸಿದರಾ?
Only check, my lord. Then they have produced only loan account, my lord. It is in handwritten, my lord. Thereafter, I have before the first appellate court, I have filed the IA for production of all documents, my lord. But they have produced before the first appellate court only, my lord. They have not cross-examined they have not.
ಹೇಳ್ರಿ ಕೌನ್ಸಿಲ್. ಏನು ಹೋಯ್ತಲ್ರಿ ಮೇಡಮ್?
Before the first appellate court.
What is the error? What is the error? I am sitting under revision. What is the error? Concurrent findings are given by the trial court both.
Yes,
what is the error?
The
error apparent on record. We exercise the revision.
Loan sanctioning and obtaining the loan is also.
ಗೊತ್ತಾಗಾಯ್ತಲ್ಲ ಮೇಡಮ್, ಅವ್ರದ್ದೇ ಸರಿ ಇಲ್ವಾ?
The respondent have not produced any loan document also. I have not filed a loan application also, my lord. As per the exhibit P6, my lord, that is loan account. The respondent have given loan 5 time, my lord. Kindly pay ink page number 6, my lord. I have entire details I have produced, my lord. Ink page number 6, my lord. My petition. First loan amount of rupees 50,000 was sanctioned on 17/6/2009, my lord. And on the same day it was cleared. It could be seen that exhibit P6. Second loan amount of rupees 70,000 was sanctioned on 17/6/2010, and on the same day it was cleared in one installment. And third loan amount of rupees 75,000 was sanctioned on 4/7/2011, and it was cleared on 26/2/2013 in one installment. And fourth loan amount of rupees 1 lakh was sanctioned on 28/2/2013 within 2 days from the date of third loan was cleared. and it was cleared on 5/7/2014. One loan and fifth loan amount of rupees 1 lakh was sanctioned on 7/7/2014. Within 2 days from the date of fourth loan was cleared. It is evident from Exhibit P6, my lord. My contents is I have obtained only one first loan, my lord. That is 50%. And second, third, fourth, fifth loan I have not collected, my lord. I have not borrowed the respondent, my contention, but they have not produced any single of document, my loan application they have not produced. I have not filed any application for loan. They have produced only loan account, that is handwritten document.
Exhibit P6 to 8 is a notary.
That is
Ledger copy of ledger account. Exhibit P6, Exhibit P7 copy of savings account. Exhibit P8 copy of loan account.
P6 to P18, it is handwritten document, my lord. Except those documents, they have not any document produced before the tribunal, my lord.
How much amount you have deposited before the first appellate court?
20%, my lord.
20% before the trial court.
First appellate court.
Trial court ali compensation order agirliva?
Illa agilla sir.
No.
No, my lord.
Then you deposit 50%, then we will see.
5% deposit.
No, 5%, 50%.
30%. 20 ಮಾಡಿದೀವಿ. I am agriculturist, my lord.
Maybe you are an agriculturist. You availed the loan from PCRD bank.
30% maybe.
Madam. Third, admit. Third on IA 1 of 2022 for suspension of sentence. The main contention of the petitioner counsel that except the one loan amount, no other loans are borrowed from the respondent, and also not produced any loan application for having sanctioned the loan in favor of the petitioner hearing. The counsel also would submit that an amount of 20% was deposited before the first appellate court. For the reasons mentioned in the application as well as grounds urged in the revision petition, and also the ground very contention that only loan amount availed only one time and not other loans, it is appropriate to suspend the sentence subject to depositing of 50% of the amount within 4 weeks. Within 4 weeks. The petitioner also directed to execute a bond for rupees 2 lakhs with one surety before the trial court within 15 days from the date of this order. Issue notice against respondent. The office is directed to secure the records of lower court as well as the first appellate court. Yes, please.
Proceedings may not initiated under 138 of the negotiable instrument. Just amount 3,50,000. The trial court convicted the accused and the first appellate court may not be confirm the judgment of the trial court. Specific defense before the trial court is that may not be have no legal no transaction. But one of my friend Arun may not have taken the loan from the complainant, for which may not stand as a surety. And one more defense may not, there is no service of legal notice of the complainant. Second may not, the third may not, the except the signature of the check may not, the all are written may not. It is a handwriting, signature, all are indifferent. And the exhibit, in order to prove the transaction may not, exhibit P16 has been produced before the trial court. That is the income tax returns for the year 2016. In which my lord it was specifically shown my lord he himself has borrowed the loan for a sum of rupees 16,50,000. In addition to that, my lord, in order to prove the transaction, sundry advance, it is shown as my lord he has paid sundry advance in favor of the accused.
Sundry advance means, my lord, it is the normal business transactions for that. OD facilities ಕೊಡ್ತಾರಲ್ಲ, if the amount is paid, my lord, it should be
How much amount you have deposited?
20%, my lord, have deposited before the first applied court.
You deposit 50%, you will see. Same order, madam. Same order. Subject.
It's offense under 114 of the DPH Act. Responding secretary has filed a private complaint. Alleging that my lord, as per the Joint Director of Enforcement Cell, he was not paid market cess for the year 2011 and 2012 and 2012 and 2013. Which amounts to 1,39,268. It's a bad amount has to be paid. But after the Honorable Court has taken cognizance and issued a notice, summons, he appeared and he pleaded not guilty. Thereafter, my lord, the complaint examined as pleaded 1. He admits that, my lord, the defense has taken by the petitioner that, my lord, exhibit D1 and D2 have been produced. D1, my lord, for the year 2011 and 12. D2, my lord, the marketing under RTI, there is no due in respect of markets. Trial court, my lord, para 15, your lordship, page 38. They have not produced any documentary evidence, my lord, showing reassessment. How much is differential amount. In the evidence deposition, my lord, they have taken different stand, saying that it's a differential amount. But in the private complaint, they are specifically saying that, my lord, he has not paid the market cess for the year 2011 and 12 and 12 and 13. But in deposition, they are saying that there is a differential amount. Thereafter, paragraph 17, your lordship, kindly see, you have D1 has been discussed with regard to D1 and D2. The accused at the time, I shall read. Accused at the time of cross-examination of complaint witness has confronted some of the documents. Exhibit D1 is the document related to market cess, which was having seal of Secretary of APMC, Yad Shumaga. By going through the same, it is noticed that accused has paid 4,60,000 as market cess. There was no due amount for any penalty. Further, by going through Exhibit D2, the documents taken under ATI of APMC, Sagara, wherein it has stated that of the year 2011-12, accused is exempted for payment of market cess as accused paid market cess on paddy. Therefore, he is exempted for payment of market cess on byproducts of paddy. Exhibit 3 is the letter so far as D3 to D5 are in respect of PW2, who is directed the secretary to lodge the complaint. There was a case pending between against Lokayukta. One of the defense suggestion is that my lord, he is asking for bribe. When he is refused to pay the amount, it was recommended to file the complaint. After analysis, my lord, para 20, page 44, my lord. The Honorable Trial Court regarding D1. Except D1 is not produced the document, so therefore they have to pay. In so far as Exhibit P4 and P10, the correspondence between the secretary and petitioner, that was misinterpreted, saying that you are admitting the marketing. In Exhibit P4 and 10 is requested how much you give the statement and what is the reassessment. That was not done. The appellate court, my lord, reiterating the same position without discussion, my lord, confirm the order of the trial. The Honorable appellate court, my lord, has to reappreciate the evidence, except saying D1 is appellate court in para 25, my lord, page in page 14. After 6th line, my lord, is saying this liability is not disputed by the accused. The accused has produced Exhibit D1 dated 7/8/2013, wherein it is recited that the accused has paid all cess. But this document is pertaining to the year 2013. Other year of 2013. It does not say about the cess for the year 2011-12. Accused has produced D2, wherein it is stated that Mrs. Santosh Enterprises has paid cess to paddy. but it is not stated whether they have paid cess to all the products purchased or not. It is decided that accused is not required to pay cess to byproducts. Exhibit D2 does not say that accused has paid cess to entire purchased main products. Accused all the way saying that he is not required to pay cess to byproducts. But the accused has not produced any material document to show that he has paid cess to the main product. On the other hand, there is no material to show that accused has purchased byproduct only, not main products, that is paddy. Therefore, considering the entire evidence on record, exhibit 2, 3 and 25 are the documents which clearly details about the payment of cess by the accused and remaining balance sheet to be paid as of stated. This is the findings, my lord. They have not produced the balance sheet except a demand notice.
What is the amount directed you to pay the amount?
Amount, my lord, after the
6 lakh and odd.
5,67,000. 5,67,000. Not originally 1,39,268 they are claiming. 3 times penalty, my lord, equivalent to 4 lakh.
No, it comes to 4 lakh and odd. That is as per the statute.
Total, my lord, 5,57,072. But while suspending the sentence, my lord, in view of the D1, D2, appellate court has not ordered.
Records ಬಂದಿದೆ madam, transport records.
Admission.
Order admit. ಏನು ಏನು ಹಾಕಿಲ್ಲ ಅಲ್ಲ, ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್ ಹಾಕಿದ್ದೀರಾ? ಇಲ್ಲ ಇದೆಯಾ?
IA1 of
third on IA1 of 2022, wherein prayer is made to suspend the sentence in support of the application approved also found. Having heard the petition of counsel and main contention of the petition of counsel that no due is payable in favor of the respondent. Both the courts have not properly appreciated the material on record. Instead of the first appellate court also confirmed that the order passed by the trial court directing the appellant to pay an amount of rupees 5,67,072. Appellant and reason. For the offence punishment section 114 of Karnataka Agriculture Produce Marketing Regulation Act in respect of cess, market cess for the period 2011-12, 2012-13. The very order impugned are not sustainable in the EPLA. Having heard the respective counsel of both the petitioner as well as respondent, conviction and sentence is suspended subject to payment of 50% of the amount within 60 days. Within 60 days from the date of this order, and deposit the amount before the trial court. Call for records the lower court as well as trial court. The other level condition, the petitioner is also directed to execute a bond for rupees 1 lakh with one surety before the trial court. Amount disperse ಮಾಡಬೇಕಲ್ಲ, ಮತ್ತೆ ಡಿಸ್ಪರ್ಸ್ ಆದ್ರೂ ರೀಪೇಮೆಂಟ್ ಆರ್ಡರ್ ಆಗ್ತದೆ ಅಲ್ವಾ? ಆದ್ರೆ ನಿಮ್ಮ ಅಪೀಲ್. ನೆಕ್ಸ್ಟ್ ರಾಜು ಸಿ ಏನ್ ಹೇಳ್ರಿ? ABC.
Posted for arguments. Now the prosecution has filed a 216 application.
Alteration of charge.
Allegation is that there is no circulation, there is no processing.
What is the error in the order, counsel? It can be altered at any stage.
This is some material for framing charge.
Framing charge. This is only for alteration of charge.
They already charged.
Already. The order which you are questioning is before this court, which is the order.
Prosecution has filed application for
alteration of charge.
Allegations is that, my lord, on the date of the incident, the complaint inspector is a summota complaint. Yeah, the credible information.
I three. Now we are not on merits. Now we are on only with regard to the alteration of charge.
Processing again material illa. ಅದು ಬರೀ ಅಮೌಂಟ್ ಇತ್ತು ಅದು ಸರ್ಕ್ಯುಲೇಷನ್ ಇಲ್ಲ ಪ್ರೊಸೆಷನ್ ಇಲ್ಲ ಸರ್ ಪ್ರೊಸೆಸ್ ಇಲ್ಲ ಇನ್ನೇನ ತಗೊಳಕ್ ಹೋಗ್ತೀವಿ ಇವ್ರು ನೋಡಿ ಎದ್ರಕೊಂಡು ಹೋಗ್ತಿದ್ದ ಅಂತ ಚೆಕ್ ಮಾಡಿದಾಗ ಅಮೌಂಟ್ ಸಿಕ್ತು ಅಂತ ಹೇಳಿ ಮ್ಯಾನುಫ್ಯಾಕ್ಚರಿಂಗ್ ಆಗ್ಲಿ ಪ್ರಿಂಟಿಂಗ್ ಆಗ್ಲಿ ಏನು ಮೆಟೀರಿಯಲ್ ಅವನು ಸಿ 28 ರೂಪಾಯಿ 500 ಕರೆನ್ಸಿ ನೋಟ್ಸ್ 118 ನೋಟ್ಸ್ ಅಂತ ಸೀಸ್ ಮಾಡ್ದ ಅಂತ ಹೇಳ್ತಾರೆ ಅಷ್ಟೇ ಪ್ರೊಸೆಸಿಂಗ್ ಯಾರು ಸರ್ಕ್ಯುಲೇಷನ್ ಇಲ್ಲ ಏನಿಲ್ಲ case is posted for arguments. Aವಾಗ you defense evidence ಮಾಡೋದು ಅಂತ ಹೇಳೋದಕ್ಕೆ
it can be altered at any stage.
Application ಅಲ್ಲಿ ಕೂಡ ಏನು grounds.
Yes madam, what do you say?
Half printed currency notes were also seized and printer is also seized. And the possession of the at this instance it's relatively seized. So
Currency notes as well as the printer. Half printed notes also seized. That means they were under the process of printing the notes.
So that's why your notification application was filed for additional charges under section
489A and 489D.
Your lordships are charged was filed for all the offenses your lordships under 489. At the time of reading charge your lordships these sections were left out 489A and 489B. So that's why the application filed was filed your lordships and it was allowed.
ಕಲರ್ ಪ್ರಿಂಟ್ ಮುಂದೆ ಕಲರ್ ನೋಟ್ಸ್ ಮಾಡಿ ಪ್ರಿಂಟ್ ಮಾಡ್ತಿದ್ದೆ ಅಂತ ಹೇಳ್ತಾರೆ ಕಲರ್ ಪ್ರಿಂಟ್ ಅಷ್ಟೇ
ಪ್ರಿಂಟಿಂಗ್ ಮೆಷಿನ್ ಕೂಡ
ಕಲರ್ ಪ್ರಿಂಟ್ ಮಾಡಿ ಕಂಪ್ಯೂಟರ್ ಕಲರ್ ಪ್ರಿಂಟ್
making or possessing instruments of materials
ಅದು ಕಲರ್ ಜೆರಾಕ್ಸ್ ನೋಟ್ಸ್ ಅದು ನೋಟ್ಸ್
or materials for forging or counterfeiting currency notes or bank notes. Counterfeiting currency notes or bank notes. Whoever counterfeit knowing performs any part of the process of counterfeiting any currency notes. For the petitioner counsel and also the counsel appearing for the respondent. This petition is filed challenging, allowing the application filed under 216 of CRPC for altering the charge for the offence punishment 489A and D of IPC. When this court about to dictate the orders on merits, seeks permission of this court to permit the petitioner to withdraw the petition. Submission permitted to withdraw. SV Prakash Taranath Puja.
My lord, kindly it was fixed on 14th or 15th.
Why?
Settlement is in progress, my lord.
Yeah, raise the 12/11/2019.
Yes,
settlement.
It is in progress. As
in progress 2019. We are in 2022.
Yes.
In progress. Fine. No progress at all. 138.
ಮಾತಾಡ್ತಾ ಇದ್ದಾರೆ ಅದು ಎಷ್ಟಕ್ಕೆ 2 lakh rupees ಚೆಕ್ ಅದು
Taranath Pujari. Ilva Taranath Pujari. So petitioner of counsel present and the respondent counsel absent. The petitioner counsel submits that still negotiation and perusal of records on 12/11/2019 also a submission is made that already been settled between the parties. Avaga already been settled between the parties. And now again that matter
trial court judge, trial court advocate has stated this on his instruction submitted.
However, one more opportunity is given to report the settlement or to argue the matter on merits.
Either of the settlement or argument.
Yes. Is this matter on 14th March?
Oblige.
Narsimha Raju HT Nataraj.
I represent the petitioner. Morning I seek type blood 1 week. A little fever I am having. Maybe taken next week blood I will argue.
Fever anta advocate.
1 week.
Maintenance ಕೊಟ್ಟಿಲ್ವಾ?
No, I'm sorry.
9,000 ರೂಪಾಯಿ ಆರ್ಡರ್ ಮಾಡ್ಕೊಂಡು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
9,000 ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ ಆರ್ಡರ್ ಮಾಡಿಸ್ತಾರೆ, ಮಿಸ್ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ನಾವು ಒಂದು ವರ್ಷದಿಂದ ನಿನ್ನೆ ರಾತ್ರಿ 45,000
ನಿನ್ನೆ ರಾತ್ರಿ
ಕಳಿಸಿದ್ದಾರೆ, 45,000 ಕಳಿಸಿದ್ದಾರೆ. And they are not paying the maintenance, and also the compensation which was granted by the airport confirmed by the appellate court 10 lakh rupees they are not.
ಏನ್ರಿ?
But kindly see, he's always lying. Kindly see, I produced the memo. Lord, kindly see, Lord, I produced the memo. In January 2022, I paid the maintenance, Lord. As per the direction of this, January 2022, I paid the entire maintenance as per the direction of this honorable court. Without document, he keep on saying, kindly see, I produced the bank extract, everything. And moreover, there was a proposal for settlement also, kindly see memo. Page number 14. My learned friend was 14 in the memo. The MC petition, it is for 13.
Have you given this copy of memo to the other side?
ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಕಾಪಿ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ.
ಯಾವಾಗ ಕೊಟ್ಟಿದ್ದೀರಿ ನೀವು?
ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿದೆ ಸ್ವಾಮಿ.
ಯಾವಾಗ್ರಿ? ಬೈ ಪೋಸ್ಟಲ್ ಕಳ್ಸಿದೀರಾ?
ಪೋಸ್ಟಲ್ ಕಳ್ಸಿದ್ದೀನಿ ಮಿಲಾಡ್.
ಹಾಕಿದಿರಿ ಇಲ್ಲಿ?
ಹಾಕಿದ್ದೀನಿ. Yes, received also ಮಿಲಾಡ್.
ಏನ್ರಿ ರಿಸೀವ್ ಮಾಡಿದಿರಿ ಅಂತ ಬೈ ಪೋಸ್ಟ್ ಕಳ್ಸಿದಾರಂತ ನೋಡ್ರಿ. Post receipt ಇದೆ.
The last time you argued the matter before lordship, earlier lordship, yes, concede for that. We paid the maintenance up to January 2020.
Copy serve ಮಾಡಿಬಿಡಿ, then we'll decide the issue.
Please, please.
According to you, you have paid the amount up to January 2022.
My submission may kindly be recorded. January 2022, I paid. Even you know well everything.
Maintenance award ಆಗಿರೋದು ಎಷ್ಟು?
9,000. Let kindly see this. Granting
9,000 ಆಗಿದೆ. ಈ ಟೋಟಲ್ 9,000 ಮಾಡಿದಾರ.
Please, kindly sir.
9,000 ಡೇಟ್ ಯಾವಾಗ ಹೇಳಿ?
I will sir.
Date of order, date of petition before the trial.
13/1/2020 in the 13/1/2020 this honorable court stay the order both the court and direct.
ಈ ಕೋರ್ಟ್ ಬೇಡ. ಫಸ್ಟ್ 9,000ನೇ ತಗೊಳ್ಳೋಣ. ನಿಮಗೆ from the date of petition ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆಯಾ?
Please, at that time I paid everything. Yes, admitted also.
Petition ಅಲ್ಲಿ ಎಷ್ಟಾಗಿದೆ ಆರ್ಡರ್ ಹೇಳಿ?
ಅದರಲ್ಲಿ 15,000 ಆಗಿದೆ.
15,000 ಆಯ್ತು. ಈಗ
before the trial court
ಮಾಡಿದ್ದಾರೆ.
ಹೌದಾ?
Date of petition ಯಾವಾಗ ಹೇಳಿ?
The date of petition is below. The date of petition, I'm sorry, I don't have the
copy of the order ಇರ್ತದಲ್ರಿ, order trial
copy of the order ಇಲ್ಲ, ಅದರಲ್ಲಿ ಇಲ್ಲ sir.
Operation portion 42. Operative portion
42 ನಲ್ಲಿ ಇದೆ ನೋಡಿ.
Page number 42 ನಲ್ಲಿ.
Center and petitioner from the date of petition ಅಂತಿದೆ. Petition file ಮಾಡಿ.
That we have paid minute.
ಇಲ್ಲಿ ಆರ್ಡರ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆಯ್ತು. ಅದು ಫ್ರಮ್ ದ ಡೇಟ್ ಆಫ್ ಪಿಟಿಷನ್ ಅಂತ 10,000 ಅಂತ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಮೈಂಟೆನೆನ್ಸ್ 5,000.
ಹೌದು.
Control is also directed to pay the monthly maintenance of this 5,000.
Please minute.
ಆಯ್ತು 15,000.
ಹೌದು. That we are challenged before the honorable
date ನೋಡಿ ಮೇಡಮ್.
appeal ಅಲ್ಲಿ
first 15 14 11 16 9,000 14 11 16 ಎಷ್ಟಾಗುತ್ತೆ ಅಮೌಂಟ್? ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದೀರಿ ಹೇಳಿ?
ನೋಡಿ, ಅವ್ರ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಎಲ್ಲ ಒಪ್ಕೊಂಡಿದ್ದಾರೆ, ಎಂಟೈರ್ ಅಮೌಂಟ್ ಪೇ ಮಾಡಿದ್ದಾರೆ ಅಂತ. ದೇ ಆಲ್ಸೋ ಫೈಲ್ಡ್ ಅನ್ ಅಫಿಡವಿಟ್ ಬಿಫೋರ್ ದಿಸ್ honorable court. Has admitted everything. There was no due. Even appeal ಅಲ್ಲಿ 9,000 ಕೊಡಿ ಅಂತ ಡೈರೆಕ್ಷನ್ ಮಾಡಿದ್ರು. That were still we are continuing. This honorable court by staying both the orders directed to pay 9,000. January 2020.
What is the balance?
That's what I think will also additional affidavit placed by me before some court on 21st January 2022.
21st January.
Additional affidavit.
Additional affidavit. ಯಾವತ್ತು ಹಾಕಿರೋದು?
21st January 2020.
21st ಯಾವ್ದು ಇಲ್ವಲ್ರಿ ಇಲ್ಲಿ?
affidavit letter affidavit.
ಇಲ್ವಲ್ಲ ಅದನ್ನೇ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಇನ್ನೊಂದು ಇದೆ, 1 more 7-9 ಇದೆ. 21st January ಯಾವ್ದಿಲ್ಲ ನೋಡಿ. ಅಕಾರ್ಡಿಂಗ್ ಟು ಯು ವಾಟ್ ಇಸ್ ದಿ ಬ್ಯಾಲೆನ್ಸ್?
1,08,000 ರೂಪಾಯಿ ಕೊಡ್ಬೇಕು ಈ ಅಕೌಂಟ್ ನಲ್ಲಿ.
1,08,000 ಮನೆ ಕೊಟ್ಟಿದ್ದಾರೆ. 1/8 ಮೈನಸ್ 45 ಕಳೆದ್ರೆ ಇನ್ನು ಬ್ಯಾಲೆನ್ಸ್. ಏನಂತ ಮಾಡಿದ್ದಾರೆ ಎಂಟ್ರಿ ಮಾಡ್ರು?
All the areas of maintenance 9,000 ಅಂತ ಮಾಡಿದ್ದಾರೆ. They have not completed the order, therefore I made an application.
Why you have paid the amount in terms of the entry order?
Let kindly see the order. Let kindly see entry order. Tav nodi son.
What it says?
9,000. What it was directed me to pay 9,000 maintenance.
9,000 and further order ಏನು?
ಏನಿಲ್ಲ, ಫರ್ದರ್ ಆರ್ಡರ್ ಏನು ಇಲ್ಲ. ನೋಡಿ ಆರ್ಡರ್ ಶೀಟ್ ನೋಡಿ ಸರ್. Which is dated 13/1/2020.
Pending consideration for admission, the order under challenge passed by both the court below is states subject to the condition that the petitioner shall continue to pay rupees 9,000 as ordered by the first appellate court until disposal of this petition. ಹೌದು.
ಇದಾದ್ಮೇಲೆ ಯಾವ್ದು ಆರ್ಡರ್ ಆಗಿಲ್ಲ. 9,000 ಮಾರ್ಚ್ ಜನವರಿ ವರೆಗೂ ಪೇ ಮಾಡಿದ್ದೀನಿ. ಇವನ್ he has admitted. ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಅವ್ರು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ. ಇವನ್ ದಟ್ ಇಸ್ ದ ರೀಸನ್ ಐ ಫೈಲ್ಡ್ an affidavit before this honorable court. ಆ 9,000 ಪೇ ಮಾಡ್ತಲೇ ಇದೆ.
Admission?
That he also filed an additional affidavit.
ಮೇಡಮ್ ಇದು ಇಲ್ಲಲ್ಲ, ನೀವು ಫೈಲ್ ಮಾಡಿರೋದು ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆಯಾ? ಅಕ್ನಾಲೆಜ್ಮೆಂಟ್ ಇದೆ ಸರ್. ಅದರ ಸೈಡ್ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೀರಾ? ಇದ್ರ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿದೀರಾ? ಅಡಿಷನಲ್ ಅಫಿಡವಿಟ್
ಅವರು
ಸರಿ
ಅಡಿಷನಲ್ ಅಫಿಡವಿಟ್ ಫೈಲ್ ಮಾಡಿದ್ರೆ ಸ್ವಲ್ಪ ದಯಮಾಡಿ I will read my I will read kindly. Additional affidavit he has filed.
ಒಂದೇ ನಿಮಿಷ ಅವರೇನೋ ನಿಮ್ಮಲ್ಲೇನೋ ಅಡ್ಮಿಷನ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ, ಹೇಳಿ.
Para 4 of the additional affidavit kindly ಅವ್ರು ಫೈಲ್ ಮಾಡಿರೋದ್ರಲ್ಲಿ. I further submit that para 4 kindly from further submit that the order passed by the trial court in case number so and so dated 3/10/2019. I also further submit the petition has filed the above case and obtained interim order on 31/2020 to pay sum of 9,000 as maintenance. Since the petitioner did not pay maintenance previous, I have taken warrant arrest. Therefore, he had paid a sum of 45,000 in the month of February 2020, which amounts to covers 5 months, namely from October 2019 to February 2020. Thereafter, following payments are made. Not kindly see 17/6 in the Ella he has admitted. This is the payment in the right side. Payment. Kindly see the next payment. Apart from the said payment, the petition has paid a sum of rupees 63,000 per a period of 7 months. 63,000 till August 2021 ವರೆಗೂ ಪೇ ಮಾಡಿದ್ವಿ. Since the compromise petition was entered, the petition has sought for refund of same. Accordingly, refund the aforesaid amount of 63,000 to petitioner. 63,000 pay ಮಾಡಿರೋದ್ನ he has returned it. She has returned it. ಇಲ್ಲ ನಾವು ಪ್ರಾಪರ್ಟಿ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡಿದೀವಿ ಅಂತ. Therefore, the petition is liable to pay me the maintenance ordered by this honorable court February 2021 to till today, which works out arrears of 12 months and the sum of rupees 1,08,000 is the arrears of maintenance payable to the petitioner. 1,08,000. Adರಲ್ಲಿ 63,000 we have already paid. Aurene she only returned the amount transferred to my account, saying that we have taken the property. In the compromise ವಾಗಿ my learned friend only has paid has filed the MC petition 13B petition. ಅದರಲ್ಲಿ ಪ್ರಾಪರ್ಟಿ ಕೊಡೋದಂತೂ ಆಗಿತ್ತು. 63,000 ರಿಟರ್ನ್ ಕೊಟ್ಬಿಟ್ರು, ನಾವು ಪೇ ಮಾಡ್ರ, ಆದ್ರೆ ನಾನು ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ದೀನಿ. ಬಟ್ ಈಗ ಜನವರಿ 2022 ವರೆಗೂ ಆಸ್ ಪರ್ ದ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಮೈ ಕ್ಲೈಂಟ್ ಐ ಪೇಡ್ ದ ಮೇಂಟೆನೆನ್ಸ್ ಮಿನಿಟ್. ದೇರ್ ವಾಸ್ ನೋ ಡ್ಯೂ, ಓನ್ಲಿ 2 months ಇದೆ. ನನ್ನ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ
63,000 ರಿಟರ್ನ್ ಮಾಡಿರೋದು ರೀಸನ್ ಏನು?
Baby was born, and since baby was born, the husband did not attend the hospital. Also, he did not come to see the girl also.
It's all merits, well, it's all on merits.
That time to take us back of matrimonial offense did not resume, and ultimately she filed a complaint. She filed a complaint for that period, and this complaint was filed out. Then last year, ಏನ್ ಮಾಡಿದ್ದಾರೆ, in order to overcome 498 petition, they made it as if they wanted to take away ಮನೆ ಕರ್ಕೊಂಡು ಹೋಗ್ಬೇಕು ಅಂತ ಹೇಳಿ ಆ ಕೇಸ್ ನ ವಿಡ್ರಾ ಮಾಡಿಸಿ ಮನೆ ಕರ್ಕೊಂಡೋಗಿ ಮತ್ತೆ ಹರಾಸ್ಮೆಂಟ್ ಮಾಡಿ ಮತ್ತೆ ವಾಪಸ್
498 ಇದು earlier the same was withdrawn.
498
ಪೆಂಡಿಂಗ್ ಇರ್ಬೇಕಾದ್ರೆ ಸೂಪರ್ ಪಾರ್ಟಿಷನ್ ಹಾಕ್ತಾರೆ ಸೊಲ್ಯೂಷನ್ ಅಲ್ಲಿ ತಾಯಿ
ಅದೆಲ್ಲ ಆಯ್ತು. ಈಗ ನಾವು ನಾವು ವಿ ಆರ್ ಡಿಸೈಡಿಂಗ್ ವಿತ್ ರಿಗಾರ್ಡ್ ಟು ದಿ ಅರಿಯರ್ಸ್ ಆಫ್ ದಿ ಮೇಂಟೆನೆನ್ಸ್ ಇಸ್ ಕನ್ಸರ್ನ್. ಈಗೇನು ಆಸ್ತಿಯನ್ನು ಕೊಟ್ಟಿದಾರ ಯಾವ್ದಾದ್ರು?
ನಾವು ಒಪ್ಕೊಂತ ಇಲ್ಲ ಅವರು.
Ground that some property was given to her.
They wanted to do a property, therefore they are forced to give the money back. Force ಮಾಡಿ 60,000 ಕೊಡಬೇಕು, ನಿಮ್ಮ ಪ್ರಾಪರ್ಟಿನ ಕೊಡಬೇಕು ಅಂತ ಹೇಳಿ 32 ಗುಂಟೆ ಕೊಡಬೇಕು ಹೋಗಿದ್ವಿ. 32 ಗುಂಟೆಗೆ ಕೋರ್ಟ್ ಸಜೆಷನ್ ತಗೊಂಡ್ಮೇಲೆ 32 ಗುಂಟೆ ನೋಡಕ್ ಹೋದ್ರೆ accessibility ಇದೆ, ರೋಡ್ ಇಲ್ಲ, ಇಂಟ್ರೆಸ್ಟ್ ಇದೆ, ರೋಡ್ ಹೋಗಕ್ಕೆ ಆಗಲ್ಲ ಆ ಪ್ರಾಪರ್ಟಿ.
ಆಯ್ತು, ಈಗ ಏನು 63,000 ಪ್ರಾಪರ್ಟಿ ತಗೊಳಕ್ ರೆಡಿ ಇಲ್ವಾ ನಿಮ್ ಕ್ಲೈಂಟ್?
ರೆಡಿ ಇಲ್ಲ, ಆಕ್ಸೆಸ್ ಇಲ್ಲ.
ಅದೇ ಅದಕ್ಕೆ ಹೇಳ್ತಾ ಇರೋದು, ಈಗ ಆಕ್ಸೆಸ್ ಇಲ್ಲ ಅಂತ.
ಪ್ರಾಪರ್ಟಿ ಯಾಕಂತಂದ್ರೆ ರೋಡ್ ಪ್ರಾಪರ್ಟಿಗೆ ಪಾಪ ಇಲ್ಲಿ ಹೋಗ್ತಾರೆ, ಒಳಗಡೆ ಹೋಗ್ತಾರೆ.
ಏನ್ರಿ ಅಕ್ಸೆಸ್ ಇಲ್ವಾ ರೋಡ್?
3 ಪ್ರಾಪರ್ಟಿ ಸಜೆಸ್ಟ್ ಮಾಡಿದ್ವಿ ಸ್ವಾಮಿ. ಅವರೇ ಒಪ್ಪಿಕೊಂಡು MC ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಸೈನ್ ಹಾಕಿ ಮೈ ಲರ್ನ್ ಫ್ರೆಂಡ್ ಇಸ್ ಓನ್ಲಿ ಆಸ್ ಡ್ರಾಫ್ಟೆಡ್, ಈ ಓನ್ಲಿ ಕನ್ಸೆಂಟೆಡ್. ನಾನು ಪೇಜ್ ನಂಬರ್ 18 ಅಲ್ಲಿ ಅಫಿಡವಿಟ್ ಹಾಕಿದ್ದೀನಿ ನೋಡಿ ಸರ್.
ಅವ್ರು ಹೇಳೋದು, ಅವ್ರು ಏನು ಅದನ್ನ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ. ನೀವು ಪ್ರಾಪರ್ಟಿ ವಾಟ್ ಯು ಹ್ಯಾವ್ ಆಫರ್ಡ್ ನಾಟ್ ಹ್ಯಾವಿಂಗ್ ಎನಿ ಆಕ್ಸೆಸ್ ಟು ಗೋ ಟು ದಿ ಲೆಟ್ ಲ್ಯಾಂಡ್ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ.
ಒಂದು ಪ್ರಾಪರ್ಟಿ ಬಿಟ್ರೆ ಯಾವ ಪ್ರಾಪರ್ಟಿಗೂ ಆಕ್ಸೆಸ್ ಇಲ್ಲ, ಆ ತರ ಇದೆ. ಅವರು ತಾವೇ ಲಾಸ್ಟ್ ಟೈಮ್ ಡೈರೆಕ್ಷನ್ ಮಾಡೋ ಹೊತ್ತಿಗೆ ಪ್ರಾಪರ್ಟಿನ ತೋರಿಸಿದೀವಿ, ಯಾವ್ದು ಆಕ್ಸೆಸ್ ಇಲ್ಲ. ಅದಕ್ಕೆ ನಮಗೆ ಬೇಕಾಗಿಲ್ಲ ಪ್ರಾಪರ್ಟಿ ಅಂತ ಹೇಳಿ ನಾವು ಈಸ್ ಆರ್ಗ್ಯೂಯಿಂಗ್ ಲೈಕ್ ದಟ್. 13
refunded amount of rupees 63,000 according to you alwa?
ಹೌದು ಸರ್, ಅವರೇ ವಾಪಸ್
pay that amount, then it matches with the remaining amount.
I will agree, my lord. I will agree. I will pay man. ಅವರೇ ವಾಪಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಆಯ್ತು, ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಬ್ಯಾಲೆನ್ಸ್ ಅಮೌಂಟ್? 63,000
ಒಂದು 10 days my lord. ನಾನು ಸ್ವಲ್ಪ ಫೀವರ್ ಇದೆ, 10 days ಅಲ್ಲಿ ಕೊಟ್ಬಿಡ್ತೀನಿ. 63,000
ಆಗ 63,000 plus 45 ಎಷ್ಟಡೆ ಕೊಟ್ಟಿರೋದು
ಎಲ್ಲ ಆಗೋಗುತ್ತೆ, ಕ್ಲಿಯರ್ ಆಗೋಗುತ್ತೆ.
Not amounts to an uncomplained, thereby you are getting up the interim order. That's what you got. It is not that maintenance. It's also a fact that he did not complete the order of the Supreme Court. Because on prima facie, looking at
have you filed any separate application for action against?
Kindly see, kindly application ಹಾಕಿದ್ರೆ vacating, how he has misguided to the court. Kindly see, my lord, the application he has filed.
they have not come over. They have violated the order.
No. I'm sorry.
They only say that maintenance was
have you returned that amount of rupees 63,000? Have you returned that amount of rupees 63,000?
No, not only 63. Apart from 63, there are other amount of an additional.
ಅದಕ್ಕೇನೆ ಈಗ ಇಬ್ರುನು ಒಂದು ಮೆಮೊ ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಹಾಕಿ ನಾಳೆ ನಾಡಿದ್ದು ಕ್ಲಿಯರ್ ಆಗಿ ಇಬ್ರುನು. According to him, what is the balance? According to him, now he claims that he has paid the entire amount up to January 2022. According to you, they have not paid the amount. Not only that 63,000, and also remaining balance is there. ಎಲ್ಲಿದ್ದಾರೆ ಅದರಲ್ಲಿ? ಕೊಟ್ರಿ, ಅದ್ರಲ್ಲಿ ಇಲ್ವಲ್ಲ? ಏನಂತ? ಅಡಿಷನಲ್ ಅಫಿಡವಿಟ್
ಅದನ್ನ 4th ಪ್ಯಾರಾದಲ್ಲಿ ಹೇಳ್ತೀನಿ ಏನೇನು ಅಮೌಂಟ್ ಬಂದಿದೆ ಅಂತ.
ಅದನ್ನೇ ನಾನು ಓದಿ ಹೇಳಿದ್ದೆ. ಈಗ
1 to 21 ಮೇಲೆ ಕೊಟ್ಟೇ ಇಲ್ವ ಇವ್ರು ದುಡ್ಡು?
ಇಲ್ಲ, ಅದೇ violation of the order.
ಸ್ವಾಮಿ 63,000 ಕೊಡೋದಕ್ಕೆ ರಿಟರ್ನ್ ಹಾಕಿದ್ರೆ ಆಮೇಲೆ 45,000 ಕೊಟ್ಟಿದ್ದೀನಿ. ಅವ್ರು ಯಾಕೆ ಹಿಂಗ್ ಹೇಳ್ತಿದ್ರೆ ನಮ್ಗೆ
45,000 ನೆನ್ನೆ ಕೊಟ್ಟಿದ್ದೀರಿ ಅಂತ
ಟ್ರಾನ್ಸ್ಫರ್
ಇಲ್ಲಿ ಮನ್ಸಿ ಬಂದಾಗ ಪೇಮೆಂಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ.
ಇಲ್ಲ ಸ್ವಾಮಿ,
ಆರ್ಡರ್
ಪ್ರಾಪರ್
ಕೌನ್ಸಿಲ್
Not kindly see my one
every month you have to pay 9,000 ಅಂತ ಹೇಳಿ. Why you have not paid the amount from the date of order?
Not kindly see, because of the property proposal ಅವರೇ ರಿಫ್ಯೂಸ್ ರಿಟರ್ನ್ ಮಾಡಿದ್ರು. ಅಲ್ಲಿನವರೆಗೂ ಪೇ ಮಾಡ್ಕೊಂಡೆ ಬಂದು ಪ್ರಾಪರ್ಟಿ ಕೊಡೋ ಹೊತ್ತಿಗೆ ಅವರೇ ರಿಟರ್ನ್ ಮಾಡಿದ್ರು. ಅದಾದ್ಮೇಲೆ 45,000 ಕೊಟ್ಟಿದ್ದೀನಿ. ಲಾಸ್ಟ್ ಅಕೇಶನ್ ಅಲ್ಲಿ ಮಾತ್ರ ಪ್ರಾಪರ್ಟಿ ಬೇಡ ಅಂದಿದ್ದವರು. ಅಲ್ಲಿನವರೆಗೂ ಪ್ರಾಪರ್ಟಿ ಬೇಕು ಅಂತ ಹೇಳಿದ್ರು 63,000 ಅವರೇ ರಿಟರ್ನ್ ಮಾಡಿದ್ರು. This is the thing is happening, lad. We have offered the property, they have accepted.
Property ಬಗ್ಗೆ ಏನಾರ ಆರ್ಡರ್ ಇದೆಯಾ?
Property ಬಗ್ಗೆ ಆರ್ಡರ್ ಇದೆ, ತಾವು ನೋಡಿ ಸ್ವಾಮಿ. Last occasion, lad, we have asked for the direction, we have shown the property also. Kindly see the order sheet, lad. In the last occasion, Lordship has directed to show the property also. We have shown.
Where is that order? Date of order entry.
Date of order.
Property is not in lieu of maintenance as ordered by this court. ಹೌದಲ್ಲ?
No. But
13 settlement.
13B petition only has agreed for one-time settlement. That document also produced before Lordship. 13B ಹಾಕಿದ್ದಾರೆ, ಅವರೇ ಹಾಕಿದ್ದಾರೆ. Kindly see my document.
ಅದರಲ್ಲಿ ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಆಗಿದೆ ಏನ್ರಿ? ಇಲ್ಲ.
ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಇನ್ನೂ ಆಗಿಲ್ಲ.
Why you have not paid the interim maintenance till the disposal of the 13B petition?
But we are keep on paying, my lord. 63,000 ಅಷ್ಟೇ balance ಇರುತ್ತೆ. He has returned it.
ಅಲ್ಲ ರೀ, ನಿಮ್ ಪ್ರಕಾರ ಈಗ 63,000 ಮಾತ್ರ ಬ್ಯಾಲೆನ್ಸ್?
ಹೌದು. ಅವರೇ ರಿಟರ್ನ್ ಮಾಡ್ರಿ. ಇನ್ನೆಲ್ಲ ಪೇ ಮಾಡಿದೀನಿ. ಐ ವಿಲ್ ಪ್ರೊಡ್ಯೂಸ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ ಆಲ್ಸೋ.
ಆಯ್ತು, 13/1/2020 ಅಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿರೋದು. ಆಮೇಲೆ ಎಷ್ಟು ನೀವು ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರಿ?
Kindly see, my lord, I have produced the extract, my lord, along with the memo. Kindly see page number 2. ನನ್ನ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ ಡಾಕ್ಯುಮೆಂಟ್ ಹಾಕಿದ್ದೀನಿ, which is dated 25/1/2022. ಅದರಲ್ಲಿ kindly see, my lord, first page ಅಲ್ಲಿ I have extracted everything.
ಆಯ್ತು, 45,000 ಒಂದು ಟೋಟಲ್ 2,07,000 ಕೊಟ್ಟಿದ್ರಿ ಅಂತ.
ಅದರಲ್ಲಿ 63,000 ರಿಟರ್ನ್ ಆಗಿದೆ. ಅವ್ರು ವಾಪಸ್
ರಿಟರ್ನ್ ಆಗಿದೆ. ಆಯ್ತು,
45,000 ಪೇ ಮಾಡಿದೀವಿ.
What do you say with regard to this memo of calculation?
No, whatever we have said, memo of calculation
ನಿಮಗೆ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ ಇದು?
He has agreed everything in the additional affidavit. What he has transpired, the same I have put it before the memo.
ನಿಮ್ಮ ಅಫಿಡವಿಟ್ ಯಾವತ್ತಿಂದ್ರಿ? ಅವ್ರ ಹಾಕಿರೋದು ಯಾವಾಗ? ಅದು ಕೂಡ
25/1/2022.
Actually, what is the balance?
8,000 ರೂಪಾಯಿ ಬರಬೇಕಾಗಿತ್ತು ಲಾಸ್ಟ್ ಮಂತ್ಗೆ. So as on January, 1,08,000 rupees arrears was there, and that means say 9,000 ಅಂತ ತಗೊಂಡ್ರು ಕೂಡ ನಾವು ವಾಣಿಜ್ಯ ಆರ್ಡರ್ ಅಂತ ಆಗಲ್ಲ. Completion violation of the order, therefore an application can be filed. Subsequent to filing an application, some development has taken place.
Now he says he is ready to pay the 63,000 amount which was returned. You only returned that amount.
No, they forced it. She is supposed to put ಮಾಡಿದ್ದಾರೆ, ಎಲ್ಲರೂ ಪ್ರಾಪರ್ಟಿ ಕೊಡಲ್ಲ.
ಆಯ್ತು ರೀ, 63,000 ನಿಮಗೆ ಬಂದ್ರೆ ಅದರ್ ದನ್ 45,000 ಅಲ್ಲಿಗೆ ಟ್ಯಾಲಿ ಆಗುತ್ತಾ ಟೋಟಲ್ ಅಮೌಂಟ್?
ಟ್ಯಾಲಿ ಆಗುತ್ತೆ.
ಡಿಸ್ಪೋಸ್ ಮಾಡನ್ರಿ, ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡೋಣ. ಫಸ್ಟ್ ಯು ಅರಿಯರ್ಸ್ ಆಫ್ ಮೇಂಟೆನೆನ್ಸ್ ಬಗ್ಗೆ ಹೇಳಿ.
ಏನೇ ಮಾಡಿ ಆಕ್ಸೆಸ್ ಇರೋ ಪ್ರಾಪರ್ಟಿ ಕೊಟ್ಟರೆ ನಾವು ಏನು ಕೇಳಕ್ ಬರಲ್ಲ.
ಆಕ್ಸೆಸ್ ಇರೋ
ಈಗ ಪ್ರಾಪರ್ಟಿ ಬೇಡ ಅಂದ್ಮೇಲೆ ನಾನೇ ಓನ್ಲಿ ಐ ಪ್ರೆಸರೈಸ್ಡ್ ಹಿಮ್. Now he is saying he is keep on going away. I said that maximum property ಯಾವ್ದಿದೆ ಅಲಾಟ್ ಮಾಡ್ತೀನಿ, ನಾನು ಅಕೌಂಟ್ ಡೈರೆಕ್ಷನ್ ನಾನು ಇನ್ಸ್ಟ್ರಕ್ಟ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದೀನಿ.
He is well off. He doesn't want to maintain female child as well as hospital ಕೊಡಲಿಲ್ಲ.
ಆಯ್ತು, ಅದೆಲ್ಲ ಬಿಟ್ಬಿಡಿ. ಈಗ ಎಷ್ಟು ಪ್ರಾಪರ್ಟಿ ಕೊಟ್ರೆ ನೀವು ಯಾವ ಪ್ರಾಪರ್ಟಿ ಕೊಟ್ರೆ ಒಪ್ಕೋತೀರಿ?
ಆಕ್ಸೆಸ್ ಇರೋದು ಯಾವ ಪ್ರಾಪರ್ಟಿ 32 ನಾವು 13B ನಲ್ಲಿ ಸೇರಿಸಿದೀವಿ.
ಅಕ್ಸೆಸ್ ಇರೋ ಪ್ರಾಪರ್ಟಿ ಯಾವ್ದಾರು ಇದೆಯಾ? ಯಾವ್ದು ಹೇಳಿ?
ನೋಡಿರೋದು ಯಾವ್ದಮ್ಮ? ಮೂರು ಪ್ರಾಪರ್ಟಿಗೆ ನೋಡಿದ್ದೀವಿ.
ಯಾವ್ದದು? ನೀವು ಸರ್ವೆ ನಂಬರ್ ಹೇಳ್ಬಿಡಿ, ನೋಡೋಣ, ಅವ್ರಿಗೆ ಕೇಳೋಣ, ಅದನ್ನ ಕೊಡ್ತಾರೆ.
ಪ್ಲೀಸ್
ಮೂರಿದೆ ಅಂತ ಪ್ರಾಪರ್ಟಿ, 3 ಸರ್ವೆ ನಂಬರ್ ಇದೆ. ಒಟ್ಟು 11 ಪ್ರಾಪರ್ಟಿ ಇರೋದು. 3 ಸರ್ವೆ ನಂಬರ್ ಅಲ್ಲಿ ರೋಡ್ ಇದೆ.
ಯಾವ್ದು ಹೇಳಿ? ನಿಮ್ ಪ್ರಕಾರ ನಿಮಗೆ ಕೊಡ್ತಾ ಇರೋದು ಈಗ ಆಕ್ಸೆಸ್ ಇಲ್ಲ. ನಾಡಿದ್ದು ಹಾಕಿರ್ತೀನಿ ನೋಡಿ, ಅಷ್ಟೊಳಗೆ ಆಗ್ಬೋದಾ?
ನಾಡಿದ್ದು ಬೇಡ ಸ್ವಾಮಿ, ಅಲ್ಲಲ್ಲ, ಒಂದು ಫ್ರೈಡೆ ಹಾಕಿ ಸ್ವಾಮಿ. ನಾನು
ಫ್ರೈಡೇನೆ ಹಾಕೋಣ. ಆಯ್ತು, ನಾಡಿದ್ದು ಬೇಡ, ಫ್ರೈಡೆಗೆ ಹಾಕೋಣ. ನೋಡಿ, both the council submits with regard to the petitioner council submits that the amount which has been paid, 63,000, was returned, and hence there was a due, and apart from that 45,000 was paid, and the council appearing to the respondent also not disputes the receipt of rupees 45,000 day before yesterday, and also council submits that the 3 properties are having access, and if any property out of 3 having access is given to the respondent is ready to take the same, and hence both the councils are directed to give the correct details of the balance and list this matter on Friday date. Saturday ಇರ್ಬೇಕಲ್ಲ sitting, Saturday ಹಾಕೋಣ. ಬಡವಾ ಆಯ್ತು, ಫ್ರೈಡೆ ಡೇಟ್ ಕೊಡಿ. 4th of March ಅವ್ರದ್ದು ಕಾಪಿ ಕೊಡಿ. ಆಮೇಲೆ ಆಫೀಸ್ ನಲ್ಲಿ ತಗ್ಸಿ ಮೇಡಮ್, ಅವ್ರು ಫೈಲ್ ಮಾಡಿರೋದು ಅದ್ರೊಳಗೆ ಒಂದು ಕಾಪಿ ಇದೆ ನೋಡಿ, ಒಂದು
ಪ್ಲೀಸ್.
Trial court has acquitted. The charge under 498, A3, 4 and 6 are the government. Appellate court has reversed and convicted. And in the meantime, there was matrimonial proceedings in the family court. The marriage is
divorced. Order has been passed.
4 ಲಕ್ಷ ಕೊಡಬೇಕು ಅಂತ ಆಗಿದೆ. 4 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ. ಆಚೆ ಕಡೆ ಹೋಗಿದ್ರೆ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ. ಯಾವ್ದಾದ್ರು ಕನೆಕ್ಟ್ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ಬಿಟ್ರೆ ಒಳ್ಳೆದು.
ಯಾರು ಬಾಲಕೃಷ್ಣನ್ ಇಲ್ವಾ? ರಿವಿಷನ್ ಹೆಂಗ್ ಬರ್ತದೆ? ರಿವರ್ಸಲ್ ಆಫ್ ದಿ ಆರ್ಡರ್ ಆಫ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
ಆರ್ಡರ್ ಆಫ್ ದಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ acquitted. Appeal to court of session.
ಅದೇ ಹೇಳಿದ್ದು ನಾನು ಹೇಳಿದ್ದು ಒಂದು ಮತ್ತೆ ಅಗೇನ್ ಅಪೀಲೇ ಬರುತ್ತೆ, ರಿವಿಷನ್ ಬರಲ್ಲ.
It's one of the points. Appeal against acquittal under section 378 by the victim as also by the state. That's one of the points which I have raised also. And other points are also there.
What I am suggesting is once the acquittal order is reversed by the appellate court, revision not lies, appeal lies on.
Convicted.
First acquittal. Subsequently it was reversal. Yes. In an appeal.
Acquitted.
Acquittal was reversed in an appeal.
I will find out as to whether an appeal lies under 378 against such an order.
Revision only, concurrent finding.
Revision is maintainable also.
Balakrishnan, Balan Associates. ಮೊನ್ನೆ ಸೆಟ್ಲ್ ಆಗಿದೆಯಾ ಅದು 13B ಅಥವಾ ಏನು?
ಅದು ಸೆಟ್ಲ್ ಆಗಿದೆ, ಡೈವರ್ಸ್ ಆಗಿದೆ.
ಡೈವರ್ಸ್ ಸೆಟಲ್ಮೆಂಟ್. ಆಗ ಡೈವರ್ಸ್ ಸೆಟಲ್ಮೆಂಟ್ ಆಗುವಾಗ ಈ ಮ್ಯಾಟರ್ ಬಗ್ಗೆ ಏನಿಲ್ವಾ?
That is one of the points which I have got to request my Mr. Balan. Now everything is settled. Now open ಮಾಡೋದು ಯಾಕೆ?
What is there ಅಂತ? That's what I am also. Once matter is settled and also received an amount of rupees 4 lakh. 2011 ಮ್ಯಾಟರ್ ಇದು. ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಶೀಟ್ ಯಾವಾಗ ಮೇಡಮ್ ಇದು? ಈಗ ನಾವೇ ಮಲಗಿದ ಫೈಲ್ ಸೇಲ್ಸಿರೋದು ನಾವೇನಾ? ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು ಬಂದು? I have given instructions, put up old matters. 19 ಮೇಲೆ ಬಂದೇ ಇಲ್ಲ. Revision petitioner counsel is present. Respondent counsel is absent. The matter was listed earlier in 2019 and thereafter not listed. And hence one more opportunity is given to the respondent counsel. List this matter on. ಒಂದು 2 ವಾರ ಕೊಡಿ. ಫೈಲ್ ಸಿಕ್ಕಿಲ್ಲ, ನಂಗೆ ಹುಡುಕಿಲ್ಲ ಅನ್ನೋದು ಬೇಡ. 14th March. 36 CH ಹನುಮಂತರಾಯ.
ಬೆಳಗ್ಗೆನೆ ಕೇಳಿದೆ ಅವ್ರಿಗೆ ಸ್ವಲ್ಪ ಸರಿ ಇಲ್ಲ. ಐ ವಿಲ್ ಓನ್ಲಿ ಟೇಕ್ ಅಪ್ ದ ಮ್ಯಾಟರ್ ಮೇಲೆ ಐ ವಿಲ್ ಪ್ರೊಸೀಡ್. ಕೈಂಡ್ಲಿ ಮೈ ನಾಟ್ ಅಲಾಟ್ ಮೀ 10 days ಟೈಮ್. ಕ್ಲೈಂಟ್ ಗೂ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದಾರಂತೆ ಫೈಲ್ ಎತ್ಕೊಂಡು ನನ್ನ ಕಡೆ ಹೋಗ್ಲಿಕ್ಕೆ ಫೋನ್ ಮಾಡಿದ್ರು ಅವರುನು. ಐ ಆಮ್ ನಾಟ್ ಅಕಾಮಡೇಟಿಂಗ್ ವಿತ್ ದ ಫೈಲ್.
ನೋಡ್ರಿ ಎಲ್ಲಾ ಕಡೆ ಬರೀ ಇದೇ ಕೆಲಸ ನೋಡಿ.
ನಾನೇನು ಜಾಸ್ತಿ ದಿವಸ ಕೇಳ್ತಾ ಇಲ್ಲ.
Citing the reason for medical inconvenience in the family of the learned counsel for the petitioner prays for a week's accommodation. ಈ ಮೆಡಿಕಲ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಬಹಳ ವೆರಿ ಥ್ರೂಔಟ್ ಇನ್ ದಿ ಆರ್ಡರ್ ಶೀಟ್.
ಒಂದು 10-15 days ಕೊಡಿ ಸಾಕು ಮೈ ಲಾರ್ಡ್. ಐ ವಿಲ್ ನಾಟ್ ಹ್ಯಾವ್ as my lords know me. I will not
counsel fee Ramsundar
go ahead with the matter.
Adjournment on the ground on behalf of the appellant revision petitioner counsel on record or otherwise he undertakes to argue the matter and hence list this matter. ಯಾವತ್ತು? 14th March.
2 weeks ಕೊಡಿ. 2 weeks
14th March.
ಆಗ್ಬೋದು.
ಎಂ ಪಾರ್ಥ.
Concurrent findings of both the court, my lord.
An offense in
324, my lord. In this case, the second petitioner JMFC order was confirmed by the principal judge Mysore, my lord. When the judgment was delivered,
Nandana judgment. Agarbada, not before this. I only confirmed the order.
Yes, my lord. Yes, ma'am.
Note, the counsel appearing for the revision petitioner brought to notice of this court that the appellate court order is passed by ಹಂಗ ಹಾಕೋದ ಬೇಡ, ಇದನ್ನ ಹಾಕ್ಬಿಡಿ ಸಾಕಷ್ಟೇ. ಪೋಸ್ಟ್ ದಿ ರಿಜಿಸ್ಟ್ರಿ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಪ್ಲೇಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಬಿಫೋರ್ ದಿ ಡಿಫರೆಂಟ್ ಬೆಂಚ್. ಅದೇ ಅಂದ್ರೆ ನಾಟ್ ಬಿಫೋರ್ ಮೀ ಅಂದ್ರೆ ಅದು ನಾಟ್ ಬಿಫೋರ್ ಮೀ ಸರ್ ಬೆಟರ್.
Reasons should be mentioned, my lord. Not before me, reasons should be mentioned. Otherwise.
ಬೇಕಾಗಿಲ್ಲ. ನಾಟ್ ಬಿಫೋರ್ ಮೀ ಅಂದ್ರೆ ಕೋರ್ಟಿಗೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ, ಅಲ್ಲ ರಿಜಿಸ್ಟ್ರಿ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ. ನಾಟ್ ಬಿಫೋರ್ ಮೀನ್ ನಾವು ರೀಸನ್ ಬರೆಯೋದೇ ಬೇಡ. ಔಷಧ್ ಪಾಷಾ. ಅಮಿಕಸ್ ಕುರಿ BS ವೆಂಕಟನಾರಾಯಣ. ನೀವ ವೆಂಕಟನಾರಾಯಣ? ನೌಷಾದ್ ಪಾಷಾ ಯಾರು? ನೀವ ಅರ್ಲಿಯರ್ ಆರ್ಡರ್ ಆಗಿದೆ ಆಲ್ರೆಡಿ. Unless that order is recalled. But our application ಹಾಕ್ಬೇಕು ರಿಕಾಲ್ಗೆ. ಯಾರಾದ್ರೂ ಮಾಡಿ ಅಷ್ಟೇನೆ. ಲರ್ನೆಡ್ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಆಬ್ಸೆಂಟ್ ಅಂತಿದೆ. ಅದಕ್ಕಿಂತ ಮುಂಚೆ ಹಿಂದೆನ ಆರ್ಡರ್ ಇದೆಯಾ? ಅಮಿಕಸ್ ಕ್ಯೂರಿ ಯಾವಾಗ ಅಪಾಯಿಂಟ್ ಆಗಿದ್ದು? When the matter was listed on so and so, no so and so. Finally. This court has noted the fact that since this is a state instituted case, BS Venkatarayana, learned from member of bar, appointed as amicus curiae to represent the revision petitioner ಅಂತ ಆರ್ಡರ್ 18/11/21 ನಲ್ಲಿ. ಮೊದಲು ಕೂಡ ನೀವೇನಾ? ನೀವು ಸ್ಟೇಟ್ ಪರವಾಗಿನಾ? ಅಲ್ಲ ಪಿಟಿಷನರ್ ಅದೇ. Earlier petition is also filed by the state engaging you. You are also an amicus curiae ಅಲ್ಲ? ನಿಮ್ದು ನೀವು ಪರ್ಸನಲ್ ಆಗಿ ಫೈಲ್ ಮಾಡಿರೋದಾ? But unless this order is recalled, how you can?
That day I was absent.
ಆಯ್ತು ಈಗ already there was an order. Either you have to make an application for recall or but order ಯಾಕಾಗ್ತದೆ? Once amicus curiae is appointed, his wakalat is ceased. Once amicus curiae is appointed, his wakalat is ceased. ಏನಿದೆಯಾ ಆ ತರ ಏನಾದ್ರು? ಮತ್ತೆ ಮಾಡ್ಬೇಕಲ್ಲ, ರಿಕಾಲ್ ಆಗ್ಬೇಕು. Normally ಬೇಡ. What is the procedure? Is it not seizes of the wakalat once you appoint the amicus curiae? ಅಲ್ವಾ? Once we have appointed amicus curiae, automatically the wakalat which he was holding, for the reason, what is the reason for appointing amicus curiae? When the advocate is on record, is not appearing before the court, court seeks an assistance from other advocate. ಅವ್ರು ಕೊಡ್ಬೇಕು, ಅವ್ರ ಕಾಸ್ಟ್ ಕೊಡ್ಬೇಕು.
Since 11 years.
11 years ಸರ್ ನಾವೇನ್ ಮಾಡೋಣ? 11 years ಅಂತ ಅಷ್ಟೊಂದು ಕನ್ಸರ್ನ್ ಇದ್ರೆ ನೀವು ಕೋರ್ಟ್ ಮುಂದೆ ಅಪೇರ್ ಆಗಬೇಕು.
Try to contact him. Unable to trace it.
ಆಯ್ತು ರೀ, ನಾವು he has been appointed. ಅವ್ರ ಫೀಸ್ ಯಾರು ಕೊಡೋರು ಈಗ? Or otherwise I will permit him to argue that we will pay the pay. Government will pay once amicus curiae is appointed. ನಾವೇ ಮಾಡಿದೀವಲ್ಲ ಮೇಡಮ್ ಸುಮಾರಲ್ಲಿ. The order to pay amicus curiae. Once amicus curiae is appointed, registry will be directed to pay the amount. ಅಲ್ವಾ? ಕೊಟ್ಟಿದ್ದೀವಿ, ಹಿಂದೆ ಕೊಟ್ಟಿದ್ದೀವಿ. ಸಬ್ಜೆಕ್ಟ್ ಟು ಪೇಮೆಂಟ್. ಈಗ ಅವ್ರು ರೆಡಿ ಇಲ್ವಲ್ಲ? ಅವ್ರೇನ ಅವ್ರಿಗೆ ರಿವಿಷನ್ ಪಿಟಿಷನರ್ ಏನ ಅವ್ರಿಗೆ ಕಾಂಟ್ಯಾಕ್ಟ್ ಮಾಡಿಲ್ವ ಅಂತಲ್ಲ?
From Tamil Nadu. Contact ಮಾಡಿದ್ರೆ ಸಿಗ್ತಾನೆ ಇಲ್ಲ ಸರ್.
ಅದಕ್ಕೆ ಏನ್ ಮಾಡ್ತೀರಿ ನೀವು? ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲ್ಲ.
Lordship permits me, I will ready to argue.
Subject to payment of amicus curiae fee. Subject to payment of amicus curiae fee. ಹೌದಾ? ಆಯ್ತು ನೋಡಿ. ಆಯ್ತು ಹೇಳ್ರಿ ಮೇಡಮ್, ಹೇಳ್ರಿ ನೀವ್ ಹೇಳ್ರಿ ಫಸ್ಟ್. ವಾಟ್ ಆರ್ ದಿ ಗ್ರೌಂಡ್ಸ್? ಏನ್ ಅಫೆನ್ಸ್ ಏನು?
304A my lord.
304A ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
1 year my lord.
1 year.
279,000 rupees fine.
ಎರಡಕ್ಕೂ ಕನ್ವಿಕ್ಷನ್ ಮಾಡಿದಾರ? ಎರಡಕ್ಕೂ ಮಾಡಕ್ ಬರಲ್ಲ. Once 304A is invoked, that is the major offense, merges with 279 also. ಆಯ್ತು ಮಾಡಿದ್ದಾರೆ ಈಗ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಏನ್ ಮಾಡಿದ್ರು? ಅಪಲೇಟ್ ಕೋರ್ಟ್ನವರು ಕನ್ಫರ್ಮ್ ಮಾಡಿದ್ರ?
ಅವರು ಮಾಡಿದ್ದಾರೆ, ಸೇಮ್ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದಾರೆ.
Surrender before the trial court to undergo sentence on or before 29/1/2020. ಯಾವ ವರ್ಷದ ಆಕ್ಸಿಡೆಂಟ್ ಇದು? ಆಯ್ತು, what is the error?
25/10/2007.
What is the error to invoke revisional jurisdiction?
But here, as per the prosecution case, PW 1 to 4 are the eyewitness to the incident.
I cannot reappreciate the evidence. Only if any perversity I can. With under section 401 I can.
Yes, where the incident took place, it's a highway, my lord. There is no bus stop. All the witnesses admit that at the place of the incident there was no bus stop. In case of the prosecution is that the deceased was waiting for the bus stop to go to Kalambilla. So my only contention is this, my lord. It's a national highway. There was no bus stop, and people are not allowed to stand in the road, on the road, my lord.
ಆಯ್ತು, ಆಕ್ಸಿಡೆಂಟ್ ಎಲ್ಲ ಆಗಿದ್ದು ಹೇಳಿ ಫಸ್ಟ್. ಸ್ಕೆಚ್ ಇದೆಯಾ?
Sketch ಇದೆ, but unfortunately it was not marked, my lord. Because I was not been examined. He went to the spot, prepared the spot marker, and also prepared the sketch. As he was not examined, that sketch has not been marked for the lower court. But you may kindly see the sketch, the sketch prepared by the AO. It's very clear there was no bus stop at the place of the incident. Barely the sun, road suddenly. So people not allowed to come inside the enter to the highway.
Go to the appeal order available at page 25.
This further that there is another question for the appeal that in the class 9 preliminary stated that we will be district government hospital to allow and reach the state hospital at 7 AM till 5:30 AM. He did not come back to the place. Therefore, filing of the complaint. This is in delay of the complaint, my lord. Why? That is not my contention. My contention is at the place of the incident there was no bus stop. So people are not allowed to enter into the highway. As there was a belly.
Sketch code, madam.
And moreover, at the time of the incident, they admitted, all the witnesses, eyewitnesses admitted there was a dark. Katle agittu. So they cannot able to see what was happened. They said that when they heard the sound, then only they come to know that the accident was occurred. Here, my condition is, my lord, when the government has not allowed them to enter into the highway. It's not my fault, my lord. And they also admit that at the place of incident, they cut the belly. Belly cut madidare, cut madibittu they unauthorized they enter into the highway. They admit in their cross examination. And also admit that there was no bus tangudana anta yavade palka illa anta adu admit ಮಾಡ್ಕೊಂತಾರೆ. Very clear that there was no bus stop.
ಸ್ಕೆಚ್ ಇದೆಯಾ? ಮಾರ್ಕ್ ಆಗಿಲ್ಲ ಅಂತ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಇದೆಯಾ ನೋಡಿ.
Not marked, my lord, because I was not been examined. Left side of the road there was a fence, my lord, and there was no stop. They admit.
ಸ್ಕೆಚ್ ನೋಡಿದ್ದೀರಾ ನೀವು?
ಹೌದು ಸರ್.
ತೋರ್ಸಿ ಅವ್ರಿಗೆ. 40 feet sketch mark ಇದೆ. ಆಮೇಲೆ ಕೃತ್ಯ ನಡೆದ ಸ್ಥಳ ನಾಟ್ ಆನ್ NH4, that is in service road.
No, service road ಆ ಕಡೆ ಇದೆ ಸರ್. Before that there was a fence. ತಂತಿ ಬೇಲಿ ಇದೆ.
ತಂತಿ ಬೇಲಿ.
ಹೌದು ಸರ್.
ನಿಮ್ ವೆಹಿಕಲ್ ಯಾವ ಕಡೆಯಿಂದ ಬಂದಿದೆ?
ನಮ್ಮ ವೆಹಿಕಲ್ ಹೈವೇ ಅಲ್ಲಿ ಇದೆ ಸರ್. ಹೈವೇ ಅಲ್ಲಿ ಇದೆ, ಮೇನ್ ರೋಡ್ ಅಲ್ಲಿ ಇದೆ. After that fence there was the service road. Next to that service road. And there was a fence. As per the government order, they cannot cross the fence.
Original ತೋರ್ಸಿ. In which direction you are proceeding? Fencing ಆ ಜಾಗದಲ್ಲಿ ಇಲ್ಲ, ನೀವು ಹೇಳೋ ಹಾಗೆ.
Fencing cross ಮಾಡಿ ಅವ್ರು ಬಂದಿರೋ ಸರ್. They cross the fence. I am going on the right side of the road, my lord. Correct side of the road. They cross the fence. Unauthorized. All the witness admits that ಅಲ್ಲಿ ಯಾವುದೇ ಹೋಗಕ್ಕೆ ಇಲ್ಲ, ಜಾಗ ಇಲ್ಲ, ಕಟ್ ಮಾಡಿ unauthorized ಆಗಿ.
ಕೊಡಿ ಎವಿಡೆನ್ಸ್ ಕೊಡಿ, ಎಲ್ಲಿದೆ ನೋಡೋಣ. ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ ಇದೆ ಅಂತ ಯಾರು ಹೇಳಿದಾರೆ ನೋಡೋಣ.
See the evidence of PW1, my lord. Next, we turn to page number 32. Class examination, my lord. ನಾನು 2ನೇ ವರ್ಷದ PUC ಓದಿರುತ್ತೇನೆ. ನಮ್ಮ ಊರಿಗೂ ಎಲ್ಲಿಯೂರಿಗೂ ಗೆಡ್ಡಿಗೂ 1 ಕಿಲೋಮೀಟರ್ ದೂರ ಇದೆ. ನಮ್ಮ ಊರಿನ ಬಳಿ.
ಒಂದ್ ನಿಮಿಷ ಇರಿ, ನಾನೇ ಓದ್ತೀನಿ, ನಂಗೆ ಬರ್ತದೆ ಕನ್ನಡ, ಈಸಿಯಾಗಿ ಓದ್ತೀನಿ ನಾನೇ. ಮೃತ ರಾಜಣ್ಣ ನಮ್ಮ ತಂದೆ. ಬೆಳಗಿನ ಜಾವ 4:45 ಗಂಟೆಗೆ ನಾನು ನಮ್ಮ ತಂದೆ ಹೂವು ಮತ್ತು ಸೊಪ್ಪನ್ನು ಮಾರಾಟ ಮಾಡಲು ಶಿರಾಗೆ ಹೋಗಲು ಎಲಿಯೂರು ಗೇಟ್ ನ ಬಳಿ ಬಸ್ಸಿಗಾಗಿ ಕಾಯುತ್ತಿದ್ದೆವು. ಬಸ್ ಸ್ಟಾಪ್ ಅಂತ ಎಲ್ಲಿದೆ? ಅವ್ರು ನೀವ್ ಹೇಳ್ತಾ ಇದ್ರಿ ಬಸ್ ಸ್ಟಾಪ್ ಇದೆ ಅಂತ, ಎಲ್ಲಿದೆ?
ಇಲ್ಲ
ವಿಟ್ನೆಸ್ ಯಾರು ಹೇಳಿದಾರ್ರಿ ಬಸ್ ಸ್ಟಾಪ್ ಇದೆ ಅಂತ?
ಇಲ್ಲ, ಯಾರು ಹೇಳಿಲ್ಲ ಸ್ವಾಮಿ.
ಬಸ್ ಸ್ಟಾಪ್ ಇದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಆಗ ತುಮಕೂರು ಕಡೆಯಿಂದ ಒಂದು ಲಾರಿ ಅತಿವೇಗವಾಗಿ ಬಂದು ಫುಟ್ಪಾತಿನ ಮೇಲೆ ನಿಂತಿದ್ದ ನಮ್ಮ ತಂದೆಗೆ ಡಿಕ್ಕಿ ಹೊಡೆಯಿತು. ಕೆಳಕ್ಕೆ ಬಿದ್ದ ರಕ್ತ ಗಾಯಗಳಾದವು. ಆ ನಂತರ ಕಳ್ಳಂಬೆಳ್ಳ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋದೆವು. ಅಲ್ಲಿ ಆಗುವುದಿಲ್ಲ ಎಂದು ಹೇಳಿದ್ರೆ ತುಮಕೂರು ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋದೆವು. ಅಲ್ಲಿ ಬೆಳಗ್ಗೆ 8:50 ತೀರಿಕೊಂಡರು. ಲಾರಿ ಚಾಲಕ ತಪ್ಪಿನಿಂದ ಆರೋಪಿಯನ್ನು ಲಾರಿಯ ಚಾಲಕನಾಗಿದ್ದ ಬಗ್ಗೆ ನಾನು ಪೊಲೀಸ್ನವರಿಗೆ ದೂರು ಕೊಟ್ಟಿದ್ದೆ. ದೂರಿಗೆ ನಾನು ಸಹಿ ಮಾಡಿದ್ದೇನೆ. ಲಾರಿಯನ್ನು ಸ್ಥಳದಲ್ಲಿ ಬಿಟ್ಟು ಹೊರಟು ಹೋಗಿದ್ದನು. ನಾನು ದೂರು ಕೊಟ್ಟ ಬಳಿಕ ಪೊಲೀಸರು ಸ್ಥಳಕ್ಕೆ ಬಂದು ಮಾಜರ್ ಬರೆದರು. ಪಟ್ಟಿ ಸವಾಲಲ್ಲಿ ಏನಿದೆ? ಯಾವುದೇ ವಾಹನಗಳನ್ನು ನಿಲ್ಲಿಸುವುದಿಲ್ಲ ಮತ್ತು ಸರ್ವಿಸ್ ರಸ್ತೆ 2 ಕಡೆ ಬಸ್ಸು ನಿಲ್ಲಿಸುತ್ತಾರೆ. ಅಪಘಾತವಾಗುವ ಮೊದಲು ನಾವು ತಂದೆ ಸೇರಿ ನಾವು ಒಟ್ಟು 5 ಜನ ಬಸ್ಸಿಗಾಗಿ ಕಾಯುತ್ತಿದ್ದ ನಿಂತೆವು. ನಾವು ನಿಂತಿದ್ದ ಜಾಗದಲ್ಲಿ ಬಸ್ ನಿಲ್ದಾಣ ಎಂದು ಯಾವುದೇ ಫಲಕ ಇರುವುದಿಲ್ಲ. ಸರ್ವಿಸ್ ರಸ್ತೆಯಲ್ಲಿ ಬಸ್ ನಿಲ್ದಾಣ, ತಂಗುದಾಣ ಎಂದು ಇದೆ ಎಂದರೆ ನಿಜ. ನೀವೇ ಸಜೆಸ್ಟ್ ಮಾಡಿದಿರಿ. ಸರ್ವಿಸ್ ರಸ್ತೆಯಲ್ಲಿ ಬಸ್ ನಿಲ್ದಾಣ, ತಂಗುದಾಣ
ನಿಂತಿರೋ ಜಾಗದಲ್ಲಿ
ಇದೆ ಎಂದರೆ ನಿಜ.
ಸರ್ವಿಸ್ ರಸ್ತೆಯಲ್ಲಿ, ಬಟ್ ದಿ ಆಕ್ಸಿಡೆಂಟ್ took place in the main road, my lord. As per the sketch, is what happened. Accident took place in the highway, main road.
Highway na service road, sketch note.
Service road ಅಲ್ಲಿ ಇದೆ ಸ್ವಾಮಿ, but the accident took place as per the sketch. It was a highway. ಅಲ್ಲಿ ಯಾವುದೇ ಬಸ್ ನಿಲ್ದಾಣ ಇಲ್ಲ.
ಸ್ಕೆಚ್ ತೋರಿಸ್ರಿ ಅವರಿಗೆ.
ಆ ದಿನ ಅಪಘಾತ ಮೊದಲು ನಮ್ಮ ತಂದೆ ನಮ್ಮಿಂದ 5 ಹೆಜ್ಜೆ ಮುಂದೆ ನಿಂತಿದ್ರು. ಆಗ ನಾವೇನಾರು ಅಲ್ಲೇ ಮಾತಾಡ್ತಾ
ಕೊಡಿ ಮೇಡಮ್, ಒರಿಜಿನಲ್ ಸ್ಕೆಚ್ ಕೊಡಿ. ಕೊಟ್ನಲ್ಲ ಅವ್ರಿಗೆ ವಾಪಸ್ ಬಂತ.
ಅದಕ್ಕೂ ಮೊದಲು ನಾನು ಲಾರಿ ಬರೋದು ನೋಡಿರಲಿಲ್ಲ ಎಂದಿರುವುದು. ನನಗೆ ವಾಹನ ಚಲಾಯಿಸುವ ಅಭ್ಯಾಸ ಇರುವುದಿಲ್ಲ. ಸದರಿ ಲಾರಿ ಅತಿವೇಗವಾಗಿ ಬರುತ್ತಿತ್ತು, ಆದರೆ ಎಷ್ಟು ಕಿಲೋಮೀಟರ್ ವೇಗದಲ್ಲಿ ಬರುತ್ತಿತ್ತು ಎಂದು ನಮಗೆ ಹೇಳಲಾಗುವುದಿಲ್ಲ. ನಮ್ಮ ತಂದೆ ನಮ್ಮ ಪಕ್ಕದಲ್ಲಿ ನಿಂತಿದ್ದರೆ ಅಪಘಾತವಾಗುತ್ತಿರಲಿಲ್ಲ ಎಂಬ ಪ್ರಶ್ನೆಗೆ ಸಾಕ್ಷಿಗೂ ಆರೋಪಿ ಅಪ್ಸೈಡ್ ಮಾಡಿದ್ದಾರೆ. ಗಾಡಿ ಅಪ್ಸೈಡ್ ಮಾಡಿದಾರಂತ ಈ ರಿಪೋರ್ಟ್, ಬಟ್ ದಿ IME ರಿಪೋರ್ಟ್ ಇಸ್ ವೆರಿ ಕ್ಲಿಯರ್. The lorry was not upside. ಅದು ಹಂಗೆ ನಿಂತಿತ್ತು.
ಬಿಗಿನಿಂಗ್ ಅಲ್ಲಿ ಫೈನಲಿ ಸ್ಕೆಚ್. ಅಲ್ಲರಿ ಸರ್ವಿಸ್ ರಸ್ತೆ ಈ ಫೆನ್ಸಿಂಗ್ ಇಂದ ಆಚೆಗಿರುತ್ತಾ?
ಹೌದು ಸರ್.
ಹೆಂಗೆ ಇದೇನ್ ತಂತಿ ಬೇಲಿನಾ?
ಹೌದು.
ಹಾ,
ಆ ತಂತಿ ಬೇಲಿ ಯಾವ ಕಡೆ ಸರ್ವಿಸ್ ರೋಡ್ ಇರೋ ಸ್ವಾಮಿ, ಅವ್ರು ದಾಟ್ಬಿಟ್ಟು ಈ ಕಡೆ ಬರ್ತಾರೆ.
ನಿಮ್ ಮೇಲೆ ವೆಹಿಕಲ್ ನಿಂತಿರೋದು ಡೈರೆಕ್ಷನ್ ನೋಡಿದೀರಾ?
ಎಸ್, ರೈಟ್ ಸೈಡ್ ಇದೆ ಸರ್, ಮೇನ್ ರೋಡ್ ರೈಟ್ ಸೈಡ್ ಇದೆ ನಮ್ಮ ಕಡೆ.
ತುಮಕೂರು 30 ಅಡಿ ಆಗಲ್ಲ ಶಿರಾ
ಡ್ರೈವಿಂಗ್ ಗಾಡಿ
ಕೃತ್ಯ ನಡೆದ ಸ್ಥಳ.
ರೈಟ್ ಸೈಡ್ ಆಫ್ ದಿ ರೋಡ್, ನಾಟ್ ಲೆಫ್ಟ್ ಸೈಡ್.
ನಿಮ್ಮ ವೆಹಿಕಲ್ ಯಾವ ಕಡೆಯಿಂದ ಯಾವ ಕಡೆ ಹೋಗ್ತಾ ಇತ್ತು ಡೈರೆಕ್ಷನ್?
ಕೆಲಂಬಲ ಕಡೆ.
ಅದೇ ಶಿರಾ ಕಡೆಗ?
ಶಿರಾ ಕಡೆ.
ಹಾ,
ರೈಟ್ ಸೈಡ್ ಇದೆ ಸ್ವಾಮಿ. ಡ್ರೈವಿಂಗ್ ಮೈ ವೆಹಿಕಲ್ ಆನ್ ದಿ ರೈಟ್ ಸೈಡ್ ಆಫ್ ದಿ ರೋಡ್. They said that they were standing on the left side of the road and waiting the bus, but there was no bus stop. So due to their fault, it was happening, not my fault. Category listed at it's on highway, my lord, in road again. All the witness admits that there was no bus stop, and it's due to darkness, were unable to see the vehicle. And they jumped the fence illegally. Page number 3 of class exam, one my lord. He admits that ಆ ಸಮಯದಲ್ಲಿ ನಮ್ಮ ತಂದೆ
ತಲೆ ಮೇಲೆ ಸೊಪ್ಪು ಹೊತ್ತುಕೊಂಡು ರಸ್ತೆ ದಾಟುತ್ತಿದ್ದಾಗ ಗಾಬರಿಯಿಂದ ಹಿಂದಕ್ಕೆ ಹೋಗುವಾಗ ಈ ಅಪಘಾತವಾಗಿದೆ ಎಂದರೆ ಸುಳ್ಳು.
ಮುಖ್ಯ ರಸ್ತೆಯಿಂದ ಸರ್ವಿಸ್ ರಸ್ತೆಗೆ ಬರಲು ಮಧ್ಯದಲ್ಲಿ ಹಾಕಿರುವ ಜಾಲರ ತತ್ತಿ ಬೇಲಿಯನ್ನು ಮಧ್ಯದಲ್ಲಿ ಸ್ವಲ್ಪ ಜಾಗ ಮಾಡಿಕೊಂಡು ಅದರ ಮೂಲಕ ಮುಖ್ಯ ರಸ್ತೆಗೆ ಜನ ಓಡಾಡುತ್ತಾರೆ ಎಂದರೆ ನಿಜ. It's illegal they cut the fence, my lord. And enter into the main road. It's their fault. ಎಲ್ಲೂರು ಗೇಟಿನಲ್ಲಿರುವ ಜಾಲವನ್ನು ರಾಷ್ಟ್ರೀಯ ಹೆದ್ದಾರಿ ಜನರು ಕಟ್ಟು ಮಾಡಿ ಇಟ್ಟಿದ್ದಾರೆ. ಜನ ತಮ್ಮ ಅನುಕೂಲಕ್ಕಾಗಿ ಕಟ್ಟು ಮಾಡಿ ಹೊಂದಿದ್ದಾರೆ. PW2 also admits my lord, my cross examination. ಆ ಸ್ಥಳದಲ್ಲಿ ಬಸ್ ನಿಲ್ದಾಣ ಎಂದು ಯಾವುದೇ ಫಲಕ ಇರುವುದಿಲ್ಲ.
Yes, madam.
Totals of PW3 my lord.
3, 4 I have read all the 4.
Including the complaint, your lordships are the eyewitness to the incident. Not just PW1 complainant was standing right next to his father. PW1 is the complainant, the son of the deceased. Was standing right next to his father. PW2, 3, and 4 are also the eyewitnesses, your lordships. We already mentioned about the rash and negligent driving of the driver. And they've also seen that.
Have you seen the place of accident? But witnesses all they says that they were in service road, but not in service road. It is in highway only. 10 ಅಡಿ ದೂರ ಅಂದ್ರೆ ಏನಾಯ್ತು? ಎಲ್ಲಿ ಬಂತು? They are not in service road, but according to them, bus stop is there in service road. PW1, you go to the evidence of PW1. ಗೇಟಿನ ಬಳಿ ಬಸ್ಸಿಗಾಗಿ ಕಾಯುತ್ತಿದ್ದೆವು ಅಂತ PW1 ಹೇಳ್ತಾನೆ. ಫಸ್ಟ್ ಆಫ್ ಆಲ್ ಅಲ್ಲಿ ಯಾವ್ದು ಗೇಟ್ ಇಲ್ಲ. PW1, he is the son of the deceased. ಆಯ್ತಾ? And in the cross examination PW1, ನಮ್ಮ ತಂದೆ ನಮ್ಮ ಪಕ್ಕದಲ್ಲಿ ನಿಂತಿದ್ದರೆ ಅಪಘಾತವಾಗುತ್ತಿರಲಿಲ್ಲ ಎಂಬ ಪ್ರಶ್ನೆಗೆ ಸಾಕ್ಷಿಯು ಆರೋಪಿ ಅಪ್ಸೈಡ್ ಮಾಡದಿದ್ದರೆ ಅಪಘಾತವಾಗುತ್ತಿರಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾನೆ. ಅಪ್ಸೈಡ್ ಆಗಿಲ್ಲ ವೆಹಿಕಲ್, ಹೌದಾ? ಮತ್ತೆ ಮೇಲ್ಗಡೆ ಸರ್ವಿಸ್ ರಸ್ತೆಯಲ್ಲಿ ಬಸ್ ನಿಲ್ದಾಣ ತಂಗುದಾಣ ಇದೆ ಎಂದರು ನಿಜ. ಬಟ್ ಆಕ್ಸಿಡೆಂಟ್ ಇಸ್ ನಾಟ್ ಇನ್ ಬಸ್ ಸ್ಟ್ಯಾಂಡ್, ಅಲ್ಲ ತಂಗು ಇದು ಸರ್ವಿಸ್ ರೋಡ್. ಮೇಲ್ಗಡೆ ನೋಡಿ, ಮೇಲ್ಗಡೆ ಸರ್ವಿಸ್ ರಸ್ತೆಯಲ್ಲಿ ಬಸ್ ನಿಲ್ದಾಣ ತಂಗುದಾಣ ಇದೆ ಎಂದರೆ ನಿಜ. ಬಟ್ ದ ಆಕ್ಸಿಡೆಂಟ್ ಇಸ್ ನಾಟ್ ಇನ್ ಸರ್ವಿಸ್ ರೋಡ್. ಆಯ್ತಾ? PW1 ಎವಿಡೆನ್ಸ್. ಈ ಕಡೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನಂಬರ್ 3 ಯಲ್ಲಿ ಮುಖ್ಯ ರಸ್ತೆಯಿಂದ ಸರ್ವಿಸ್ ರಸ್ತೆಗೆ ಬರಲು ಮಧ್ಯದಲ್ಲಿ ಹಾಕಿರುವ ಜಾಲರ ತಂತಿ ಬೇಲಿಯನ್ನು ಮಧ್ಯದಲ್ಲಿ ಸ್ವಲ್ಪ ಜಾಗ ಮಾಡಿಕೊಂಡು ಅದರ ಮೂಲಕ ಮುಖ್ಯ ರಸ್ತೆಗೆ ಜನರು ಓಡಾಡುತ್ತಾರೆ ಎಂದರೆ ನಿಜ. ದಟ್ ಆಲ್ಸೋ ಅಡ್ಮಿಟ್ಸ್. In between the main road and also the service road, there is a fencing. ಅದನ್ನ ದಾಟಿ ಬಂದಿದ್ದಾರೆ ಅವರು. ಆಯ್ತಾ? ನೆಕ್ಸ್ಟ್ ನಮ್ಮ ಊರಿನಿಂದ ಎಲಿಯೂರಿಗೆ ಹೋಗಬೇಕಾದ್ರೆ ಸುಮಾರು 1 ಫರ್ಲಾಂಗ್ ದೂರದಲ್ಲಿ 100 ಅಂಡರ್ಗ್ರೌಂಡ್ ಬೈಪಾಸ್ ನೆಕ್ಸ್ಟ್ ಮರ್ದರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಅದೇನು ಆಸ್ಪತ್ರೆ ತೆಗೆದುಕೊಂಡು ಹೋದ ಬಗ್ಗೆ. ನೆಕ್ಸ್ಟ್ PW2 ನೋಡಿ, ಇವನೇನ್ ಹೇಳ್ತಾನೆ, ಎಲಿಯೂರ್ ಗೇಟ್ ನಲ್ಲಿ ತಂದೆ ಫುಟ್ಪಾತಿನ ಮೇಲೆ ನಿಂತಿದ್ದರು. ಅಲ್ಲೆಲ್ಲಿ ಫುಟ್ಪಾತ್ ಇದೆ? ಚಾಸ 1ರವರ ತಂದೆ ಫುಟ್ಪಾತ್ ಮೇಲೆ ನಿಂತಿದ್ದರು. ಆಗ ತುಮಕೂರು ಕಡೆಯಿಂದ ಬಂದು ಲಾರಿ ತುಂಬಾ ವೇಗವಾಗಿ ಬಂದು ರಾಜಣ್ಣನಿಗೆ ಡಿಕ್ಕಿ ಹೊಡೆಯಿತು. ಆಗ ಅಲ್ಲಿ ಕೆಳಕ್ಕೆ ಬಿದ್ದು ಗಾಯಗೊಂಡ ಅವನು ಅಂತ ಹೇಳ್ತಾರೆ. ಸ್ಕೆಚ್ ಅಲ್ಲಿ ನೋಡಿದಾಗ ಅಲ್ಲಿ ಫುಟ್ಪಾತ್ ಇಲ್ಲ, ಯಾವ ಫುಟ್ಪಾತ್ ಇಲ್ಲ ಅಲ್ಲಿ. ಆಯ್ತಾ? ಮತ್ತೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಮೂವರು ಸರ್ವಿಸ್ ರಸ್ತೆಯಲ್ಲಿ ನಿಂತಿದ್ದೆವು ಅಂತ ನಾವು, ಬಟ್ ದೇ ಆರ್ ನಾಟ್ ದೇರ್ ಇನ್ ದಿ ಸರ್ವಿಸ್ ರೋಡ್. ಅಪಘಾತ ಸಮಯದಲ್ಲಿ ಚಾಸ 1 ಮತ್ತು ಚಾಸ 3ರವರು ಸರ್ವಿಸ್ ರಸ್ತೆಯಲ್ಲಿ ನಿಂತಿದ್ದು. ಆ ಸಮಯದಲ್ಲಿ ನಾನು ಚಾಸ 1, 3ರಿಂದ ಪುಟ್ಟರಾಜನ ಮಾತ್ರ ಇತ್ತು, ಬೇರೆ ಯಾರು ಇರಲಿಲ್ಲ. ಅಪಘಾತವಾದಾಗ ಕತ್ತಲಾಗಿತ್ತು. ಆ ಸಮಯದಲ್ಲಿ ನಾನು ಮಾತನಾಡುತ್ತಿರಲಿಲ್ಲ, ನನಗೆ ವಾಹನ ಚಲಾಯಿಸಲು ಬರುವುದಿಲ್ಲ. ಮತ್ತೆ ಹಿಯರ್ ಆಲ್ಸೋ ಹೀಗೆ ಸರ್ವಿಸ್ ರಸ್ತೆಯಲ್ಲಿ ತಂಗುದಾಣ ಎಂದು ಫಲಕ ಇದೆ. ನಮ್ಮ ಊರಿನಿಂದ ಎಲಿಯೂರು ಗೇಟ್ಗೆ ಬರಲು ಸುರಂಗ ಮಾಡಿದ್ದಾರೆ ಎಂದರೆ ನಿಜ. ಸರ್ವಿಸ್ ರಸ್ತೆಗೂ ಮುಖ್ಯ ರಸ್ತೆಗೂ ಮಧ್ಯದಲ್ಲಿ ಜಾಲರಿ ಬೇಲಿ ಹಾಕಿದ್ದಾರೆ ಅಂದ್ರೆ ನಿಜ. ಈ ಆಲ್ಸೋ ಅಡ್ಮಿಟ್ಸ್ ದಿ ಸೇಮ್ ಇನ್ ದಿ ಕ್ಲಾಸ್. ಮತ್ತು PW3 ಆಲ್ಸೋ ಫುಟ್ಪಾತ್ ನಲ್ಲಿ ನಿಂತಿದ್ದಾಗ ಅಂತ ಹೇಳ್ತಾರೆ, ವೇಗವಾಗಿ ಬಂದು ರಾಜಣ್ಣನಿಗೆ ಡಿಕ್ಕಿ ಹೊಡೆಯಿತು. ಆಲ್ ವಿಟ್ನೆಸಸ್ ಸೇಸ್ ದಟ್ ದೇ ವರ್ ಇನ್ ಫುಟ್ಪಾತ್. ಬಟ್ ಇನ್ ದಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಹಿ ಸೇಸ್ ದಟ್ ನಾವು ಮುಖ್ಯ ರಸ್ತೆಯ ಫುಟ್ಪಾತ್ ಮೇಲೆ ನಿಂತಿದ್ದೆವು. ಮೃತ ರಾಜಣ್ಣ ನಮಗಿಂತ 8 ಅಡಿ ಮುಂದೆ ನಿಂತಿದ್ದರು. ಅಂದ್ರೆ ಹಿ ಇಸ್ ನಾಟ್ ಇನ್ ಫುಟ್ಪಾತ್ ಆಲ್ಸೋ. PW3 ಅಪಘಾತ ನಂತರ ಲಾರಿ ಸ್ವಲ್ಪ ಮುಂದೆ ಹೋಗಿ ವಾಲಿಕೊಂಡು ಫುಟ್ಪಾತಿನ ಮೇಲೆ ನಿಂತುಕೊಂಡಿತ್ತು. ಅಪಘಾತವಾದ ಕತ್ತಲಾಗಿತ್ತು ಎಂದರೆ ನಿಜ. ಗೇಟ್ನ ಬಳಿ ಬಸ್ಸಿಗಾಗಿ ಕಾಯುತ್ತಿದ್ದ ಮೃತ ರಾಜಣ್ಣ ರಸ್ತೆಯ ಪಕ್ಕದಲ್ಲಿ ನಿಂತಿದ್ದರು. ಆಗ ತುಮಕೂರು ಕಡೆಯಿಂದ ಒಂದು ಲಾರಿ ಬಂದು ಮೃತ ರಾಜಣ್ಣ ಡಿಕ್ಕಿ ಹೊಡೆಯಿತು. ಚೀಫ್ ಮುಂದೆ ಹೋಗುತ್ತಿದ್ದ ರಾಜಣ್ಣ ನಮಗಿಂತ ಸ್ವಲ್ಪ ಮುಂದೆ ಹೋಗುತ್ತಿದ್ದನು. ಮೃತ ರಾಜಣ್ಣ ಮುಖ್ಯ ರಸ್ತೆಯಲ್ಲಿದ್ದನು. ಇವನು ಅಡ್ಮಿಟ್ ಮಾಡ್ಕೊತಾನೆ ನೋಡಿ. ಕ್ರಾಸ್ ಅಲ್ಲಿ PW4 ಈ ಅಡ್ಮಿಟ್ಸ್ ದಟ್ ಮುಖ್ಯ ರಸ್ತೆಯಲ್ಲಿದ್ದನು, ನಮ್ಗಿಂತ 8ರಿಂದ 10 ಅಡಿ ಮುಂದೆ ಇದ್ದ ಅಂತ. ನನಗೆ ಅಥವಾ 8-10 ಅಡಿ ದೂರದಲ್ಲಿ ಒಬ್ಬ ವ್ಯಕ್ತಿ ಲೈಟ್ ಬೆಳಕು ಇದ್ದರೆ ಕಾಣಿಸುತ್ತದೆ ಮುಂದಿಂದ. ಆಮೇಲೆ ಮುಖ್ಯ ರಸ್ತೆಯಲ್ಲಿದ್ದನು. ಅಪಘಾತ ಮೊದಲು ಲಾರಿ ಎಷ್ಟು ವೇಗವಾಗಿ ಬರ್ತಿದೆ ಅಂತ ನಾನು ನೋಡಿರುವುದಿಲ್ಲ. ಸ್ಪೀಡ್ ದೇ ಕೆನಾಟ್ ಟೆಲ್, ಬಟ್ ದೀಸ್ ಆರ್ ದಿ ಎವಿಡೆನ್ಸ್ ಡಿಸ್ಕ್ಲೋಸಸ್ ದಟ್ ನಾಟ್ ಇನ್ ದಿ service road. Accident is also not in the service road and also not in the footpath. Footpath allu illa. Avane PW4 categorically admits that he was in main road and at the distance of 8 to 10 feet from the PW other witnesses. These are the materials are not considered by the both the trial court as well as the first appellate. So heard the petitioner, counsel and also the counsel appearing for the state. The present petition is filed being agreed by the judgment of conviction and confirmation order passed by the appellate court. The facts of the case of the prosecution is that on 25/10/2007 at about 5 AM near Eliyur Gate on NH4 road, being the driver of lorry bearing registration number K21A6888, drove the same in rash and negligent manner and dashed to Rajanna, who was waiting for bus on the left side of the road. Due to this, the said Rajanna sustained burn injuries and died at Tumkur Government Hospital while taking treatment on the same day. And hence, the charge has been framed against the present petitioner for offence mentioned 37279 304A of IPC. The prosecution mainly relies upon the evidence of PW1 to total history PW 1 to 8, and particularly mainly relying upon the statement eyewitnesses evidence, that is PW1 to 4. The defense have not laid any evidence before the trial court. However, both the courts on appreciation of material comes to the conclusion that the accident was on account of negligence on the part of the petitioner herein, being agreed by the said judgment and of conviction and confirmation of the present of division petition is filed. The main contention of the revision petitioner before the court is that both the courts have not perused the material available on record, and perverse order has been passed and failed to appreciate particularly the evidence at PW 125. And they claims that they have seen the accident and who are said to the eyewitnesses to the accident. And it is clear that none of them were present at the time of the accident. Unfortunately, lower court as well as the first appellate court have given the finding that they are the eyewitnesses to the incident. And their statement corroborates each other. But there are contradictions in the evidence of PW 124 particularly. The PW1 who claims that he is the son of the deceased. But he claims that he was in the bus stop. But no, there was no any bus stop, only a provision is made to stop the vehicle. The council also brought to notice of the contradictions of the witnesses PW 2 to 4. Hence it requires interference of this court. Council appearing for the state would submit that the trial court as well as first appellate court both considered the material available on record. And PW3 and R eyewitnesses to the incident. Both of them have stated that they have seen the accident and the accident was taking place due to rash and negligent driving of lorry by its driver. The council also submits that all the witnesses categorically says that the other witnesses PW1 and 2 who are the eyewitnesses also supported the case of the prosecution, and the driver after causing the accident he ran away from the spot. And these are the materials are clearly corroborates the case of the prosecution. Though counsel submits that sketch is not proved. Sketch is not marked and proved by examining the evidence of PW 1 to 4, particularly eyewitnesses, is sufficient. Having heard the respective counsel and also on perusal of material, the question before the court is whether both the courts have committed an error in convicting the petitioner and perverse finding is given, not appreciating the material available on record. Having heard the respective counsel and also on perusal of material available on record, particularly PW1 who is the son of the deceased, he claims that the accident was occurred when they were waiting for bus near the Eliur gate. And at that time, the lorry came in a rash and negligent manner and dashed against his father, who was standing on the footpath. In the cross-examination, he admits that when they were standing near the spot, no board is fixed that there is a bus stop. But witness claims that in service road there is a board. He also claims that lorry was upsided and hence accident was occurred. And admits that at the time of the accident there was a darkness. And also he admits that there was no any street light. He also admits that in between the service road and main road there is a fencing. And people are also removing the portion of the fencing using the set place for their movement. The other witness is PW2. He claims that all of them were standing on the footpath. And a lorry came and dashed against the deceased. But in the cross-examination, he admits, he claims that CW1 and CW3 and all of them were standing on the service road. And there was a darkness. And he also admits that there was no any board, that there was a bus stop. But he claims that the board is there at the service road. He also admits that in between the service road and main road, there is a fencing. The other witness is PW3. He also claims that all of them are standing in footpath. Larry came in a rash and negligent manner and dashed against him. But in the cross-examination, he admits that there were 4 persons and all of them are standing on the footpath. But deceased was standing at the distance of 8 feet from them. In the cross-examination, he also admits that there was a darkness at the time of the accident. The other witness, PW4, who claims that he is also an eyewitness, he says that they were standing near the Yellure gate to board the bus. And deceased was standing by the side of the road. The lorry came and dashed against him. In the cross-examination, he admits that the deceased was standing. The deceased was moving in a main road. And he was at the distance of 8 to 10 feet. It is suggested that they were standing at the distance of 20 feet and the same was continuing. And he cannot tell the speed of the vehicle. The PW5 is the major witness. 5 and 6. PW7 is PSI, who registered the FIR and sent the same to court. PW8 is the IME inspector. And in this evidence, he says that no damages caused to the lorry. And there was no any mechanical defect. Having heard the respective counsel and also on perusal of oral and documentary evidence available on record, I have already pointed out that the sketch has not been marked. However, sketch discloses the national highway and also there is a service road, and in between the service road and the main road there was a fencing. And also it is admitted fact that the said portion of the fencing was got removed and people are using the said area for movement. Though all the witnesses claims that all of them are standing on the footpath, but the very PW4 categorically admits that the deceased was moving and he was in the main road. And he was also at the distance of 10 feet from them. And hence it is clear that all of them were not standing on the footpath as deposed by other witnesses PW123. All the PW123 claims that all of them are standing on the footpath. but accident was taken place not in the footpath and the same was in the main road. And the evidence of PW1 is also clear that there was no any bus stop where the accident was taken place, and also no board. But he claims that the bus stop is there near the service road. But hence it is clear that the accident was not taken place in the service road. PW1 claims that the lorry was upsided and hence accident was occurred. Voluntarily slays voluntary slays. And PW8 evidence is clear that no damages to the vehicle. Hence it is clear that lorry was also not upsided as deposed by PW1. It is also illustrated from the mouth of all the witnesses that there was no any street light and there was a darkness at the time of the accident. Having taken note of the admission given by PW2 also, he says that all of them are standing in the service road, but accident was not taken place in the service road. But he deposes in chief that all of them are standing on the footpath. He also categorically admits that fencing was got removed to certain extent and people are moving in the set place and taking access to the main road through the said removal of fencing. The PW3 also deposes in chief evidence that all of them are standing on the footpath. He claims that all of them are standing on the footpath, but he also admits that the deceased was at the distance of 8 feet from them. And hence it is clear that all of them are not on the footpath and the deceased was at the distance of 8 to 10 feet. And accident was also taken place in the main road. And such being the factual aspects of the case, both the trial court as well as the first appellate court fails to appreciate the material available on record, particularly the evidence of PW1 to 4. Though they claims that they are the eyewitnesses, and in the cross-examination they have given different versions. And in the chief evidence, though claim that all of them are standing on the footpath, but all the witnesses claims that the deceased was at the distance of 8 to 10 feet. When such being the factual aspects and when the accident was taken place on the main road, the evidence of PW1 to 4 does not corroborate each other regarding the accident is concerned. It is not in dispute that vehicle was also proceeding on the highway where there was no any bus stop, and only they claims that bus stop was in the service road, not in the main road. And hence both the courts failed to take note of the admissions illustrated from the mouth of particularly PW1 to 4. When such being the factual aspects of the case, the order passed by both the trial court as well as the first appellate court is nothing but perverse, and appreciation is also against the material on record. Hence, it is a fit case to exercise the powers under Section 401 of CRPC, and the very legality of the order is questioned before this court, and this court can exercise the powers under Section 401 of CRPC and reverse the finding of the trial court. In view of the discussions made up, I pass the following order. Revision petition is allowed. The impugned order passed by the trial court as well as the first appellate court in so and so is hereby set aside. Consequently, the conviction and sentence passed by the trial court is set aside and accused is acquitted. Accused oblique revision petitioner is acquitted. 41. ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಎಲ್ಲ ಪಾಸ್ ಓವರ್ ಮಾಡಿ ಮಧ್ಯಾಹ್ನ ನೋಡು ಯಾವ್ದು ಕಮೆಂಟ್ಸ್ ಮಾಡ್ರೆ ಆಗೋದಿಲ್ಲ ಮಧ್ಯಾಹ್ನ. ಹಿಯರಿಂಗ್ ಬೇಡ, ನಾವೇ ಹಾಕ್ತಾ ಇದೀವಿ, ಓಲ್ಡಷ್ಟೇ ಮಾಡ್ತಾ ಇದೀವಿ. ಕೇಳಿದಾರ ಯಾರು? ಬಂದಿದೆಯಾ? ಇಬ್ರು ಸೈಡ್ ರೆಡಿ ಇದಾರ? ಮತ್ತೆ ಹೇಳಿ ಏನಾಗ್ಬೋದು 66? ಅದರ್ ಸೈಡ್ ಯಾರು SPP-ನಾ? ಯಾಕೆ ರೀಸನ್ ಏನು? Petitioner counsel 6 times on the ground that is not keeping well. 2015 ರೀ. ಮಿಸ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಯಾವ್ದಾರ ಒಂದು ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. 14th ಕೊಡ್ತೀರಾ? ಇವತ್ತು ನಾವೆಲ್ಲ 14th ಆಯ್ತು 15. ಸೀರಿಯಲ್ ನಂಬರ್ ಏನು? ನೀವ್ಯಾರು? BS ಪ್ರಸಾದ್ ಯಾರು? ವೈ ಒನ್ ಟೈಮ್ misplaced. Petitioner counsel 6 times on the ground that file is misplaced. ಇನ್ನೇನಾಗುತ್ತೆ? 2013 ಎಲ್ಲ ಇಟ್ಕೊಂಡ್ರೆ ಮಿಸ್ಪ್ಲೇಸ್ ಆಗುತ್ತೆ. Miss this matter on 14th. 50. ಹೇಳಿ. ಮುರಾರಿ ಮೋನಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ? ನೀವೇನಾ? ಓಕೆ. ಕೊಡ್ಬೋದಾ ಡೇಟು? Petitioner counsel 6 times. Respondent 2 to 4 counsel is also present and says no objection. ಒಂದ್ ನಿಮಿಷ. Miss this matter on 14th. ಮತ್ತೆ ಟೈಮ್ ಕೇಳ್ಬೇಡಿ. 49 ಹೇಳಿ. ವಕಾಲತ್ತೆ ಹಾಕಿಲ್ಲ. Counsel submits that Anjana CH has filed wakalat 2 days back, and hence the office is directed to put up the wakalat and show the name. Name already shown. And counsel 6 times. List this matter on 14th March.
Serial number 62, Your Honor.
62.
ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಬೇಕಿತ್ತು. ಪ್ರಾಸಿ ಕೌನ್ಸಿಲ್
ಯಾವಾಗ ಹಾಕಿದ್ರಿ?
ಇನ್ನು 2 weeks ಅಲ್ಲಿ ಅಪ್ಲೈ ಮಾಡ್ತಾರೆ.
ವಕಾಲತ್ ಯಾರು ಹಾಕಿರೋದು?
ಇನ್ನು ಹಾಕಿರೋ DB ಗೌಡ.
ಮತ್ತೆ ನರೇಂದ್ರ DV ಕೂಡ ವಕಾಲತ್ ನಾಟ್ ಫೈಲ್ಡ್.
ಹಾಕ್ಬೇಕಿದ್ರೆ ಒಂದು 2 days ಟೈಮ್ ಬೇಕು. ಅವ್ರು ಹುಷಾರಿರಲಿಲ್ಲ, ಸೊ ಅವ್ರು ಔಟ್ ಆಫ್ ಟೌನ್ ಇದ್ದಾರೆ. ಸೊ ಅದಕ್ಕೋಸ್ಕರ
ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ seeks 2 days time to file ವಕಾಲತ್. And hence if wakalat is filed, show the name. Ida counsel ಇದಾರಲ್ಲ?
ಕೌನ್ಸಿಲ್ ಇದ್ದಾರೆ, ಬಟ್ ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿಲ್ಲ.
ಅಷ್ಟೇ ತೋರಿಸ್ಬಿಡಿ ಅಷ್ಟೇ. And counsel on Praxi counsel also 6 times. Is this matter on 14th March?
ಸೀರಿಯಲ್ ನಂಬರ್ 45.
ಹೇಳ್ರಿ ಏನಾಗ್ಬೇಕು? 45
ಏನ್ ನಾಗೇಂದ್ರ ನಾಯ್ಕರು ಇವತ್ತು ಧಾರವಾಡದಲ್ಲಿ ಇದ್ದಾರೆ. ಅದಕ್ಕೆ ದಿಸ್ ಫ್ರೈಡೆ, ಥರ್ಸ್ಡೇ ಫ್ರೈಡೆ ಆಲ್ಸೋ
ಅಂದ್ರೆ 2012 ಮ್ಯಾಟರ್ 1 decade.
2 days ಥರ್ಸ್ಡೇ ಆರ್ ಫ್ರೈಡೆ.
ನೀವು ಪ್ರಾಕ್ಸಿನಾ?
ಹೌದು ಮೇಡಮ್, ನಾಗಭೂಷಣ್ ರಾವ್
ಮೇಡಮ್ ಅಲ್ರಿ ನಾನು?
ಅಲ್ಲ ಸರ್.
Praxi counsel 6 times on the ground that counsel on record is in Dharwad. Hence this matter on 14th. Shana. Ira kodinile ettu. ಅದು ಅಡ್ಮಿಷನ್ ಒಂದು ಪಾಸ್ ಔಟ್ ಮಾಡಿದ್ವಲ್ಲ, ಯಾರು ಮಾಡಿ?
Number 40.
ಸರ್ ಇಲ್ಲೂ ಇಲ್ಲೂ ಇದಾವಂತ ಎಲ್ಲ ಒಟ್ಟಿಗೆ
ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾ ಇದ್ರು ಮೇಡಮ್ ನಾನೇ ಇಷ್ಟ ಆಗ್ತಾ ಇದ್ರು ಹಿಂದೆ ನೋಡಿ ಮೇಡಮ್ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀನಿ ಕೇಳಿಸ್ಕೊಂಡಿಲ್ಲ
ದಸರಾದಲ್ಲಿ ಮಾಡ್ಕೊಬಿಡಿ, ಕಂಟಿನ್ಯೂ ಆದ್ರೆ ಮುಗಿಯಲ್ಲ.
Request
ಹೇಳಿ.
serial number 64 will be not attended.
64. SP ಯಾವ ಕಡೆನಾ? ಆಯ್ತು. ಯಾವಾಗ when do you want?
Excuse me,
Good. Additional council 6 time. This matter on ಯಾವಾಗಲೂ 14th ಹಾಕ್ಬಿಡಿ, 14th March. Serial number 17.
May I please, my lord?
Yes, counsel.
My lord, regarding the compromise where conviction has already been recorded, my lord, to pose a question, my lord. I will submit that this honorable single judge's decision, coordinate bench of this on court, my lord, has decided this question, my lord. The 498 and the there is a compromise after the conviction, my lord, since it's 498A, because the honorable Supreme Court has laid down that the 498A can be quashed, my lord. That's of course on the 482 CRPC, that is before conviction. My lord's question is after conviction, what has to happen? The general principle, my lord, of section 320 CRPC, my lord, if it is applicable, 320 is applicable. I do consider 320 is not applicable. If it is applicable, it is written in 320 subsection 8, my lord, that the powers of compromise can be exercised by the appellate or the revisional court. My lord, since now that the honorable, my lord is exercising the revisional jurisdiction, where the matter has not attained finality, but the honorable court is examining the legality or otherwise of the proceedings. So it means the matter is pending before my lord. The exercise of the power to quash, my lord, is under 482 CRPC, is not under 320 or 397 CRPC, my lord, in this case. The power under 482 CRPC is equally available, my lord, to this honorable court while exercising the revisional jurisdiction, my lord. So therefore, my lord, the honorable Arun Single Judge, my lord, that was way back in 2005, my lord.
Recently, Supreme Court held that once conviction is confirmed, after that,
please, my lord. That
the same cannot be accepted even though parties have compromised the matter. 15 days back. 15 days back.
Please, my lord. That is, I will also. It's my duty to place those decisions also, my lord. I will place not to place those decisions, my lord. 2000 other
But
decisions.
here is a conviction only for section 3 and 4.
3 and 4.
3 and 4 of DP Act. I think 498 yeah, acquittal in this case.
Please. Because
504, 506 are acquittal.
Please, my lord.
Only section 3 and 4.
Yes. Gyan Singh's case, my lord, the exceptions are that the family matters, my lord, involving dowry cases is written. Dowry case is an exception to the general rule, my lord, where permission can be granted. Gyan Singh's, my lord, it speaks of dowry cases, my lord. Dowry.
That is in 482. What about in revision?
Now, my lord, I at this stage only I concede, my lord. We are not praying the honorable court exercise the regional jurisdiction. We are requesting the honorable court exercise 482, which is inherent for all the high courts, my lords. Whether the honorable court exercising the appellate jurisdiction or under for the jurisdiction of 397.
Whether revisional court by accepting the compromise between the parties can set aside the order of conviction and confirmed by the appellate court. That is the question now.
Please, I do agree, my lord.
Look into and make submission. If any judgment on the point, that then we'll consider it.
Please, if there is no judgment, I will request my lord to lay down, my lord. Now that my lord is
some support. There must be some support.
Please.
21.
Please, your lords may accommodate after 2-3 days, my lord. This week only.
Yes. Next week. Monday. Next Monday. You also examine whether the court can, in a revisional court can accept the compromise and acquit the accused. Next Monday, 7th of petitioner counsel seeks time. List this matter of 7th of March.
Please, my lord. Great.
Last time order sheet kodi. ಇವತ್ತು ಇಲ್ಲ ಮತ್ತೆ ಯಾವಾಗ್ಲೂ ಬರೋದೇ ಇಲ್ವಾ? As a last chance after that request agenda, request list after 2 weeks. So this matter is listed for admission and counsel repeatedly not appeared before the court. The order sheet also reveals that at the instance of petitioner, matter was adjourned on 24/9/21, 4/10/2021, again on 23/10/21. This court made it also again on 14/1/22, adjourn the matter and as a last chance, order to list this matter after 2 weeks. When the matter again listed after 2 weeks also, no representation. No representation. And this court also made an observation in the order. Petitioner counsel shall be present without fail on the next date of hearing, or otherwise the court will proceed to dispose of the matter in accordance with law. Having perused the order of the trial court, The proceedings was initiated against the petitioner for the offense punishable under section 138 of Negotiable Instrument Act. Petitioner alla complaint ಏನಾಯ್ತು? Against the petitioner alla by the petitioner against the respondent for the offense punishable under 138 of Negotiable Instrument Act. The trial court, after considering the material on record, convicted the respondent for the offense punishable under 138 of Negotiable Instrument Act and thereafter imposed fine of rupees 10 lakhs 2,000 and out of that 10 lakhs is payable in favor of the complainant. And 2,000 vest with the government. Being agreed by the said order, the respondent has filed an appeal in criminal appeal number 501 of 2016. The appellate court dismissed the appeal and confirmed the judgment of the trial court. Being agreed by the order, the complainant has referred this revision petition contending that the imposition of lesser penalty is both opposed to law and facts. The appellate court, while dismissing the prayer for enhancement, came to the conclusion that check has been issued for the purpose of security and also that amount was invested for the purpose of partnership. He further observes that the partners are abide by the terms and conditions of the partnership deed. Without the commencement of the commercial transaction, the accused cannot be penalized. The appellate court said to consider the case of the revision petitioner for enhancement of sentence. The counsel also vehemently contend that even though the check which was issued for security, some of the trial court categorically observed that the accused had the knowledge of presentation and the accused has given the consent to present the check. The reasoning given by the first appellate court for rejection of the enhancement of prayer is improper and without justification. The respondent is admittedly involved in several complaints of similar nature, and he is a habitual offender being involved in such offences. It also contend that the year of transaction relates to the year 2012. Some of the respondent having not paid the amount legally payable as rendered the complainant inexplicable loss, which remains redressed in no other manner. The appellate court has not even imposed the interest on such compensation amount awarded to the allegation. The amount paid to the accused in 2012, the complaint was filed in the year 2013. When failed to take note of the transaction of the year, and perusal of the material also that the transaction was taken place in the year 2012. The trial court, while passing the order of sentence. Yes, madam. Taken note of material on record, and record discloses that there was a transaction. And there are sufficient grounds to accept the guilt of accused. The check itself is for rupees 10 lakhs. No reasons are assigned by the accused for stoppage of payment. Thus, accused is found guilty and comes to the conclusion that in the ends of justice would meet if the check amount plus rupees 2,000 is ordered. Hence, imposed fine of rupees 10 lakh. Imposed and directed to pay an amount of rupees 10 lakh 2,000. The appellate court, while dismissing the appeal filed by the petitioner herein, for enhancement of the sentence also comes to the conclusion that the vital defense raised by the accused is that the investment is intended to be made for the proposed project and as security, the check was issued. Therefore, even though the liability is established as per admitted facts and documents, the endorsement given by the accused, it is apparent that project work initiated in partnership. Therefore, penalization of higher sentence doesn't in any way justifiable. The partners are obeyed by the terms and conditions of the partnership deed, and they have to bear the benefits and loss. Therefore, without being the beginning of the project, one cannot be penalized. More than the amount due under the instrument, as it is not initiated as commercial transaction, so as to raise any benefit unless the project is implemented. Hence comes to the conclusion that trial court is justified in imposing of fine and payment of compensation. Having taken note of the reasoning assigned by the trial court and also the appellate court, and the appellate court in paragraph number 19 considered the appeal filed by the petitioner applicant complainant hearing. And the reason is given that the very project is not implemented. And also project work was initiated in partnership and parties are liable for both benefits as well as loss. When such reasonings are given in paragraph 19 by the appellate court, considering the inadequate compensation and sentence ordered by the trial court, and having considered the factual aspects of the case and the liability arising between the parties, it is not a fit case to invoke the jurisdiction, invoke the revisional jurisdiction, and hence dismissed, and hence revision is dismissed. Now the discussion made of about petition is dismissed. Narasimha Murthy, order sheet padi. This matter is called twice, no representation. And this court also in the previous occasion noted that previous occasion on 11/2/2022 noted that no representation on behalf of the petitioner. In order to list this matter today, and in spite of no representation, in the ends of justice, one more opportunity is given. If the counsel doesn't appear in the next state of hearing, the matter will be disposed of in accordance with law. Is this matter on 14th? Heard this matter in part. This matter is called twice, and both the occasion respondent counsel is absent. However, on the ends of justice, one more opportunity is given. This matter on Thursday date, madam, third. 28. Yes, Sankarachar.
This matter both has commit the accused.
Concurrent finding.
Concurrent.
Have you deposited 50% of the amount?
Yes.
Where? Here or trial court?
Trial court.
Trial court.
Yes.
What is the error committed by both the courts in considering the material?
I'm seeking for a remand of the matter because defense of the accused he has not read the cross-examination.
Why he has not cross-examined the witness?
When counsel before the trial court, he has taken one suggestion from the 2W1 that no other payment from the no other payment except this check amount.
Why he has not been cross-examined, madam?
That is only merely error only because
what is the error? What is the error?
He has not taken.
Error by whom?
Trial court.
Trial court. Why trial?
Not trial court, my counsel of the trial.
Counsel. Then what court can do? Order sheet is here, trial court.
In the evidence matter, there is clear cut case that matter she don't know how much amount has given. One time she stayed there 7 lakh, one time.
Whatever it may be, madam. LCR admission matter.
Admission. Only based on that statement, Millard, in both the court as
at least you go to the evidence of the court.
Trial court evidence, yes.
Appellate court and reasons.
Based on that statement only, Millard, they have also confirmed the
cause of action have been run. On the other hand, the accused have hold. Thorough examination. Cross examination of PW. Only the cross examination PW has stated with exhibit.
We have taken all the contention.
Class
financial capacity no madidare. But here only one question that is Millard, except this check.
Answer to the question that she wants such a exorbitant money which she collected after she sold one vacant site. Cross examination is also done. Why matter has to be remanded?
Evidence because here Millard she don't know that how much amount she has given. One time she said that 5 lakh, another time is 7 lakh. Then after in the evidence, they have clearly taken that signature where is in the instrument in the exhibit P8.
Madam, while remanding, why court has to remand the matter? Why you are seeking for a remand?
Because here they are in the cross
And also
examination.
cross examination, you confronted the document exhibit D1 also. After
That is the
both of
sale deed.
exhibit D1 sale deed, as could be seen that husband of the complainant got sold one site bearing site number 859. The same site is one of the site have been carved in 7 numbers also. Sale deed as could be seen, exhibit D1 site number belong to husband of the complainant have been sold for a sum of 9 lakh. And they have sold the property and given the amount.
ಅವ್ರು ಯಾರ ಕಡೆಯಿಂದ ಕೊಟ್ಟಿದ್ದು ಅಂತ ಹೇಳಲ್ಲ ಸ್ವಾಮಿ, ಅವ್ರ ಹಸ್ಬೆಂಡ್ ನೇಮ್ ಇಂದ ಅದು ಸೇಲ್ ಆಗಿದೆ, ಹಸ್ಬೆಂಡ್ ನೇಮ್ ಇಂದ. ದಿಸ್ ಚೆಕ್ ಅಮೌಂಟ್ ವಾಸ್ ಗಿವನ್ ಬೈ ದಿ ವೈಫ್.
ಹೌದು, ವೈಫ್
ಸೌಭಾಗ್ಯ.
ಆಯ್ತು, ಗಂಡನ ಆಸ್ತಿ ಇಲ್ಲಿ ಮಾರಿದಾಗ ದುಡ್ಡು ಬಂದಿದ್ನ ಹೆಂಡತಿ ಕೊಡಬಾರ್ದು.
ಅಲ್ಲಿ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ, 7 lakh ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ, 2.5 ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ. She don't know how much amount has given Millard. ಈಗ ಆಮೇಲೆ ಇವ್ರು ಬಂದ್ಬಿಟ್ಟು they have taken specific contention.
For the law laid down by the Honorable Supreme Court, so and such permission includes the legally enforceable debt. On appreciation of entire evidence, this court of the opinion that accused has failed to prove the fact that he has not issued check for discharge of labor. So on the contrary, the complainant has proved that accused has issued check exhibit given for a sum of 2,40,000 towards discharge of legally enforceable debt. And on presentation of the check, also service legal total accused has not paid the amount. Considered that court complaint has proved so. Only 2,43,000.
ಹೌದು ಸರ್, ಬಟ್ ಅವ್ರ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಸ್ವಾಮಿ ಇವ್ರು ಕ್ರಾಸ್ ಮಾಡಿದಾಗ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ, ಒನ್ ಟೈಮ್ ಶಿ ಸೇಸ್ ದಟ್ 5 lakh ಅಂತ 7 lakh ಬರಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ.
But now check is given filed only for 2,43,000.
2,43,000. But in signature in the check also, Millard, we have questioned in the cross examination that was not taken. In last pair of the evidence is very clear that the document produced in exhibit B8 also some agreement of produced ಮಾಡಿದ್ದಾರೆ. In that also signature also there.
Have you led any evidence?
Evidence ಮಾಡಿ ಅದನ್ನ ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ಲ ಸರ್.
Why you have not led the evidence? You have not led any evidence. Why ನೀವು ಎವಿಡೆನ್ಸ್ ಮಾಡಿಲ್ಲ ಅಂತ ಮ್ಯಾಟರ್ ರಿಮೈಂಡ್ ಮಾಡ್ಬೇಕಾ?
ಏನಾಗಿದೆ ಅಂದ್ರೆ ಎವಿಡೆನ್ಸ್ ಅಂತಂದ್ರೆ ಸರ್ ಅಲ್ಲಿ ಅವರು ಸ್ಪೆಸಿಫಿಕ್ ಡಿಫೆನ್ಸ್ ಅದು ಒಂದು ಕೇಳಿದಾರೆ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಎಲ್ಲದನ್ನ ಅದರ್ ಕಂಟೆನ್ಷನ್ ದೇ ಹ್ಯಾವ್ ನಾಟ್ ಟೇಕನ್. In last pair of
the observation is very clear. Thus, the material placed on record clearly established that accused number 1 has failed to rebut the presumption arising in favor of complainant. On the contrary, suggestions made by the accused in the course of cross-examination probably that complainant is proved accused as a borrowed an amount of issued check. So complainant has complied all the provisions of 138. Hence, complainant has proved that the accused number 1 has committed an offence. No grounds, madam.
In the evidence, shall I read the evidence part, cross-examination part? Because they have taken only one part of that. Millard in the end, initially he has taken that counsel has taken the defense that Millard's signature is where is in the document, that is agreement. That is agreement. In agreementally, she is stating that Millard they only brought the papers and they only given the everything that are, but there is no signature of the accused.
But he has admitted the check issued to the
admit ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಸರ್, ಅದನ್ನ ಇಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ they specifically
admitted that he has issued the bank check and complainant has stated that when
and admitted means they have not taken the
accused number 1 has asked her to use one of the blank check by saying accused number 1 has permitted the complainant to fill up.
They are not disputed so far as they have taken admitted Millard. The cross examination li specific ಆಗಿ they have taken contention that Millard you have ತಗೊಂಡು ಹೋಗಿದ್ದೀರಿ ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ.
You have not led any evidence also, madam.
Shall I here?
Have you given any reply? No reply.
Taken contention that
no reply. Nothing.
Not received the legal notice at all, madam.
Personal acknowledgement card exhibit.
ಅದರಲ್ಲಿ ಅಲ್ಲ ಅಂತ ಹೇಳಿ ತಗೊಂಡಿದ್ದಾರೆ contention.
Mere taking of defense is not enough, and the acknowledgement is not.
Signature ಅಲ್ಲ specific.
Have you took that placed the sent that document to the handwriting expert?
ಅಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಸರ್, ಅದಕ್ಕೆ ಅವರದಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
Mere denial not enough. No grounds.
Because here, Millard, shall I read one para of that evidence cross examination?
You can read, madam. You can read.
Because Millard here are ಅವ್ರಿಗೆ you know that Millard there is no necessity of lending the money because the construction of the building is more.
Then you have to explain why you have given the check and all. You have to explain, but you are not given any. You have not led any evidence.
Shall I read the cross examination?
There is a presumption under section 139.
Shall I read the cross examination of the Shall I read the
You
class?
read, madam, read, madam.
Call for LCR, my lord, otherwise, my lord,
No,
because,
why we have to call for LCR?
because my lord, in cross examination, they have taken
Matter
specific.
is listed for admission, you make out a case now.
Yes, my lord. Shall I read that cross examination of the
Yes,
PW?
madam, yes.
I have the certificate copy of.
You can read.
From the first one, ಆರೋಪಿತರು ಕೊಟ್ಟಾಗಿನಿಂದ ವಿವಾದ ಚೆಕ್ ನನ್ನ ಹತ್ತಿರ ಇರುತ್ತದೆ. She has taken it. ಯಾವ ದಿನಾಂಕ, ತಿಂಗಳು ಮತ್ತು ವರ್ಷ ಎಂದು ವಿವಾಹಿತ ಚೆಕ್ ನನ್ನ ಹತ್ತಿರ ಇರುತ್ತದೆ ಎನ್ನುವುದು ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. ದೆನ್ ಕರಾರ ಪತ್ರವನ್ನು ಆರೋಪಿತರೇ ತೆಗೆದುಕೊಂಡು ನಮ್ಮ ಮನೆಗೆ ಬಂದಿದ್ದರು. ಆದರೆ ಯಾವ ದಿನಾಂಕದಂದು ಬಂದಿದ್ದರು ಎನ್ನುವುದು ನೆನಪಿಲ್ಲ. ಕರಾರ ಪತ್ರಕ್ಕೆ ಆರೋಪಿತರು ಹಾಗೂ ನಾನು ಸಹಿ ಮಾಡಿರುತ್ತೇವೆ. But there is no sign of ಸೌಭಾಗ್ಯ. ಸಹಿಗಳನ್ನು ನಮ್ಮ ಮನೆಯಲ್ಲಿ ಹಾಕಿರುತ್ತೇವೆ. ಎಷ್ಟು ಮುಖಬೆಲೆ ಬಾಂಡ್ ಪೇಪರ್ ಅನ್ನು ಆರೋಪಿತರು ತಂದಿದ್ದರು ಎಂದು ನೆನಪಿಲ್ಲ. ಕರಾರ ಪತ್ರದ ಜೊತೆಗೆ ಆರೋಪಿತರು ವಿವಾಹಿತ ಚೆಕ್ ಅನ್ನು ನೀಡಿರುತ್ತಾರೆ. ಆರೋಪಿತರು ಸಹಿ ಮಾಡಿದ ಖಾಲಿ ಚೆಕ್ ಅನ್ನು ನೀಡಿರುತ್ತಾರೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಕರಾರ ಪತ್ರದಲ್ಲಿ ಸಹಿ ಮಾಡಿದ ಖಾಲಿ ಚೆಕ್ ಗಳನ್ನು ನೀಡಿರುತ್ತಾರೆ ಎಂದು ಬರೆಯಲಾಗಿದೆ ಎಂದರೆ ಸರಿಯಲ್ಲ. ಕರಾರ ಪತ್ರದಲ್ಲಿ ಯಾರು ಸಾಕ್ಷಿಯಾಗಿ ಸಹಿ ಮಾಡಿರುತ್ತಾರೆ ಎನ್ನುವ ಪ್ರಶ್ನೆಗೆ ಸಾಕ್ಷಿದಾರರು ಕರಾರ ಪತ್ರವನ್ನು ಆರೋಪಿತರೇ ಬರೆದುಕೊಂಡು ಬಂದಿದ್ದರು. ಆ ಸಮಯದಲ್ಲಿ ನಾನು ಮತ್ತು ನನ್ನ ಗಂಡ ಮತ್ತು ಮಗ ಮನೆಯಲ್ಲಿ ಇದ್ದೆವು. ಕರಾರ ಪತ್ರಕ್ಕೆ ಸಾಕ್ಷಿಯಾಗಿ ಯಾರು ಸಹಿ ಆಗಿರುತ್ತಾರೆ ಎನ್ನುವುದು ಗೊತ್ತಿಲ್ಲ. ಎನ್ನ ಸೂಚನೆ ಸಾಕ್ಷಿದಾರರು ಆರೋಪಿತರೇ ಅದನ್ನು ಬರೆದುಕೊಂಡು ಬಂದಿದ್ದಾರೆ ಗೊತ್ತಿಲ್ಲ ಎಂದು ನುಡಿದಿರುತ್ತಾರೆ. ಕರಾರ ಪತ್ರವನ್ನು ಯಾರು ಬರೆದಿರುತ್ತಾರೆ ಎಂದು ಗೊತ್ತಿಲ್ಲ, ಯಾಕಂದ್ರೆ ಆರೋಪಿತರೇ ಅದನ್ನು ಬರೆದುಕೊಂಡು ಬಂದಿದ್ದರು. ಆರೋಪಿತರ ಕರಾರ ಪತ್ರವನ್ನು ಎಲ್ಲಿ ಮತ್ತು ಯಾರಿಂದ ಬರೆದುಕೊಂಡು ಬಂದಿರುತ್ತಾರೆ ಎನ್ನುವುದು ತಿಳಿದುಕೊಂಡು ಹೋಗಿಲ್ಲ. ಆರೋಪಿತರು ನೀಡುವ ಇನ್ನೊಂದು ಚೆಕ್ ಅನ್ನು ನ್ಯಾಯಾಲಯಕ್ಕೆ ನೀಡಲು ಯಾವುದೇ ತೊಂದರೆ ಇಲ್ಲ. ಅದು ಯಾವ ಬ್ಯಾಂಕಿಗೆ ಸೇರಿರುತ್ತದೆ ಎನ್ನುವುದು ನೆನಪಿಲ್ಲ. ಅದಕ್ಕೆ ಎರಡನೇ ಆರೋಪಿ ಸಹಿ ಹಾಕಿರುತ್ತಾರೆ. ಒಂದು ಚೆಕ್ಕಿನಲ್ಲಿ 2,42,000, ಇನ್ನೊಂದು ಚೆಕ್ಕಿನಲ್ಲಿ 2,50,000 ಬರೆದುಕೊಂಡಿರುತ್ತಾರೆ. ವಕೀಲರ ಹತ್ತಿರ ಇರುವ ಚೆಕ್ಕಿನಲ್ಲಿ 2,50,000 ರೂಪಾಯಿ ಬರೆದು ಕೊಟ್ಟಿರುತ್ತಾರೆ. ಆ ಚೆಕ್ ನ ಮೇಲೆ ಕಾನೂನು ಕ್ರಮ ತೆಗೆದುಕೊಂಡಿರುತ್ತೇನೆ. ಆ ಕೇಸ್ ನಂಬರ್ ಹೇಳಲು ಬರುವುದಿಲ್ಲ. There is no such case ಚೆಕ್ ಆಲ್ ಮೇಲೆ ಇಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಇಲ್ಲೇ ಚೆಕ್ ಇಲ್ಲ, ಅದಿಲ್ಲ, ಅದು ಸುಮ್ಮನೆ. ಆ ಕೇಸ್ ಯಾವ ನ್ಯಾಯದಲ್ಲಿ ಇದೆ ಎನ್ನುವುದು ಗೊತ್ತಿಲ್ಲ. ಆರೋಪಿತರಿಗೆ ಹಣ ಕೊಟ್ಟಾಗ ಯಾವುದೇ ರಸೀದಿ ಪಡೆದುಕೊಂಡಿರುವುದಿಲ್ಲ. ನಂಬಿಕೆ ಮೇಲೆ ಹಣವನ್ನು ಆರೋಪಿತಿಗೆ ನೀಡಿರುತ್ತೇನೆ. ಅದರಿಂದ ಹಣ ನೀಡಿದಕ್ಕೆ ಪತ್ರ ಬರೆದುಕೊಂಡಿರುವುದಿಲ್ಲ. ಕರಾರು ಪತ್ರದ ದಿನ ಅಂದರೆ ನಿಪಿ 8.
Even when you have disputed the source of income also for having made payment, even SP account also got marked. Passbook husband of the.
That is husband of the
property was sold.
ಅದು husband of the ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಇಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ಸ್ವಾಮಿ, ಅವ್ರು ಚೆಕ್ ಹೇಳ್ತಾರೆ, ಇದರಲ್ಲಿ ಕರೆಕ್ಟ್ ಆಗಿ ಕರಾರ ಪತ್ರ ಅವರಿಗೆ they have produced the document, that is one agreement. She don't know what is the agreement, my lord. There is the signature also. Our disputing the signature of that document. How they collected the document?
Yes, have one simple question. Have you sent the document, disputed document of agreement to handwriting expert, and also the notice which was served on you? There was a postal acknowledgement. Now you are disputing that that signature not belongs to you.
Yes.
Have you sent those documents to the handwriting expert?
Yeah, what happened, my lord, in the trial court, my lord, counsel has not taken the defense. That is only, they have taken only in the cross examination. They have not
whether for this court in sitting in revision petition can fill up the lacuna.
She has clear,
counsel,
he has clearly
the counsel who has not cross examined the witness or led any defense evidence under
they have taken
401 of CRPC, whether court can fill up the lacuna by remanding the matter.
My contention, your lordship, they have taken only one part of the cross examination. In other part, they have not taken. That is my contention, because they have taken only that, except this check, there you don't have any other amount balance from this accused. He suggested, my counsel has suggested. Then she said, madam, yes, except this, there is no other amount. There is no balance amount. Only on that ground, that same thing what the trial judge was taken that account, my lord. In other, except other contention, what they raised in before the cross examination, they are not at all taken. That is my contention, your lordship. When here, my lord, she is for every question she is that she don't know anything, my lord. In that, my lord, she specifically taken contention that, my lord, where you taken that agreement paper, where you is it any signature in that paper? She has agreed.
She has given an explanation that those documents, including agreement, was brought by the accused only.
Signature
ಬೇಕಾಗಿದ್ದವರಿಗೆ ಅದಕ್ಕೆ ಅವರೆಲ್ಲ ಮಾಡಿಸ್ಕೊಂಡು ತಗೊಂಡು ಬಂದಿದ್ರು.
ಇಲ್ಲ ಸರ್, ಸಿಗ್ನೇಚರ್ ನಂದಿದೆ ಅಂತ ಹೇಳ್ತಾರೆ ಅವರಲ್ಲಿ. ಬಟ್ ಇದರಲ್ಲಿ ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ, ಅವ್ರ ಸಿಗ್ನೇಚರೇ ಇಲ್ಲ. ನಮ್ಮವರು ಹೇಳ್ತಾರೆ ನಮ್ ಸಿಗ್ನೇಚರ್ ಅಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ. Then lastly they have taken contention that, my lord, they are the friends and they are used to come to home and all ಅಂತ ತಗೊಂಡಿದ್ದಾರೆ ನಮ್ಮವರು. ಆಗ ನೀವು ಚೀಟ್ ಮಾಡಿ ನೀವು ಅದನ್ನ ಕತ್ಕೊಂಡು ಹೋಗಿದ್ದೀರಿ ಪೇಪರ್ಸ್ ಅಂತ ಇವ್ರು ತಗೊಂಡಿದ್ದಾರೆ, ಕಂಟೆನ್ಷನ್ ತಗೊಂಡಿದ್ದಾರೆ. They have taken that contention also in that cross examination.
ಕಂಟೆನ್ಷನ್ ತಗೊಂಡ್ರು ಪ್ರೂವ್ ಮಾಡಬೇಕಲ್ವಾ?
ಅದನ್ನೇ ಸ್ವಾಮಿ, ಅವ್ರು ಏನಾಗಿದೆ ಅಂತ ಹೇಳಿ ಅವ್ರು ಎಲ್ಲದಕ್ಕೂ ಇವರು ಏನಾಗಿದೆ.
What prevented in you needing any defense evidence?
ಆಮೇಲೆ ಸ್ವಾಮಿ ಅವರು 2008 ಅಲ್ಲಿ ಸೇಲ್
You are
ಮಾಡಿದ್ರು.
not answering to my question, madam.
That I got it. But what happened, my lord, in that sale deed is the year 2008. Sale deed in the year 2008, your lordship. She has given the amount, she is stating that, my lord, in the 2009, July 2009.
But I have taken loan of rupees 2,43,000 and also issued the check. Apart from that, even
Check
sale
na issue ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
agreement- issue ಮಾಡಿಲ್ಲ madam, it contains your signature. ಹೌದಾ ಇಲ್ಲ? Have you disputed that signature also?
ಹೇಳಿದ್ವಿ ಸರ್ ಅದನ್ನ
ಏನಾಯ್ತು, ಏನ್ ಮಾಡಿದ್ರಿ ಹೇಳಿ? Bari denial is not enough. You are denying a check signature, agreement signature, and also the postal acknowledgement. All you are denying. What efforts you made to prove that? The person who asserts, he has to prove. That is your contention, that those signatures are not belongs to you. Burden shifts on whom?
That is only, my lord, but only in that contention, my lord, I didn't want to lead a evidence of the accused,
madam.
accused, and I have to seek for that, my lord.
Sorry, madam.
One more date, your lordship.
No
otherwise,
date,
my lord.
madam, no date. Heard the petitioner counsel and also the counsel appearing for the state. This matter is heard the counsel appearing for the petitioner and respondent, those served unrepresented and not engaged any counsel. The factual matters of the case of the prosecution is that the respondent has filed private complaint before the learned magistrate contending that accused number 1 and 2 are the husband and wife. They are well acquainted with the complainant. The accused number 1 and 2 have taken the hand loan of rupees 2,43,000 from the complainant on different dates for construction purpose. In this regard, on 28/4/2019, accused 1 and 2 have executed an agreement in favor of complainant. The complainant was in possession of an amount of rupees 12,50,000 as he has sold the house site, and also she was getting monthly rent of rupees 30,000. The accused, in order to discharge their liability, have issued 2 blank signed checks. And on presentation of those 2 checks, issued 2 checks, and the accused requested to present 1 check. And on presentation, the same was returned with an endorsement funds insufficient. And thereafter, legal notice was issued and the same was acknowledged and no reply was given. And hence complaint is filed and trial court also took the cognizance. And the accused oblique petitioner herein denied the very transaction. Petitioners denied the transaction. The complainant oblique respondent examined himself as PW1 and got marked to document exhibit P1 to 10, including the check, the signature found on the check, and also the bank endorsement, postal legal notice, postal receipt, UCP receipt, postal acknowledgement card, agreement, and signature of accused number 1, and also bank passbook to show that they were having the money to pay the amount. The PW1 was also effectively cross-examined by the accused and that confronted the document of exhibit D1, that is certified copy of sale deed. The petitioners herein have not laid any evidence before the trial court to rebut the case of the respondent. The trial court, while convicting the petitioners herein in paragraph number 18, taken note of the cross-examination of PW1, the accused counsel himself has suggested that the petitioners herein are responsible for payment of amount what has been mentioned in this particular check. And hence comes to the conclusion that the such suggestion itself is enough that accused number 1 admitted the claim of complainant. And apart from that, trial court also taken note of the fact that accused 1 has admitted that he has issued the blank check. And also amount is to the tune of rupees 2,43,000. Claims convicted the accused of being agreed by the said order of conviction and sentence, and appeal is filed by criminal appeal number 1297 of 2016. The appellate court also, having considered the material available on record from para 14 to 17, considering the material on record and appreciation of entire evidence, comes to the conclusion that the accused has failed to prove the fact that he has not issued the check for legality, for discharge of legally enforceable debt. The trial court and the appellate court also taken note of contents of exhibit P1. It also comes to the conclusion that no rebuttal evidence on the part of the petitioner's hearing. The counsel vehemently argued that the petitioners have disputed the very check and also the agreement and also the postal acknowledgement signature available on exhibit P8. In order to substantiate the contention and defense of the petitioner's hearing, they have not, first of all, they have not let any evidence, and also those documents which have been disputed, that is check as well as sale agreement, as well as agreement and postal identity card. Those documents are not sent for any exhibit piece, postal agreement, P7, P8 and P7, and not sent the same for any handwriting expert, except taking up the defense that those documents are not contains the signature of the petitioner's hearing. No doubt, PW1 has been cross-examined, and even in the absence of the leading of defense argument, defense evidence, the court can comes to the conclusion that there was no such transaction. But in the cross-examination, except eliciting certain aspect with regard to she is not aware of the stamp paper and purchasing of the stamp paper, but she has given the explanation that the petitioners herein before availing the loan amount, they came with agreement. That is exhibit P8. The complainant has given the explanation. And apart from that, when the PW1 was cross-examined with regard to source of income is concerned, the complainant relied upon the bank statement, wherein categorically they have stated that they have sold the property and they were having the money of 12,50,000. And explanation also given with regard to their amount and source of income also. And assessing the factual aspects and reasoning given. And the complainant also explained with regard to the source of income. And both the courts have taken note of the material available on record. This court also, invoking under section 2401 of CRPC, only on the contention of the revision petitioners that they have not let the evidence before the trial court, cannot remand the matter as contained by the petitioner counsel. And this court also cannot remand the matter to fill up the lacuna of the petitioner's hearing. When considering the factual aspects of the material, particularly the documents of check as well as agreement also produced before the trial court, it is not a case to exercise the powers of 401 of CRPC to reverse the finding of the trial court. And hence I do not have any so to allow the revision petition. We have the discussions made by Telangana. Just Murthy dear life. 40? 41. CM Jagdish and Veerabhadra Swamy.
I'm appearing for the
Rashid
petitioner
Kodi.
in this case, my lord. My lord, in this case, the appellate court, the trial court and the appellate court has convicted the petitioner for the offences punishable under section 498A of IPC for rigorous imprisonment for 3 years and fine amount of rupees 10,000, my lord. And also for the 506, the rigorous imprisonment for 2 years and to pay fine of rupees 10,000, my lord. The trial court has believed the PW2 evidence. On the basis of that, the trial court has ordered the sentence, my lord, to the petitioner. So, if we kindly go through the PW2 evidence, my lord. At page 46, my lord, the cross-examination of the PW2.
46.
Yes, my lord. Para 2, my lord. ಒಂದನೇ ಆರೋಪಿ ನನ್ನನ್ನು ನನ್ನ ತಂದೆಯ ಮನೆಯಿಂದ ಹಣ ತರುವಂತಾಗಲಿ ಅಥವಾ ಬೇರೆ ಏನನ್ನಾದರೂ ತರುವಂತೆ ಹೇಳಿರುವುದಿಲ್ಲ, ಆದರೆ ನನ್ನ ಗಂಡನ ತಂಗಿಯರು ಕೇಳಿರುತ್ತಾರೆ. So there is no dowry demand in this case, my lord. And
this revision by whom? Sisters or husband?
Husband, my lord.
Husband.
Yes, my lord. And at next page, my lord, para 3. In the 13th line of the para 3, my lord. ಗಲಾಟೆ ಆದಾಗ ನಾನು 4 ತಿಂಗಳ ಗರ್ಭಿಣಿಯಾಗಿದ್ದ ವಿಚಾರವನ್ನು ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿದ್ದೇನೆ. ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ
page 47 para
13 para 3, my lord. 13th
para 3 middle or in beginning?
Middle, my lord. 13th line, my lord.
ಗಲಾಟೆ ಆದಾಗ ನಾನು 4 ತಿಂಗಳ
ಗರ್ಭಿಣಿಯಾಗಿದ್ದ ವಿಚಾರವನ್ನು ನಾನು ಪೊಲೀಸರಿಗೆ ಹೇಳಿದ್ದೇನೆ. ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ದೂರನ್ನು ಕೊಡುವ 3 ದಿನದ ಹಿಂದೆ ಗರ್ಭಪಾತವಾಗಿದ್ದು ಎಂದು ಹೇಳಿರುವ ವಿಷಯ ಅಥವಾ ದೂರನ್ನು ಕೊಟ್ಟಾಗ 4 ತಿಂಗಳ ಗರ್ಭಿಣಿಯಾಗಿದ್ದೆ ಎಂದು ಹೇಳಿರುವುದು ಸರಿಯಾ ಎಂದರೆ 2 ಸಹ ಸರಿ.
ಸರಿ ಇರುತ್ತೆ.
2 ಸಹ ಸರಿ ಇರುತ್ತೆ ಅಂತ ಹೇಳ್ತಾರೆ, my lord. And in the complaint has given by the victim's mother, my lord. PW2 mother.
Yes.
In that complaint, she has narrated the different facts, my lord. But as well as in the statement, when it comes to the chief, my lord, there is a different story here. At page number 43, my lord.
43. 44. PW2.
Yes, my lord. 44. ಮದುವೆ ಆದಾಗ ನಂತರ ಪ್ಯಾರಾ 1, my lord. ಮದುವೆ ಆದ ನಂತರ ನಾನು ನನ್ನ ಗಂಡನ ಮನೆಯಲ್ಲಿ ವಾಸ ಇರಲು ಶುರು ಮಾಡಿದೆ. 1 ವರ್ಷ ನನ್ನನ್ನು ಚೆನ್ನಾಗಿ ನೋಡಿಕೊಂಡರು. ನಂತರ 2ನೇ ಮಗುವಿನ ಗರ್ಭಿಣಿಯಾದಾಗ ಇನ್ನೊಂದು ಮಗು ಹೆಣ್ಣು ಮಗು ಆಗುತ್ತದೆ ಎಂದು 3 ಜನ ಆರೋಪಿಗಳು ಸೇರಿ ಗರ್ಭಪಾತ ಮಾಡಿಸಿದರು. ಗರ್ಭಪಾತ ಮಾಡಿಸಿದ ನಂತರ ನನಗೆ ವಿಪರೀತ ಹೊಟ್ಟೆ ನೋವು ಬರುತ್ತಿತ್ತು. ನಾನು ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಲು ಕೇಳಿದಾಗ ಹಣ ಇಲ್ಲ ಎಂದು ಹೇಳಿ ಗಲಾಟೆ ಮಾಡಲು ಪ್ರಾರಂಭಿಸಿದರು. ಆಗ ಜಗಳ ಆಯಿತು. But in the complaint, Your Honor, they have not stated anything about regarding this issue, my lord. At page 48 also, my lord. ನನ್ನ ಗಂಡ ನನ್ನ ಬಾಯಿಗೆ ಚಪ್ಪಲಿ ಇಟ್ಟು ಗೋಧುಮಟ್ಟೆಯಿಂದ ನನಗೆ ಹೊಡೆದು ಎಂದು ಪೊಲೀಸರಿಗೆ ನಾನು ಹೇಳಿದ್ದೇನೆ. ನನ್ನ ಬಾಯಿಗೆ ಚಪ್ಪಲಿ ಇಟ್ಟು ಗೋಧುಮಟ್ಟೆಯಿಂದ ನನ್ನ ಗಂಡ ನನಗೆ ಯಾವ ದಿನ ಹೊಡೆದು ಎಂದು ದಿನಾಂಕವನ್ನು ಹೇಳಲು ಆಗುವುದಿಲ್ಲ. And this facts are not narrated in the complaint, my lord. And they have told that this incident has happened in the house of the accused petitioner, my lord. But she is stating that it has happened in the field, in the agricultural field. And the PW1 chief and the cross-examination and PW2 chief cross-examination and PW3-4 are all family members, my lord. PW1 is the mother of the victim, PW2, and the PW3 is the brother of the victim, and PW4 is the father. And there is a lot of improvements and very contradictory to each and every statements of these witnesses, my lord. And in the exhibit P4, my lord, in the medical certificate, it states that there is no tenderness over the right abdomen, shows mildly enlarged, opinion taken from the specialist Chelvamba Hospital. Opinion, no injuries found. This all the evidences has not been appreciated by the trial as well as the appellate court, my lord.
Yes. That's all?
Yes, my lord.
Yes, counsel.
PW 124, my lord, is the father, complainant, and brother and father of the my lord, complainant, my lord. They have fully supported the case of the prosecution. And my lord, PW 8 and 9, my lord, are the my lord, people who had conducted the panchayat regarding parallel with the complainant as well as the accused.
Who is Panchayat?
PW 8 and PW 9.
8 and 9. Panchayatdars.
Right, my lord. The lordship can see their
Evidence.
page number 44, my lord.
44. ಸಿದ್ದಪ್ಪ ಚೆನ್ನಾಗಿ ಬಾಡಿ ಎಂದು ಬುದ್ಧಿವಾದ ಹೇಳಿದ್ದೆವು. ನಾನು ಊರಿನ ಯಜಮಾನತ್ತೇನೆ, ಅವ್ರ ಮದುವೆ ಆದ ನಂತರ ಮಧ್ಯ ಜಗಳವಾಗುತ್ತಿತ್ತು. ಈ ವಿಷಯದಲ್ಲಿ ಪಂಚಾಯತಿ ಮಾಡಿದ್ದೆವು. ಸೋನ್ಸು ಈ ರೀತಿ 3 ಸಲ ಪಂಚಾಯತಿ ಮಾಡಿರುತ್ತೇವೆ.
PW 8, my lord. And PW 9, my lord, is the neighbor as well as my lord, the grandmother of the complainant, my lord. As evident at page number 46, my lord. Where she states, my lord, ಆಗ ಮನೆಯಲ್ಲಿದ್ದ ನಾನು ಸ್ಥಳಕ್ಕೆ ಹೋಗಿರುತ್ತೇನೆ. ಆಗ ಒಂದನೇ ಆರೋಪಿಯು ಎರಡರವರೆಗೂ ಕಾಲಿನಿಂದ ಇರುತ್ತಾನೆ. ಕಾಲಿನಿಂದ ತುಳಿದಾಗ ಶಾಸಕರವರಿಗೆ ರಕ್ತಸ್ರಾವವಾಗಿರುತ್ತದೆ. ನಂತರ ಆಕೆಯನ್ನು ಉಪಚರಿಸಿ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋದರು. My lord, and after 4 days, my lord, she had a miscarriage. And my lord, the evidence of the doctor, my lord. Page number 53.
Doctor.
Okay.
PW 12.
PW 12. ಅವ್ರು ಡಯಾಗ್ನೈಸ್ ಮಾಡಿರೋದು ಕೆಲವೊಂದೇ ಭಾಗದಲ್ಲಿ ಅದುಮಿದಾಗ ನೋವು ಕಂಡು ಬಂದಿರುತ್ತದೆ. ಅವರನ್ನು ಚೆಲುವಾಂಬ ಆಸ್ಪತ್ರೆಗೆ ಹೆಚ್ಚಿನ ಚಿಕಿತ್ಸೆಗಾಗಿ ಕಳುಹಿಸುತ್ತೇನೆ. ಚೆಲುವಾಂಬ ಆಸ್ಪತ್ರೆ ನಮ್ಮ ಆಸ್ಪತ್ರೆಯೇ ಒಂದು ಭಾಗ. ಸದರಿ ಗಾಯದ ಬಗ್ಗೆ ಒಳಗಾಯಗಳಾದರೂ ಇದೆ ಎಂದು ಶಂಕಿಸಿ ಸದರಿ ಆಸ್ಪತ್ರೆಗೆ ಕಳುಹಿಸಲಾಗಿರುತ್ತದೆ. ಯಾವುದೇ ವ್ಯಕ್ತಿಯನ್ನು ಕೈಗಳಿಂದ ಹೊಡೆದಾಗ ಅಥವಾ ಕಾಲುಗಳಿಂದ ಹೊಡೆದಾಗ ಗಾಯಗಳಾಗುವ ಸಾಧ್ಯತೆ ಇದೆ.
ಅಲ್ಲಿ ಸಾಧ್ಯತೆ ಇದೆ ಅಂತ ಹೇಳಿದ್ದಾರೆ my lord, but at 75 page top line ಅಲ್ಲಿ first
you wait for your turn reply.
Sorry.
ಮಾಡ್ತಾ ಇದ್ದಾಗ ನೀವು ಮಾಡುವಾಗ ಏನಾದ್ರು whether it poke the nose.
No.
My lord, P4 is the wound certificate. My lord, you should be the doctor.
P4 lower court records ಕೊಡಿ ಮೇಡಮ್. Tenderness over the right abdomen. Ultrasound report shows mildly enlarged.
The history, my lord, in the wound certificate, my lord, reflects the assault to be the husband.
Alleged assault by the husband at about 6 p.m. by kicking on her abdomen inside her residence. By that time she was pregnant. 4 months. ಇದು ಇನ್ಸಿಡೆಂಟ್ ಆಗಿದ್ದು ಯಾವತ್ತು? 6 p.m. on 16/12. ಇದು ಅಬಾರ್ಷನ್ ಆಗಿದ್ದು ಯಾವತ್ತು? 20th. 20th.
My lord, PW 124, my lord, are the family members, my lord. There, my lord, cooperated by Prince of PW 8, my lord, who is an independent witness.
8 and 9.
8, my lord. PW9, my lord, is the grandmother of
Grandmother.
grandmother. Even she is an eyewitness. My lord, doctor's evidence, my lord, PW12, my lord, also fully supports the case of the prosecution.
But now conviction is in respect of which offences?
My lord, 498A and 504.
504.
Okay.
506, my lord.
506. Any offence of 3 and 4? DP Act illa. Because he has pointed out that in the cross examination, no demand, only demand is by the sisters. That is in cross examination of PW2. 3 and 4 of DP Act.
Illa. Page number 19, my lord.
Right. Now, what is the reasoning to the trial court? Husband ಮೇಲೆ ಇದೆ, ಇವರಿಬ್ಬರ ಮೇಲೆ ಏನಿದೆ? ಇವರಿಬ್ಬರು ಅಕ್ವಿಟ್ ಅಲ್ಲ?
They were acquitted.
Acquitted. Only against husband. ಈ ಓನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಯಾವ 16-12 ಗೊತ್ತೇನಾ? No, 16-2. At 6 p.m. He assaulted. He was taken to hospital at 9 p.m.
The injury was suspected at the same time.
9 p.m. 9 p.m. on the 16-12. Avato same day.
Same day.
Yes, counsel reply.
My lord, PW9 cross examination bandra at page 66, my lord. Sorry, my lord, 68, my lord.
68.
Yes, my lord. ಗಲಾಟೆ ಆದ ದಿನ ನಾನು ಮನೆಯಲ್ಲಿ
68 ಆದ ಇಲ್ವಲ್ರಿ? ವಕಾಲತ್ತೆ 66.
PW9 cross examination, my lord.
PW9 ಹಾಕಿದೀರಾ? ಹಾಕಿದಿರಿ. PW9 not 68, 48 ಅಲ್ಲಿ ನೋಡಿ. PW9.
Yes, my lord. PW9 cross examination.
ಮಾದಮ್ಮ.
ಗಲಾಟೆ ಆದ ದಿನ ಗಲಾಟೆ ಆದ ದಿನ ನಾನು ಮನೆಯಲ್ಲೇ ಇದ್ದೆ. ನಾನು ಸ್ಥಳಕ್ಕೆ ಹೋಗುವಷ್ಟರಲ್ಲಿ ಗಲಾಟೆ ಮುಗಿದು ಹೋಗಿತ್ತು.
ಹೌದು.
ಹಂಗೆ ಅಗೇನ್ ಮೈ ಲಾರ್ಡ್, ಚಾಸ ಯಡೂರವರ 4th ಲೈನ್ ಮೈ ಲಾರ್ಡ್ ಇನ್ ದಟ್ ಸೇಮ್ ಪ್ಯಾರಾ. ಚಾಸ ಯಡೂರವರ ತಾಯಿಯ ಮನೆ ಮತ್ತು ನಮ್ಮ ಮನೆ ಬೇರೆ ಬೇರೆ ಕಡೆ ಇರುತ್ತದೆ ಎಂದರೆ ಸರಿ. ಚಾಸ ಎರಡರವರಿಗೂ ಆರೋಪಿಗೂ ಮದುವೆಯಾದ ನಂತರ ಆಕೆ ತವರು ಮನೆಗೆ ಹೋಗಿ ಬಂದು ಮಾಡುತ್ತಿರಲಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಚಾಸ 2 ಮದುವೆಯ ನಂತರ ನಮ್ಮ ಮನೆಗೆ ಬರುತ್ತಿರಲಿಲ್ಲವಾದ್ದರಿಂದ ಅವರ ಮನೆಯಲ್ಲಿ ಏನು ನಡೆಯುತ್ತಿತ್ತು ಎಂಬುದನ್ನು ಅವರು ನಮ್ಮ ಹತ್ತಿರ ಹೇಳಿರಲಿಲ್ಲ ಎಂದರೆ ಸರಿ. ಪಂಚಾಯತಿದಾರರನ್ನು ಸೇರಿಸಿ ನಂತರ ಆ ಮುಖಾಂತರ ಮದುವೆ ಮಾಡಿಕೊಂಡಿರುತ್ತಾರೆ ಎಂದರೆ ಸರಿ. The PW2 and the petitioner are the love marriage, my lord. And in that marriage, the parents of the PW2 were not attended on here, my lord. So there is no connection between the PW2 and their family members, my lord, for the 1.5 year. After this incident, they are in touch, my lord. And page number 69, my lord, the second line. ಗಲಾಟೆ ಆಯಿತು ಎಂದು ಹೇಳಲಾದ ದಿನಾಂಕಕ್ಕಿಂತ 1 ವಾರದ ಮೊದಲು ಚಾಸ 2 ನನ್ನ ಮಗಳ ಮನೆಗೆ ಬಂದಿದ್ದಳು ಎಂದರೆ ಸರಿ. ಆದರೆ ಆಗ ಸೇರಿಸಲಿಲ್ಲ. ಆಗ ಚಾಸ 2 4 ತಿಂಗಳ ಗರ್ಭಿಣಿ ಎಂದರೆ ಸರಿ. Before this incident, she was pregnant, my lord. But the PW2 in her cross examination, she has admitted that ನೀವು ಗರ್ಭಿಣಿ ಆಗಿದ್ದೀರಾ ಅಥವಾ ಗರ್ಭಪಾತ ಆಯ್ತಾ ಅಂದ್ರೆ ಎರಡು ಸಹ ಸರಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಅಂಡ್ ಅದು ಮೆಡಿಕಲ್ wound certificate ಅಲ್ಲೂ ಅವ್ರಿಗೆ ಅಬೋರ್ಷನ್ ಆಗಿರೋದು, and they have not mentioned anything regarding about the abortion, my lord.
ಅಬಾರ್ಷನ್ ಏನು ಅವ್ರ ಅಫೆನ್ಸ್ ಏನು ಮಾಡಿಲ್ಲ, ಇನ್ವೋಕ್ ಮಾಡಿಲ್ಲ. 312 312 is not invoked.
And 498
506 and 498.
Yes, my lord. But 498 ಅವರು ಇಷ್ಟು ಡೌರಿ ಡಿಮ್ಯಾಂಡ್ ಮಾಡ್ತಿದ್ರು, ಏನ್ ಡಿಮ್ಯಾಂಡ್ ಮಾಡ್ತಿದ್ರು ಅಂತ
498 ಡೌರಿ ಡಿಮ್ಯಾಂಡ್ ಬರೋದಿಲ್ರಿ, ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಸೆಕ್ಷನ್ 3 and 4. Section 3 and 4 ಮಾತ್ರ DP Act. Section 3 and 4 not invoked. You are arguing. What is the error committed by the appellate court in appreciation of evidence?
On the basis of the PW2 evidence, they have considered that this petitioner has committed the offences punishable under section 498 and 506. But it is very contradictory to, and there is a lot of improvements between the witnesses, my lord. The complaint and the witnesses states different. So the PW in the case of the PW 1 to 4 evidence also, there is a lot of corroboration and improvements they have made out, my lord. In the cross examination also, the PW2 has admitted that the petitioner has not made the alleged offences as alleged in the complaint, my lord.
Third, the petitioner counsel and also the counsel appearing for the state. The factual matters of the case of the prosecution that this petitioner, being the husband of the PW2, subjected the wife for both mental and physical cruelty without providing food and clothing, and also gave harassment both physically and mentally. It is also an allegation that on 16/27/2007 at about 5:30 p.m. this petitioner took her and assaulted and beaten her with his hands and also kicked on her abdomen. And also all the accused persons were threatened to kill her and thereby committed the alleged offences. The injured was taken to hospital where police have received the information through her mother and recorded the statement of witnesses. Rama conducted spot Panchanama and IO collected the wound certificate, and after the completion of investigation, she filed the charge sheet. The prosecution, in order to prove the case against the petitioner and other two accused persons who have been arraigned, relied upon the evidence of PW 1 to 15 and also document exhibit P1 to P5. And defense have not led any defense evidence. The trial court, having appreciated both oral and documentary evidence, convicted the present petitioner and acquitted accused number 2 and 3 and sentenced to undergo rigorous imprisonment for 3 years and to pay a fine of ₹10,000. In default, to undergo 6 months simple imprisonment for offence punishment 498 of IPC. He was further sentenced to undergo imprisonment for 2 years and to pay a fine of ₹10,000 in default. Undergo 6 months imprisonment for offence punishment 506 of IPC. Both the sentences are run concurrently. Being agreed by the said judgment of conviction and sentence, an appeal is filed in criminal appeal number 136 of 2027. The appellate court also, on reappreciation of evidence by the order dated 22nd day of March 2012, dismissed the appeal, coming to the conclusion that judgment of the trial court and conviction not requires any interference. Being agreed by the said judgment of conviction and sentence and also confirmation, the present appeal is filed by the division petitioner. The main contention of the petitioner counsel that both the courts have failed to consider contradictions in the evidence of particularly PW 1 to 3 and PW 9. The evidence of PW 1 to 4 have clearly revealed that marriage of the petitioner with PW 2 was a love marriage. PW 1, 3 and 4 and other relatives have not attended the marriage. And thereafter, petitioner was living with PW 2 in his house. The witnesses have not visited the house of the petitioner till the alleged incident on 16/12/2007. The trial court and also appellate court accepted the evidence of PW2 regarding Panchayat was held. And the PW9 is none other than the grandmother of PW2. And in her cross-examination, she categorically admitted that a week prior of the alleged incident on 16/12/2007, PW2 came to the house of her parents. And at that time, she was 4 months pregnant. The PW2 has introduced totally a new story in the trial. And she has made lot of improvements in her evidence, contradictory to the prosecution case. And both the courts failed to consider the same and erroneously convicted and confirmed the same. The council also submits that PW1 is the mother and PW2 is the, according to the prosecution, victim, and PW3 is the brother and PW4 is the father of the victim. And there are a lot of contradictions and they are the relative witnesses and their evidence not corroborated by any of the witnesses. Per contra, the council appearing for the state would submit that the incident was taken place at 6 p.m. in the house of this petitioner on 16/12/2007. And within a span of 2-3 hours, the victim went to hospital and given the history, stating that this petitioner kicked on her abdomen. As a result, miscarriage was taken place. The council also submit that in wound certificate, a specific mentioning is made regarding injury caused to her. And within a span of abortion ಯಾವಾಗ್ರಿ?
My lord, page number 17, my lord. ಇದರಲ್ಲಿ ಇದು 4 days before the assault abortion ಆಗಿತ್ತು ಅಂತ ಡಾಕ್ಟರ್ ಆಫ್ಟರ್
ಅದು ಆಫ್ಟರ್ ಅಲ್ಲ ಅದು.
Sorry, my lord, kicking her within 3 days of
caused to the victim. The council also would submit that PW8 is an independent witness who was the part of Panchayat. And PW9 is the grandmother. She also witnessed the incident. The doctor PW12 who has been examined, spoken regarding the assault is concerned. Having heard the respective counsel and also on perusal of material available at record, the point that would arise for the consideration of this court are whether both the courts have committed an error in not considering the material on record and passed any perverse order, and order passed by both the courts are suffers from legality and propriety of the order. Having heard the respective counsel and also on perusal of material, I have already pointed out that prosecution, in order to prove the guilt of the petitioner herein, relied upon the evidence of PW1 to 15 and documents exhibit P1 to 5. The defense has not led any evidence. On perusal of the evidence available on record, particularly PW1 to 4, no doubt they are the relatives, mother, father, brother, and victim. The court has to take note of the incident of assault. According to the prosecution, incident was taken place on 16/12/2007, that too at 6 p.m. The victim PW2 in her evidence categorically deposed that this petitioner looked after her very well for a period of 1 year. And when she became pregnant for second child, she was subjected to both mental and physical assault. As a result, got pregnancy aborted. When she was suffering from severe stomach on account of abortion, when she requested them to take her to doctor, instead of taking her to doctor, this petitioner kicked on her stomach. Within 3 days of the abortion of pregnancy. She was subjected to cross-examination, and in the cross-examination, as pointed out by the counsel appearing for the revision petitioner, no doubt it is elicited in the cross-examination that this petitioner not subjected for every harassment. And also it is elicited that prior to the marriage, both of them fell in love, and panchayat was held and marriage was performed. She also admits that her parents and brother were not interested in performing the marriage of the PW2 with this petitioner. In the cross-examination, it is illustrated that at the time of giving complaint, and also in his chief evidence, he has stated that moved 3 days prior to the incident, as he was aborted, and she was subjected to assault subsequent to the abortion. It is also illustrated that she cannot tell on what date her husband put chappal on her mouth and assaulted with coconut shell. And the said fact also not informed to her parents. But she claims that the same was informed to the elders of the village, but she cannot tell the date. Other than the witness of PW2, PW1 is the mother, and PW3 is the brother, and PW4 is the father. The prosecution mainly relies upon the evidence of PW8 and 9. The PW8, in his evidence, he says that he is the elder of the village, and subsequent to the marriage, frequent galata was taking place, and he was the part of panchayat, and they have advised not to quarrel each other, and they should lead with life. PW8 says that he was the part of panchayat 3 times. In the cross-examination, he admits that he cannot tell on what date panchayat was held, but claims that PW2 family members have told him to make panchayat. It is suggested that he was not the part of panchayat, and the same was denied. The PW9 is the grandmother of the PW2. And in the and also she reveals that the incident was taken place and this petitioner assaulted as kicked on her stomach. But in the cross-examination, she admits that she was in the house, and when she went to house spot, already galata was over. and admits that PW2 is her granddaughter. PW9 also admits that panchayat was held prior to the marriage and marriage was performed after the panchayat only. It is suggested that after the marriage no panchayat was held and the same was denied. But she cannot tell on what dates panchayats were held. But she claims that panchayats were held 5 times. The prosecution also mainly relies upon the evidence of Dr. PW12. And he gave the wound certificate in terms of exhibit P4. And also on examination, he found pain in the lower part of the abdomen and referred the patient to go to Cheluvamba Hospital. And in any person assaults with hand and kicks on the abdomen, the injuries mentioned in the wound certificate will suffer. In the cross-examination, a suggestion was made that if any person falls on the hard surface, this type of injuries could be caused. So prosecution examined PW14. He is an IO who conducted the investigation and filed the report. Having heard the respective counsel and also on perusal of material and also on appreciation of material available on record by the both trial court as well as the appellate court, and also in keeping the contentions of the revision petitioner before this court, the trial court in paragraph number 11 and 12, and also taking into note of the injuries mentioned in exhibit P4, and there was no any delay in taking her to hospital, and on the same day she was taken to hospital within 3 hours. And medical support evidence also supports the case of the prosecution. And doctor who has deposed as PW12 also reiterates that on kicking the stomach, the said injury could be caused. And no doubt in the cross examination, it is illustrated that if a person falls on the hard surface, the said type of injury could be caused. But court has to take note of the history given in exhibit P4 wound certificate, and also taking into note of the injured was taken to hospital within a span of 3 years, 3 months, 3 hours of the said incident, and also take note of nature of injuries mentioned in exhibit P4, and medical evidence also corroborates the evidence of PW 1 to 4. In the cross examination of PW4, nothing is illustrated, and the same has been considered by the trial court in paragraph number, particularly the evidence of PW2 in paragraph number 13, and also in paragraph number 23, evidence of the doctor, and also in paragraph number 20, the evidence of PW8, who is the panchayat member who participated in the panchayat subsequent to the differences arises between the petitioner as well as his wife, and rightly comes to the conclusion that the prosecution has proved the case against the petitioner hearing. The appellate court also, on reappreciation of evidence, taken note of the evidence of PW2 and discussed in paragraph number 14 that she was subjected to assault, and mainly also comes to the conclusion that the evidence of PW8 corroborates the prosecution version. In paragraph number 11 discussed the same, and in paragraph number 10 also reappreciate the evidence of PW8, who is the panchayat bar, regarding subjecting the PW2 for cruelty and harassment. And also he categorically says that they have advised both the parties to live happily. In spite of it, the same was continued. The PW5 also spoken with regard to dragging the PW2 out of the house to the street. That is 1.5 years back. The trial, the appellate court on reappreciation of evidence available on record in paragraph number 23, 24, 25. Taken note of the evidence of prosecution corroborating each other, subjecting her for both cruelty and for causing life threat, and also taken note of the punishment and sentence awarded by the trial court. And having considered the same, comes to the conclusion that there are no grounds to interfere with the orders of the trial court. Having heard the respective counsel and also the reasoning given by the trial court and the very contention of petitioner counsel that there are contradictions in the evidence of PW 1 to 4 as well as PW 8 and 9. An incident was taken place on 16/12/2007 and witnesses were examined in 2009 after lapse of 2 years. When suspecting the case, the minimum contradictions bound to happen. And the contradictions which have been elicited from the mouth of the witnesses not goes to the very root of the prosecution case. Apart from the evidence of PW2, PW8, who is an independent witness, supports the case of the prosecution. And though the PW1, 3, and 4 are the relatives, and PW9 is the grandmother, and medical evidence corroborates with the oral testimony of PW2. And when suspecting the case, and when there is no any infirmity in appreciation of oral and documentary evidence by both the trial court as well as the appellate court. And the scope of revision is very limited, and only this court can reverse the finding of the trial court as well as the appellate court when the findings are perverse. And I do not find any such perverse, and orders also not suffers from any illegality and propriety of the order. And when such being the case, it is not a fit case to allow the revision petition and to set aside the order of conviction and sentence. We have the discussions made up, I pass the following order. Revision petition is dismissed. Shankarappa and Associates. Yes, Shankarappa and Associates. So this matter is called first time alla, no representation. Earlier ಏನಾಗಿದೆ ನೋಡಿ ಈ ಜನವರಿ ಅಲ್ಲ ಅವತ್ತಿದ್ರು ಅವರು. And hence one more opportunity is given to the revision petitioner counsel. This matter on 14th March. N ಸುರೇಶ ಏನಾಗಿದೆ ನೋಡಿ ಅದು. Petitioner counsel is absent. Issue notice.
No, showcase notice to the revision petition.
Showcase notice. Interest in prosecuting the matter. ಅದಕ್ಕೆ ಶೋಕಾಸ್ ನೋಟಿಸ್ ಏನಾಯ್ತು? ಶೋಕಾಸ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಆಯ್ತಾ? ನೋಡಿ ಮೇಡಮ್, petitioner counsel is absent on 8/10/21. And also this court made an observation that petitioner has not shown any interest in prosecuting the matter. And matter is pending since 2012. ಏನಾಗಿದೆ ಶೋಕಾಸ್ ನೋಟಿಸ್? However, ordered to list this matter after 3 weeks. Today also no representation. And revision petitioner is not pursuing the matter. And this court also issued show cause notice against the revision petitioner. And the same was also served on 22/10/21. And today also the either the petitioner, revision petitioner or counsel not pursuing the matter. Hence, post this matter on 14th March. If counsel doesn't appear, matter will be proceeded disposed in accordance with law. 44. Ex Lakshmi Narayana. Vijay Krishna Bhatt for R2. Both the counsel absent. HCGP is present. Here HCGP ಇದ್ದಂಗಿಲ್ಲ. Vijay Krishna Bhatt. Serial number 44 ಇಲ್ಲಲ್ಲ, ಯಾವುದು ಪ್ರೈವೇಟ್ ಮ್ಯಾಟರ್ಸ್ ಇದ್ದಾಗಿದೆ. R1 is deleted ಅಂತಿದೆಯಲ್ಲ. The counsel repeatedly not appearing before the court. However, one more opportunity is given. If the counsel doesn't appear, matter will be considered on merits in his absence. This matter on 14th March. HV Manjunath. VS Biju. ಏನು ಯಾರು ರಿವಿಷನ್ ಪಿಟಿಷನ್ಸ್ ಯಾರು ಬರೋದೇ ಇಲ್ಲ, ಎಲ್ಲ ಹಳೆ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಯಾರು ಬರೋದೇ ಇಲ್ಲ. ಓನ್ಲಿ ಫಾರ್ ಸ್ಟೇ, ಓನ್ಲಿ ಫಾರ್ ಸಸ್ಪೆನ್ಷನ್ ಆಫ್ ಸೆಂಟೆನ್ಸ್. ಸತ್ಯ ಹೇಳ್ಬಿಟ್ರೆ ಎಲ್ಲರಿಗೂ ಸಿಟ್ಟು ಬಂದ್ಬಿಡುತ್ತೆ. ನನ್ ಅಪಿಯರ್ಸ್ ಫಾರ್ ಬೋತ್ ಸೈಡ್ಸ್. ನೋಡಿ, this matter is continuously listed from 21, and petitioner counsel as well as respondent counsel are absent. However, ordered to list the matter next week. And when the matter is also listed on 13/1/22, no representation by both the sides. List this matter on 14th. If counsel doesn't appear, matter will be heard their absence. And matter will be disposed of in their absence. 47. None present on behalf of the revision committee, even in the second round of calling. Told both the occasion on 18/12/21 as well as 22/12/21, none appears. However, order to relist this matter. ಏನಾಯ್ತು ಮೇಡಮ್? ಆರ್ಡರ್ ಇಲ್ವಲ್ಲ? ಇದೆ 22/12 ಇದೇನೆ. 10/1 ಅಂತಿದೆ. 10/1 ಅಲ್ಲಿ ಲಿಸ್ಟ್ ಮಾಡಿಲ್ವಾ? 10/1 ಏನಾಯ್ತು? ಡೇಟ್ ಕೊಟ್ಟ ಮ್ಯಾಟರ್ ಯಾಕೆ ಲಿಸ್ಟ್ ಮಾಡಿಲ್ಲ? ಏನಾಗಿದೆ? 10/1 ಇಂದ 11/1. ಆಯ್ತು. On 11/1/2022, again petitioner counsel sought time. No representation today. List this matter on 14th March. Hemant Raj. Chema. ನಾವು ಕೂತ್ಕೊಂಡು ಬರೀ ಡೇಟ್ ಕೊಡೋದ ಮೇಡಮ್? No representation for the revision petitioner. Told. When this is the matter of the year 2013. No representation by the petitioner counsel. Whenever matter is listed for final hearing, and it appears the petitioner, revision petitioner counsel is not interested in pursuing the matter. List this matter on 14th March. ಕೆಂಪರಾಜು ಕೊಟ್ಟಿದ್ದಾರೆ. ರಾಜೇಶ್ವರ PN ಕೊಡಿ. ಇದೇ ಇನ್ ಮಾಡ್ಬಿಟ್ರಿ, ಯಾರಿಗೆ ಇಂಟ್ರೆಸ್ಟ್ ಇದೆಯೋ ಅವ್ರು ಬರ್ಲಿ, ಯಾರು ಹಾಕ್ತಾರೋ ಮೆಮೋ ಬೋತ್ ಸೈಡ್ಸ್. ಬಟ್ ನಾ ಸುಮ್ಮನೆ ಕರ್ಸ್ಕೊಂಡು ಡೇಟ್ ಕೊಡೋದು ಯಾಕೆ ಈ ಕೆಲಸ? ಅದಕ್ಕ ವೆದರ್ ಹೈಕೋರ್ಟ್ ಜಡ್ಜ್ ಇಸ್ ಮೆಂಟ್ ಫಾರ್ ದಟ್. ಬೋತ್ ಸೈಡ್ಸ್ ಯಾರು ಬರ್ತಾರೋ ಕೇಳ್ಕೊಬಿಡೋಣ. ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks at the request of the counsel for petitioner. ಎಲ್ಲ ಸ್ಟೇ ಎಲ್ಲ ವೆಕೇಟ್ ಮಾಡ್ಬೋಣ. ಯಾವ್ದಾರು ಸ್ಟೇ ಇದೆಯಾ? ಬೆಟರ್ ನೋಡ್ಬಿಡಿ, ನಾಳೆಯಿಂದ ನೋಡ್ಕೊಬಿಡಿ. ಯಾವ್ದಾರು ಸ್ಟೇ ಇದ್ರೆ ವೆಕೇಟ್ ಮಾಡೋಣ. ಕೌನ್ಸಿಲ್ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ವೆಕೇಟ್ ಮಾಡೋಣ. ಅಂಡ್ ದೆನ್ ಆಲ್ ವಿಲ್ ರಶ್ ಟು ದಿ ಕೋರ್ಟ್. ಒಂದ್ 30 ಹಾಕ್ಸಿ ಡೈಲಿ ನೋಡ್ಕೊಬಿಡಿ. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಯಾವ್ದ್ರಲ್ಲಿ ಇದೆ ಎಲ್ಲ ವೆಕೇಟ್ ಮಾಡೋಣ. ಅವಾಗ ಕೊಡ್ತಾರೆ. ಮತ್ತೆ ಇಷ್ಟೊತ್ತಾರ ಬರ್ರಿ. 4 ಗಂಟೆ ಆದ್ರೂ ಯಾರು ಬರೋದಿಲ್ಲ ಲಾಯರ್ಗಳು ಅಂತಂದ್ರೆ. ಪ್ಲೀಸ್ ರಾಜೇಶ್ವರ ಮಾಡ್ತೀರಾ? ನಿಮ್ದೇನೆ ಮ್ಯಾಟ್ರು. 52 ಪ್ರಸನ್ನ ಕುಮಾರ್. ಹೇಳಿ.
The court below, my lord, I have not received any notice before the court below, my lord. I am working as a junior assistant PWSSP. Matrimonial dispute, my lord. I have no notice. My lord, expert order has been passed, awarding my lord 1,000 rupees each. My lord, your lordship may please tell the order, my lord, operative portion of the order at page 19, my lord. 19. Please, my lord. ಈ ಅರ್ಜಿ ಸಲ್ಲಿಸಿದ ದಿನದಿಂದ ಮನೆಯ ಬಾಡಿಗೆ ಬಾಬ್ತು ಸೇರಿ ಅರ್ಜಿದಾರ ಜೀವನೋಪಾಯ ಮಾಸಿಕ 1,000 ರೂಪಾಯಿ. ಅರ್ಜಿದಾರ ಇಬ್ಬರು ಮಕ್ಕಳ ವಿವಾಹವಾಗುವವರೆಗೂ ಅವರ ಜೀವನ ಉದ್ಯೋಗ ಮಾಸಿಕ ತಲಾ 1,000 ರೂಪಾಯಿಗಳಂತೆ ಒಟ್ಟು 3,000 ರೂಪಾಯಿ ಮಾನಿಟರಿ ರಿಲೀಫ್ ನೀಡುವಂತೆ ಎದುರುವಿರುವುದರಿಂದ ಆದೇಶಿಸಿದೆ. This order, my lord, passed expert. I have no notice has been served on me, my lord. Then the respondent again filed a miscellaneous appeal before the first appellate court, my lord, sessions court. For that, my lord, I have taken the defense. I have no notice has been served and no opportunity has given to the petitioner, and requested the court for my lord setting aside and remanded back to the lower court, my lord. The honorable court rejected my request, and my lord order for 3,000 instead of 1,000 rupees for maintenance of children. 3,000 rupees has been awarded, my lord. 3,000 each, my lord. It comes around, my lord. After deduction, I am.
That is also by appeal by
the respondent.
Respondent. You have not filed any appeal.
I have not, my lord, preferred.
Now you can contend that no service of summons served on the petitioner.
Only appellate court notice has been served, my lord. Trial court notice I have not.
Trial court order na ನೀವೇನಾದ್ರು challenge ಮಾಡಿದ್ರಾ? No notice has been served on me. Now you cannot raise that.
My lord, reason is this, my lord.
ಹೇಳಿ.
This is the, my lord, this is the NOC brief I have received.
ಯಾವ brief ಆದ್ರೂ ಅಷ್ಟೇ, NOC ಆದ್ರೂ ಅಷ್ಟೇ, ಯಾರಾದ್ರೂ ಅಷ್ಟೇ.
Please, my lord, I request, my lord.
First of all, you have not filed any appeal
against
the order passed by the magistrate.
My lord, I request.
She only filed an appeal stating that the amount of compulsory maintenance awarded is very low. In that awarded. ಈಗ ಎಷ್ಟಾಗಿದೆ? 9,000.
ಈಗ ಟೋಟಲ್ ಅಲ್ಲ, ಅವ್ರಿಗೆ ಚಿಲ್ಡ್ರನ್ಸ್ ಗೆ 3,000 ಇರೋದು. ಆಕೆಗೆ my lord 1,000. ಅವರಿಗೆ 1,000 ರೂಪಾಯಿ, ಅವರಿಗೆ 3 ಜನಕ್ಕೂ 3,000 ರೂಪಾಯಿ ಮಾಡಿ ಈಗ ಟೋಟಲಿ my lord 12,000 rupees ಬರ್ತದೆ.
7,000 ಕೊಡ್ಬೇಕು.
3 9 3 12,000.
ಹೆಂಗ್ರಿ? ಮಕ್ಕಳಷ್ಟು 3 ಇದಾರ.
my lord ಇಬ್ರು
ಆಕೆಗೆ ಎಷ್ಟು?
ಟೋಟಲ್ 9,000.
3,000
ಈಚ್. 3 6
9,000 ಆಗುತ್ತೆ.
9,000 ಆಗುತ್ತೆ. ನನಗೆ ಏನಾಗುತ್ತೆ, ಓಲ್ಡ್ ಏಜ್ ತಂದೆ ತಾಯಿ ಇದೆ, ಮತ್ತೆ ನನಗೆ ಬರೋದು 20, ಎಲ್ಲ ಡಿಡಕ್ಷನ್ ಆಗಿ ಬರೋದು 20,000.
ಟೋಟಲ್ ಸ್ಯಾಲರಿ ಎಷ್ಟು?
ಟೋಟಲ್ 25,000 ರೂಪಾಯಿ.
ಎಲ್ಲಿ ಕೆಲಸ ಮಾಡೋದಿಲ್ಲ?
ನಾನು PWC ಜೂನಿಯರ್ ಅಷ್ಟೇ, ಜೂನಿಯರ್ ಇದು ಜೂನಿಯರ್ ಅಟೆಂಡರ್ಸ್. ಅಟೆಂಡರ್ ಬರೋದು ಬಹಳ ಕಡಿಮೆ. ಬರೋದು ಎಲ್ಲ ಡಿಡಕ್ಷನ್ ಆಗಿ 18,000 ರೂಪಾಯಿ ಬರುತ್ತೆ. ಅದ್ರಲ್ಲಿ 80% ಅಪ್ಪಿಗೆ ಹೋಗ್ಬಿಟ್ರೆ ಅಲ್ಲ, ನನಗೆ ಎವ್ರಿ ಡೇ ಮೇಂಟೆನೆನ್ಸ್ ಗೆ 15,000.
ಇಬ್ರು ಮಕ್ಳು ಮಾಡ್ಕೊಂಡು ನನಗೆ ಈಗ ಕೊಡಕ್ಕಾಗಲ್ಲ.
ನನಗೆ
ಆಯ್ತು 3,000ದಲ್ಲಿ ಇವತ್ತು ಒಬ್ರು ಬದುಕಕ್ಕಾಗುತ್ತಾ?
ಅಲ್ಲ ಅದೆಲ್ಲ ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ, ಬದುಕೋದಕ್ಕೆ ಅಂತಲ್ಲ. ನನಗೆ ಏನು ಅಂದ್ರೆ ಅಲ್ಲ ಕೋರ್ಟ್ ಬಿಲ್ ಏನ್ ಮಾಡಿತ್ತಲ್ಲ 1000 rupees ಈಚೆ, ಯಾಕಂದ್ರೆ ಎವ್ರಿ ಮಂತ್.
ಓ 1000 ರೂಪಾಯಿ.
ಅಲ್ಲ
ನಾವೊಂದ್ 10 ಮಕ್ಳು ಕೊಡ್ತೀವಿ, ಸಾಕ್ತಾರೆ 1000 ರೂಪಾಯಿ.
ತಂದೆ ನನಗೆ ವಯಸ್ಸಾಗಿರೋ ತಂದೆ ತಾಯಿ
ತಂದೆ ತಾಯಿ ಇದ್ರೆ ಹೆಂಡತಿ ಮಕ್ಳನ್ನ ಯಾಕೆ
ಅಲ್ಲ
ಮಾಡ್ತೀವಿ?
ಇಲ್ಲ ಆತರ ನಾನು ಇವತ್ತು ರೆಡಿ ನೋಡ್ಕೊಳಕ್ ಇವತ್ತು ರೆಡಿ ಇದೆ.
ಆಯ್ತು, ವಿಸಿಟ್ ಎ ಗ್ರೌಂಡ್ ಫಾರ್. ಅಲ್ಲರಿ ನಿಮ್ಗೆ ಮುಪ್ಪಿಗೆ ಬಂದಿರೋ ತಂದೆ ತಾಯಿ ಮೇಲೆ ಅಷ್ಟೊಂದು ಪ್ರೀತಿ, ಹೆಂಡತಿ ಮಕ್ಳ ಮೇಲೆ
ಅದೇ ಇದೆ ಇಲ್ಲ ಅಂತಲ್ಲ, ನಾವು ಇವತ್ತು ನೋಡ್ಕೊಳಕ್ ರೆಡಿ ಇದ್ದೀವಿ. ಅಷ್ಟು ಅಮೌಂಟ್ಗಳು ನನಗೆ ಅವಾಯ್ಡ್ ಮಾಡ್ಬಿಟ್ಟು ಇವೇರಿ ಮಂತ್ಸ್ ಅಲ್ಲ ಯಾಕಂತಂದ್ರೆ ಅಲ್ಲ
ನೋ ಗ್ರೌಂಡ್ಸ್. ಅವ್ರದ್ದು ಏನಾದ್ರು ಪಿಟಿಷನ್ ಇದ್ರೆ ನಾನೇ ಅನೌನ್ಸ್ ಮಾಡ್ತಾ ಇದ್ದೆ. 3000 ರೂಪಾಯಿ ಹೆಂಗ್ರಿ ಜೀವನ ಮಾಡ?
ಅಲ್ಲ 3000 ಈಚ್ 3000.
ಹೌದ್ರಿ, ಅದೇ ಹೇಳ್ತಾ ಇರೋದು. 3000 ರೂಪಾಯಿನಲ್ಲಿ ಒಬ್ರು ಒಂದ್ ಮಗುಗೆ ಸ್ಕೂಲ್ ಫೀ ಎಲ್ಲಾ ಕಟ್ಕೊಂಡು ಮೇಂಟೈನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ.
ಅಲ್ಲ ಅದನ್ನ
ಮಕ್ಳು ಹುಡ್ಸ್ಬಿಟ್ಟು ಬೀದಿ ಬಿಟ್ರು ಸಾಲದ, ಎಜುಕೇಶನ್ ಕೊಡ್ಸ್ಬೇಕು.
ನಾವು ರೆಡಿ ಇದೀವಿ. ಅಲ್ಲ ನಾನು ಕಂಟೆಸ್ಟ್ ಮಾಡೋಕೆ
ನೀವು ರೆಡಿ ಇದಿರಲ್ಲ, ಕೊಡಿ ಅಷ್ಟೇ. ದಟ್ಸ್ ಆಲ್.
ಹಾಗಾದ್ರೆ ನಾನು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ತಗೊಂಡೆ.
ಏನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್?
ಅಲ್ಲ ನೆಕ್ಸ್ಟ್
ನೋ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್. ಈಗ ಆಲ್ರೆಡಿ ನಾನು ಹರ್ಡ್.
ನನಗೆ ಬಂದೆ ಅಲ್ಲ ನನ್ಗೆ ಅವ್ರದ್ದು ನಾನು ಸಿಕ್ಕಿಲ್ಲ ಸ್ವಾಮಿ.
ಏನ್ ಸಿಕ್ಕಿಲ್ಲ?
ಪೆಟಿಷನರ್ ಸಿಕ್ಕಿಲ್ಲ.
ಪಿಟಿಷನರ್ ಯಾಕೆ ಸಿಗ್ಬೇಕು? ಕೋರ್ಟ್ ಆರ್ಡರ್ ಮೆರಿಟ್ಸ್ ಮೇಲೆ. ನಾನು ಕೇಳಿದ್ದು 3000 ರೂಪಾಯಿ ಮ್ಯಾನೇಜ್ ಮಾಡಕ್ ಆಗುತ್ತಾ ಅಂತ ಕೇಳಿದೆ. ಗ್ರೌಂಡ್ಸ್ ಏನಾರು ಹೇಳಿ ಇನ್ನೂ ಇದ್ರು ಕೇಳ್ತೀನಿ ನಾನು ಅಷ್ಟೇ. ಕೋರ್ಟ್ ಫಾರ್ಮ್ ಒಪಿನಿಯನ್ ಯು ಕ್ಯಾನಾಟ್ ಸೀಕ್ ಎನಿ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್.
ಸೆಟ್ಲ್ ಆಗಿರಬಹುದು ಕೇಳ್ಬಿಟ್ಟು ಹೇಳಿ.
ನೋ ನೋಡಿ, ಐ ವಿಲ್ ಡಿಕ್ಟೇಟ್ ದಿ ಆರ್ಡರ್. ನೋ ಕೌನ್ಸಿಲ್
ಮೈ ಲಾರ್ಡ್, ಐ ರಿಕ್ವೆಸ್ಟ್. ಅಲ್ಲ
ಏನ್ರಿ ಇದು?
ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಲ್ದಿರ ನಾನು ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಲ್ದಿರ ಇದು ಮಾಡಿ.
ನೋಡಿ, ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಅಂತ ಅಷ್ಟೇ. ಏನ್ರಿ? ಪುಣ್ಯಾತ್ಮ ಅವನ ಜಡ್ಜ್ ಬರೀ 1000 ರೂಪಾಯಿ ಕೊಟ್ಟವನ. ಮೂರ್ ಮಗ ಹೆಂಡತಿಗೆ 1000, ಮಕ್ಳಿಗೆ 2, 1000. ಅದನ್ನ ಎನೌನ್ಸ್ ಮಾಡಿರದೆ 3000. ಅದಕ್ಕೂ ನೀವು ತಕರಾರು. ಒಂದ್ ಅಕ್ಕಿಗೆ ಇವತ್ತು 50 ರೂಪಾಯಿ ಕೆಜಿ. ಅಲ್ಲದೆ 50 ರೂಪಾಯಿ ಕೆಜಿ. IWSSP ಬೆಂಗಳೂರ
ಯಾಕಂದ್ರೆ ಪೆಟ್ರೋಲ್ ಮನೆ ಮೇಂಟೆನೆನ್ಸ್ ಇವ್ರಿಗೆ 10,000 ರೂಪಾಯಿ.
2 ಮಕ್ಳು ಯಾಕೆ ಮಾಡ್ಕೊಂಡ್ರಿ? ಒಂದೇ ಸಾಕಾಗಿತ್ತಲ್ಲ. ಹೆಂಡತಿ ಒಂದ್ ಮಗು ಸಾಕಾಗಿತ್ತಲ್ವಾ? ಮತ್ತೆ ಆವಾಗ ಇದಿರ್ಲಿಲ್ಲ. ಈಗ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ನಂಗೆ 9000 ಕೊಡಕ್ ಈಗ ಕೊಡ್ಬೇಕಾದ್ರೆ 9000. ನಿಮ್ಗೆ ಸಂಬಳ ಎಷ್ಟು ಬರ್ತದೆ ಹೇಳಿ? ನಾಳೆ ನೀವು ಗುರುವಾರ ನಂಗೆ ಈ ಪ್ರೆಸೆಂಟ್ ಸ್ಯಾಲರಿ ಸರ್ಟಿಫಿಕೇಟ್ ತರ್ಬೇಕು. ಯಾವತ್ ಬೇಕು? ಗುರುವಾರ. ಕನ್ಸಲ್ಟ್ ಮಾಡೋದಲ್ಲ, ತರ್ಬೇಕು. ನೀವು ಕನ್ಸಲ್ಟ್ ಮಾಡೋದಲ್ಲ, ತರ್ಬೇಕು. ಈಗ ಸ್ಯಾಲರಿ ಸರ್ಟಿಫಿಕೇಟ್ ನೋಡೋಣ ಎಷ್ಟು ಅಂತ. ಸಿಕ್ಕೇ ಇಲ್ಲ ಅಂದ್ರೆ ಮತ್ತೆ ಟೈಮ್ ಕೇಳ್ತೀರಿ ಬಿಡಿ, ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ. Why you are seeking time? Why you are seeking time then? ಅಲ್ಲ ರೀ, 2012 ಹೋಗ್ಲಿ ಮೇಂಟೆನೆನ್ಸ್ ಕೊಡ್ತಾ ಇದ್ದೀರಿಲ್ಲ? ಏನೋ ಸ್ಟೇ ಇದೆಯಾ ನೋಡಿ ಮೇಡಮ್.
ಪ್ರಾಬಬ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿರ್ಬೋದು ಅನ್ಕೊಂಡಿದ್ವಿ. ಕೇಳ್ಬಿಟ್ಟು ಹೇಳ್ತೀವಿ ಪ್ರಾಬಬ್ಲಿ. ಯಾಕಂದ್ರೆ ಇಷ್ಟು ದಿವಸ ನನಗೆ ಕನ್ಸಲ್ಟ್ ಮಾಡಿಲ್ಲ, ಹಾಗಾಗಿ ಸಡನ್ ಆಗಿ ಬಂದಿದೆ ಮಾಡಿ.
ಆಯ್ತು, ಥರ್ಸ್ಡೇ ಎಷ್ಟು ಡೇಟ್ ಮೇಡಮ್? 3rd or 4th? 3rd. ಯಾರೀ? GS ಪ್ರಸನ್ನ ಕುಮಾರ್ ಇವ್ರು ಬರಲ್ವಾ? ಫೀಸ್ ಇಸ್ಕೊಂಡ್ ಜಾಬ್ಗೆ ಇಟ್ಕೊಳ್ಳೋದು ಅಷ್ಟೇನೆ. ಇಲ್ಲಿ ಬಂದ್ಬಿಟ್ಟು ಕ್ಲೈಂಟ್ ಪರವಾಗಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಂಗಿಲ್ಲ. ಆಮೇಲೆ ಮರದ ಕೆಳಗಡೆ ಕೂತ್ಕೊಂಡು ಬಾಯಿ ಬಂದಿದ್ ಮಾತಾಡೋದು.
ಥರ್ಸ್ಡೇ ನಮ್ಮ ಫಾದರ್ ಸರ್ ಬಂದಿದ್ದಾರೆ. ಫ್ರೈಡೆ. ಸಾರಿ ಮೇಡಮ್.
4th. CM Desai. Sohani Holla.
I appear for the respondent.
For respondent. Yes. What is the matter, madam? Amicus curiae.
Amicus curiae. It's been there is a misappropriation. It's an offence under section 406 and 408 of IPC.
Madam, what happened last occasion? ಬರೋದಿಲ್ಲ ಕೋರ್ಟ್ಗೆ, ಬರೀ ರಿವಿಷನ್ ಪಿಟಿಷನ್. ಅದೇ ಹೇಳಿದ್ನಲ್ಲ, ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್. ಎಸ್ ಸರಿ. Revision petition of the year 2013. Matter came to be admitted on 14/10/24. There is no progress in the matter. So even there is no representation in the interest. Release this matter on 26/7/21. ಯಾವತ್ತೂ ಬರೋದಿಲ್ಲ ಕೋರ್ಟ್ಗೆ. Any stay order, madam?
ಇಲ್ಲ ಸ್ವಾಮಿ.
Then you proceed with the matter. Take NBW and proceed and execute the order. That's all. Because counsel is not representing, not coming before the court. We execute the sentence, that's all. How many times this court has to give time, and how many matters court can appoint the amicus curiae also. Remained unrepresented. Appoints as amicus curiae to represent respondent to meet ends of justice. Now, petitioner counsel is not coming. None present for the petitioner. Sorry, madam. Respondent counsel is the respondent amicus curiae is present. Petitioner counsel is absent. In the previous occasion on 21/12/21, none present for the revision petitioner. So heard the learned commissioner then adu bera ide. And order sheet reveals that heard the respondent amicus curiae. Heard the learned amicus curiae for the revision petitioner antide. Revision petitioner ge amicus curiae appoint agidara. Only respondent ge.
Only for the respondent.
ಏನಾರು ಆಗಿದೆಯಾ ನೋಡಿ, ಯಾರನ್ನಾರು ಅಪಾಯಿಂಟ್ ಆಗಿದೆಯಾ ನೋಡಿ ಅಮಿಕಸ್ ಕ್ಯೂರಿ. ರೆಸ್ಪಾಂಡೆಂಟ್ ಮತ್ತೆ ಆರ್ಡರ್ ಮಾಡಿ. In order to facilitate the respondent, if so and so appointed as amicus curiae to represent the respondent. ನಂತರದಲ್ಲಿ ಏನಾದ್ರೂ ಇದೆಯಲ್ಲ ಮೇಡಮ್, ಎಲ್ಲ ಆರ್ಡರ್ ಮಾಡೋದು ಯಾವಾಗ ಮತ್ತೊಂದ್ಸರಿ ಏನಾಗಿದೆಯಲ್ಲ ಅಲ್ವಾ? ಈಗ ನಾನು ಓದಿದ್ದ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಹರ್ಡ್ ಅಂತೇನ ಬಂತಲ್ಲ, ಇದಾದ್ಮೇಲೆ ಮತ್ತೊಂದು ಆರ್ಡರ್ ಹಾಕಿದ್ಲೆ, ಇಲ್ಲೊಂದು ಆಗಿದೆ ಹರ್ಡ್ ದಿ ಅಮಿಕಸ್ ಕ್ಯೂರಿ ರೆಸ್ಪಾಂಡೆಂಟ್ ಇರ್ಬೇಕು. ಅದು ಏನಾಯ್ತು ಮೇಡಮ್ ಲಾಸ್ಟ್ ಇದು? ಬೇಡ, ಅದೇನ್ ಬೇಡ. And if the counsel appearing for the petitioner doesn't appear in the next state of hearing, amicus curiae will be appointed. Again 409 and 408 or 409. This matter on 14th March. 54. 14th March, madam.
Yes, your lord.
March. Sri Shaila A. Hubli. What is the reason for adjournment? Only 2013 revision. He can say record after 1 decade and say record secure ಮಾಡೋದು. Oh, not expected. Petitioner counsel 6 weeks time. And this matter on 14th. 2 ವಾರ ಕೊಟ್ಟಿದ್ದೀನಿ. ಆಯ್ತು, ಅವತ್ತು ರೆಡಿ ಆಗಿ ಬನ್ನಿ ಅಷ್ಟು. PM Matthew. Not the learned counsel for the revision petitioner. Admit ಆಗಿರೋದು ಇದು 2017. ಆಮೇಲೆ ಬಂದಿರೋದೇ ಈಗಲ್ಲ ಮೇಡಮ್. Petitioner counsel is absent. This matter on 14th March. 56 ಸತ್ಯನಾರಾಯಣ ಚಲ್ಕೆ. ಇದು ಯಾವಾಗ ಲಿಸ್ಟ್ ಆಗಿರೋದು ನೋಡಿ ಮೇಡಮ್. ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಎಲ್ಲ ಆಗ್ಲೇನಾ? 2013 ಅಲ್ಲಿ 13 ಇಂದ ಇಲ್ಲಿವರೆಗೆ ಬಂದೇ ಇಲ್ಲ. 10 ವರ್ಷ ರಿವಿಷನ್ ಪಿಟಿಷನ್. This matter was admitted in 2013 and thereafter matter not listed. And today no representation. This matter on 14th. ವಿಶ್ವನಾಥ ಪೂಜಾರಿ. ಅದೆಲ್ಲ ನಾವು ಮಲಗಿದ್ದವೆಲ್ಲ ಹೇಳ್ಸಿದೀವಿ ಅಷ್ಟೇ. ವಿಶ್ವನಾಥ ಪೂಜಾರಿ ಕೆ ಇದು ಅಷ್ಟೇನಾ? ಯಾವ ಇಯರ್? 14. This matter was listed in 2014 and none appears, and thereafter listed today only. One more opportunity is given. List this matter on 14. A. N. Radhakrishna 58. A. N. Radhakrishna ಹೇಳ್ರಿ. ಪಾಸ್ ಅವರ್ ಎಷ್ಟು ಟೈಮ್? 4 ಕಾಲು ಪಾಸ್ ಅವರ್ ಮಾಡ್ಯಾರ ನೋಡೋದು. ಎಲ್ಲ ಬೇಲ್ಗೆಲ್ಲ ಮಾತ್ರ ಬಂದು ನಿಂತಿರ್ತಾರ ಲಾಯರ್ಸ್ಗಳು. ಓನ್ಲಿ ಫಾರ್ ಬೇಲ್ ಪಿಟಿಷನ್, ಮೆಂಟ್ ಫಾರ್ ಅಡ್ವೊಕೇಟ್ಸ್ ಆರ್ ಮೆಂಟ್ ಫಾರ್ ಓನ್ಲಿ ಫಾರ್ ಬೇಲ್ ಪಿಟಿಷನ್. ಇರೋದೇ ಹೇಳ್ಬಿಟ್ರೆ ಕೋರ್ಟಲ್ಲಿ ಬೈತಾರ. ಇಟ್ ಇಸ್ ಅಶೇಮ್ ಆನ್ ದಿ ಅಡ್ವೊಕೇಸಿ. ನೋಡಿ ಪಿಟಿಷನ್, ನೀವು ಜೂನಿಯರ್ ಕೌನ್ಸಿಲ್ ನೀವು ಓದ್ಲಿಲ್ವಾ? ಯಾಕೆ ಓದ್ಲಿಲ್ಲ? ಎಷ್ಟು ವರ್ಷ ಆಗಿದೆ ಎನ್ರೋಲ್ ಆಗಿ? 1 ವರ್ಷ. ಇನ್ನೆಷ್ಟು ವರ್ಷ ಬೇಕು? ಫೈಲ್ ಓಪನ್ ಮಾಡಿದ್ರಿಲ್ಲ, ಏನ್ ಕೇಸ್ ಏನು? ಮತ್ ನೀವು ಅದನ್ನ ಮಾಡಕ್ ಸೀನಿಯರ್ ಬೇಕಾ? ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ನೀವು ಫೈಲ್ ಓದಿ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಕೊಡ್ತದೆ. ಫೈಲ್ ಓಪನ್ ಮಾಡಿ ಏನ್ ಮೇಲೆ ಕೇಸ್ ಹಾಕಿದಾರ ನೋಡಿ, ಎಷ್ಟು ಜನ ವಿಟ್ನೆಸ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದಾರ ನೋಡಿ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಫೈಂಡಿಂಗ್ ಕೊಟ್ಟಿದಾರ ನೋಡಿ, ಆಮೇಲೆ ಅಪೀಲ್ ಅಲ್ಲಿ ಏನ್ ರೀಸನಿಂಗ್ ಕೊಟ್ಟಿದಾರ ನೋಡಿ, ಆಮೇಲೆ ನಿಮ್ ಸೀನಿಯರ್ ರಿವಿಷನ್ ಫೈಲ್ ಮಾಡುವಾಗ ಏನ್ ಗ್ರೌಂಡ್ಸ್ ರೆಡಿ ಮಾಡಿದಾರೆ ನೋಡಿ. ನಾಡಿದ್ದು ಕೊಡ್ತೀನಿ, ಡೇಟ್ ಓದ್ಕೊ ಬರ್ತೀರಾ? ಆಯ್ತು. 2 ವೀಕ್ಸ್ ಎಲ್ಲ ಕೊಡೋದಿಲ್ಲ. ಯಾಕೆ? ಇವತ್ತೇ ಹೋಗಿ ಹೋಮ್ವರ್ಕ್ ಮಾಡ್ಬೇಕು. ಆಯ್ತು. ಪಿಟಿಷನರ್ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಆಬ್ಸೆಂಟ್, ಜೂನಿಯರ್ ಕೌನ್ಸಿಲ್ 6 ಟೈಮ್. ಮ್ಯಾಟರ್ ಆಫ್ ದಿ ಇಯರ್ 2013. ಲಿಸ್ಟ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಆನ್ 14th March. ಆಯ್ತು, 2 ವಾರ ಕೊಟ್ಟಿದ್ದೀನಿ, ನೀವೇ ಬರ್ಬೇಕು. ಲಕ್ಷ್ಮೀನಾರಾಯಣ
ಆಗಿರೋದು 2013 ಅಲ್ಲಿ. ಜನವರಿನಲ್ಲಿ
ಹಾಸ್ಪಿಟಲ್ ಮೇಲೆ ಬಂದಿರೋದು, ಅಡ್ಮಿಟ್ ಆಗಿರೋದು ಬಂದಿದೆ, ಜನವರಿ ಬಂದಿದೆ. ತಗೊಳ್ಳಿ. This is the matter of the year 2013. No representation by the petitioner counsel. List this matter on 14th March. Yes, madam. Yes. No adjournment, madam. No adjournment. Argue.
Your Lordship, actually the file has been
File? What happened to file?
It's been misplaced, Your Lordship. I was searching.
Misplaced?
Yes.
Why it was misplaced? Because this is 1 decade matter. That is the reason. That's why it was misplaced.
It's coming up first time.
First time. Last time ಯಾವಾಗ madam ಲಿಸ್ಟ್ ಆಗಿರೋದು ನೋಡಿ? When it was listed, madam? 2014. Petitioner counsel submits that file is misplaced and seeks time. List this matter on 14th March. Again, no such reason, madam?
Yes, sir.
ಪೃಥ್ವಿ ಒಡೆಯರ್ ಬನ್ರಿ. ನೀವಾದ್ರೂ ಕೆಲಸ ಕೊಡಿ ಕೋರ್ಟಿಗೆ, ನೋಡೋಣ. ಕೊಡ್ತೀರಾ? ಆಯ್ತು ನೋಡಿ. ಕನ್ಕರೆಂಟ್ ಪೆಂಡಿಂಗ್. ಮೆಟೀರಿಯಲ್ ಎವಿಡೆನ್ಸ್ ಇದೆಯಾ ಮೇಡಮ್? ಡ್ರೈವರ್ ಆಫ್ ದಿ BMTC ಬಸ್. BMTC bus stand. While taking turn, while entering the BMTC bus stand or months.
Statements in my lord.
PW 1, 2, 3. What they say? Whether he was present at this spot? He was along with the deceased. Suresh Babu, 42 years, car driver. Second ring in front of Nandini Milk Parlor, a bus number so came over speed, dashed against my mother. She fell down, became unconscious, shifted to KC General Hospital, thereafter to Nimans, where she succumbed to the injuries. I lodged the complaint. Speech. Were returning from Annamma temple, were returning to go to home. What he says, cross examination, it is true that there were other buses going into the bus stand. There were no other bus were going in front of offending bus. It is true that there were other people were also crossing in the bus stand. I was 5 feet behind my mother. The police have not taken my statement at the time of inquest. It is not true. I stated before the police that I was going 5 feet forward of my mother. It is not true. I was not at all accompanied my mother on the date of the accident. It is not true. Buses cannot go by overspeed to get into the bus stand. There is no nexus between the accident and accused. It is not true. Some other vehicle hit against my mother. Since I was in hospital, I have lodged complaint on the next day. Oh, he also sustained injury. Okay. So since I was in the hospital, no public gave the telephone number to me. On the next day, police came to the spot around 10 a.m. I do not know the name of policeman. I did not know this. I did not. I'm not aware of the contents of the answer. What you have elicited in the cross examination? Agantidiya complaint ಅಲ್ಲಿ ಏನಿದೆ ಕಂಪ್ಲೇಂಟ್ P1
ನನಗೆ ಪೂರ್ವದಿಂದ ಪಶ್ಚಿಮ ಕಡೆಗೆ ರಸ್ತೆ ದಾಟುತ್ತಿರುವಾಗ ನಾನು
ಮುಂದೆ ಹೋಗುತ್ತಿದ್ದು ಅದೇ ಮುಂದೆ ಹೋಗ್ತಿದ್ದು ತಾಯಿ ಮುಂದೆ ಹೋಗ್ತಿದ್ರು ನಾನು ಹಿಂದಿದ್ದೆ ಅಂತ ನೋಡಿ ಕ್ಲಾಸಲ್ಲಿ ನಾನೇ ಮುಂದೆ ಇದ್ದೆ ಅಂತ ಹೌದಾ ಐ ವಾಸ್ 5 feet ಬಿಹೈಂಡ್ ಮೈ ಮದರ್ ಕರೆಕ್ಟ್ ಆಗಿದೆಯಲ್ರಿ ಐ ವಾಸ್ 5 feet ಬಿಹೈಂಡ್ ಮೈ ಮದರ್ ಎರಡನೇ ನಲ್ಲಿ ಪೂರ್ವದಿಂದ ಪಶ್ಚಿಮ ಕಡೆಗೆ ರಸ್ತೆ ದಾಟುತ್ತಿರುವಾಗ ನನ್ನ ತಾಯಿ ನನಗಿಂತ 4-5 ಅಡಿ ದೂರದಲ್ಲಿ ಮುಂದೆ ಹೋಗುತ್ತಿದ್ದು ಅಂತಿದೆ ನಾನು ಅವರ ಹಿಂದೆ ಹೋಗುತ್ತಿರುವಾಗ ಒಬ್ಬ ಬಿಎಂಟಿಸಿ ಬಸ್ ನಂಬರ್ ಚಾಲಕ ಸರ್ವಿಸ್ ರಸ್ತೆಯಲ್ಲಿ ಪೂರ್ವದಿಂದ ಪಶ್ಚಿಮದ ಕಡೆಗೆ ಅತಿ ವೇಗ ಹಾಗೂ ಅಜಾಗರೂಕತೆಯಿಂದ ಚಾಲನೆ ಮಾಡಿಕೊಂಡು ಬಂದು ಉತ್ತರದ ಕಡೆಗೆ ಬಲ ತಿರುವು ತೆಗೆದುಕೊಂಡು ಸದರಿ ರಸ್ತೆಯಲ್ಲಿ ರಸ್ತೆ ದಾಟುತ್ತಿದ್ದ ನನ್ನ ತಾಯಿಗೆ ಡಿಕ್ಕಿ ಮಾಡಿದನು ಅದೇ ಬಸ್ಸಿನಲ್ಲಿ ನನ್ನ ತಾಯಿಯನ್ನು ಕೆಸಿ ಜನರಲ್ ಆಸ್ಪತ್ರೆಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿ ಚಿಕಿತ್ಸೆ ದಾಖಲೆ ಮಾಡಿದ್ದು ಬಸ್ಸಲ್ಲೇ ಕರ್ಕೊಂಡು ಹೋಗೋರನ್ರಿ ಮತ್ತೆ ಅಲ್ವಾ ಇಲ್ಲ ಅಂದ್ರೆ ಅವ್ನ್ ಬಸ್ ತಗೊಂಡೋಗ್ತಾನ ಬಸ್ಸಿನ ಚಾಲಕ ಹಾಗೂ ನಿಮಾನ್ಸ್ ಆಸ್ಪತ್ರೆಗೆ ಆಂಬುಲೆನ್ಸ್ ನಲ್ಲಿ ಕಳಿಸಿಕೊಟ್ಟರು ಬಸ್ಸಿನ ಚಾಲಕ ಹಾಗೂ ಬರುವುದಾಗಿ ತಿಳಿಸಿ ಹೊರಟು ಹೋಗಿರುತ್ತಾರೆ ನಿಮಾನ್ಸ್ ಆಸ್ಪತ್ರೆ ತಾಯಿಗೆ ಚಿಕಿತ್ಸೆ ಫಲವಾಗಿ ರಾತ್ರಿ 11 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಮೃತಪಟ್ಟದಾಗಿ ವೈದ್ಯರು ತಿಳಿಸಿರುತ್ತಾರೆ ಆಯ್ತ್ರಿ ಜನ ಬಸ್ ಸ್ಟ್ಯಾಂಡ್ ಹತ್ರ ಕ್ರಾಸ್ ಮಾಡ್ತಾ ಇರ್ತಾರೆ ಮನುಷ್ಯ ಮೇಲೆಲ್ಲ ಹಚ್ಕೊಂಡು ಹೋಗ್ಬಿಡದ Since 6-7 months, I was working as Nandini Milk Parlor, JMTC bus stand. Meanwhile, a bus coming from entrance road going into the bus stand, and the bus came and dashed against a aged woman who was going from Milk Parlor towards public toilet. The bus came in over speed and dashed against said lorry. Injured shifted to hospital and where she succumbed to the. It is true many number of buses keep coming into the bus stand. It is true many number of publics pass through the said bus stand. It is not true to bus normally came slow and taken into ring of the bus stand. PW1 also supported, PW2 also supported. Before accident take place, some other publics were also passing through the spot of accident. In the suggestion, it is true before accident taken place, some other publics were also passing through the spot of accident. They are also not disputing the accident. I was at Majestic waiting for the bus to go to Hebbala. The said lady fell down, sustained injuries, was shifted to hospital. Dashed against a lorry, the lady who was walking across the road. Son of the victim was also present at the spot. The bus numbers also have given accused before the court. The driver of the bus was negligent and caused accident on the day. Three witnesses. ಏನ್ ಕಾಂಟ್ರಡಿಕ್ಷನ್ಸ್ ಇದೆ ಹೇಳ್ರಿ ನೀವು. ನೀವು PW1 ಏನೋ ಕಾಂಟ್ರಡಿಕ್ಷನ್ಸ್ ಅಂತ ಹೇಳಕ್ ಹೋದ್ರೆ ಅದು ಕರೆಕ್ಟ್ ಆಗಿದೆ. ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಏನಿದೆ ಅದನ್ನೇ PW3 ಏನ್ ಹೇಳ್ತಾರೆ? The victim was going in front of her son. ಅದು ಕರೆಕ್ಟ್ ಆಗಿ ಇದೆಯಲ್ರಿ? ಯಾಕೆ ನೀವು ಹಿಂಗ ಅಂತೀರಿ ನೋಡಿ? The victim was going in front of her son. ಅವನು ಹೇಳಿರೋದು ಅಷ್ಟೇ, ನನ್ನ ತಾಯಿ ಮುಂದೆ ಹೋಗ್ತಾ ಇದ್ಲು ಅಂತ. ಕಾಂಟ್ರಡಿಕ್ಷನ್ಸ್ ಏನ್ ಬರುತ್ತೆ? Corroborates, not contradictions. The distance between mother and son is 2 to 3 meters. ಅವಳೇ ಹೋಗ್ತಾ ಇದ್ಲು, ಮುಂದೆ ಹೋಗ್ತಾ ಇದ್ಲು ಮಗನಿಗಿಂತ ಮುಂಚೆ ಅಂತ ಹೇಳ್ತಾನೆ ಅವನು. ಏನ್ ಕಾಂಟ್ರಡಿಕ್ಷನ್ಸ್ ಇಲ್ವೇ ಅಲ್ವಲ್ಲ? ನೋ ಗ್ರೌಂಡ್ಸ್. ಕಂಟೆಂಟ್ಸ್ ಅಲ್ಲಿ ಏನಿದೆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಎಲ್ಲ ಸೇಮ್ ಇದೆ. ಕೊಡಿ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಕೊಡಿ, ಇಲ್ಲೇ ಇದೆ ಮೇಡಮ್. Detailed order has been passed by the trial court. ಅದು ಪನಿಷ್ಮೆಂಟ್ ಬರೀ 6 months ಕೊಟ್ಟಿದ್ದಾರೆ. That is minimum sentence. ಅಲ್ವಾ? Even punishment also 6 months. He himself took the injured to the hospital also. ನೋಡಿದ್ರ ನೀವು? 1 to 3 or 1 to 4? 1 to 3. PW5 is the doctor who conducted PM. PW4?
PW4 is the doctor, my lord, was conducted.
4 doctor, PW5?
He's also an eyewitness, my lord.
Why?
PW1, my lord, is the son of.
Son, he was along with the mother.
Okay,
and PW2 is the alle Nandini parlor ಅಲ್ಲಿ ಇದ್ದವನು ನೋಡಿದವನು.
PW3 was waiting for the bus. And PW5, my lord, also states that he was an eyewitness. PW2, 3 and 5, my lord, are all independent witnesses, my lord. And PW6, my lord, is the AV inspector who states that the accident has not occurred with any
mechanical defect. ಏನ್ರಿ ಸುಮ್ನಾಕ್. ಫೈನಾ? ಯಾವ ವರ್ಷ ಆಕ್ಸಿಡೆಂಟ್ ಆಗಿರೋದು? 12, 1 decade. 6 months ಇದೆಯಾ? ಎಷ್ಟು ಕೊಡ್ತೀರಿ ಅಮ್ಮನ್ಗೆ? ಅಮ್ಮನ್ ಯಾರು ಮಗ ಇದಾನ ಗಂಡ ಇದಾನ ಯಾರು? ಮಗ ಮಾತ್ರನ, ಗಂಡ ಯಾರು ಇಲ್ವಾ? ಏನ್ರಿ ನಾವೇ ಸ್ವಲ್ಪ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಮಾಡಿದ್ವಿ ಸುಮಾರು. ಏನ್ ಮಾಡೋದ್ ಜೈಲಲ್ಲಿ ಇಟ್ಕೊಂಡು ಏನ್ ಮಾಡೋದ್ರಿ? ಮತ್ ಸರ್ಕಾರವೇ ದುಡ್ಡು ಕೊಡ್ಬೇಕು, ಅವ್ರೇನೋ ದುಡ್ಡು ಕೊಡ್ತಾರೆ ನೋಡೋಣ ಕೇಳೋಣ. ಎಷ್ಟ್ ಕೊಡ್ತೀರಿ ಹೇಳ್ರಿ? KSRTC ಬಸ್ ಯಾವ ಬಸ್ ಇವನು? BMTC ಎಷ್ಟ್ ಕೊಡ್ತಾನೆ ಹೇಳಿ? ನಂದೇ ಜಡ್ಜ್ಮೆಂಟ್ ಸುಮಾರಿದೆ. ಅರ್ಲಿಯರ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆಫ್ ಜಸ್ಟಿಸ್ ಜಗನ್ನಾಥನ್ ಅಂಡ್ ಜಸ್ಟಿಸ್ ಸುರ್ವಾಡಿ ರಮೇಶ್ ಅವ್ರದೆಲ್ಲ ಬರ್ದು ನೋಡಿ ಮಾಡಿದೀನಿ. ಐ ಪಾಸ್ ಸೆವರಲ್ ಆರ್ಡರ್ಸ್. ಏನೇ 1 decade ಆಗಿದೆ. ಇವ್ರೇನ್ ಹೇಳ್ತಾರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವರು? ನೆಗ್ಲಿಜೆನ್ಸ್ ಸೆಂಟೆನ್ಸಿಂಗ್ ಪಾಲಿಸಿ. ಅದೇ ಇವ್ರು ಮಿನಿಮಮ್ ಆರು ಒಂದು 6 months ಕೊಡ್ಬೇಕು ಅಂತಾರೆ. ಏನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಅವ್ರು ದುಡ್ಡು ಕೊಡಕ್ ಬರಲ್ಲ ಅಂತ ಏನಾರು ಹೇಳಿದಾರ? The court had allowed the revision petition and reduced the quantum of sentence awarded by the judicial magistrate first class for the offences from 304A, reducing the sentence of already undergone, that is 15 days. The court referred to the decision of Balveer Singh also reproduced the 2 problems also explanations also. Bearing in mind galloping trend in road accidents in India and the devastating consequences visiting the victims and their families, criminal courts cannot treat the nature of the offence under section 304A of IPC as attracting the benevolent provisions of 4 of the Probation Offenders Act. So considering the quantum of sentence to be imposed for the offence of causing death by rash negligent driving, one of the prime considerations should be deterrence. The professional driver pedals the accelerator of the automobile also. He must constantly inform him that luxuries also. He cannot should take a chance thinking that a rash driving need not necessarily cause any accident or also. Convicted, he would be dealt with leniently by the court. He must always keep in his mind the fear cycle that if he is convicted of the offence for causing death of a human or also, there is a whole role of courts to play, particularly at the level of trial court for lessening the high rate of motor accident due to careless driving of automobiles. ಏನ್ ಮಾಡಿರೋ ಅರ್ಲಿಯರ್ ಆಮೇಲೆ ಪೂರ್ತಿ 24 ಜಡ್ಜ್ಮೆಂಟ್ ಏನೋ ಡಿಸ್ಕಸ್ ಮಾಡಿದಾರೆ. ಆಯ್ತು.
Such a great sort of mistake of many others around them. That is the sake of their work. In our view, the sentence of 1 year has been affirmed by the
ಕೊಡ್ಬೇಡಿ ದುಡ್ಡು ಅಂತಾರೆ, ಪರಿಹಾರ ಏನು ಕೊಡ್ಬೇಕು ಹೋಗ್ಬೇಡಿ, ಕೊಡ್ಕೊಡ್ದು ಇಟ್ ಇಸ್ ಎ ಮಾಕರಿ ಆಫ್ ಜಸ್ಟಿಸ್ ಅಂತ ಬರೀತಾರೆ. ನೋಡಿ ಯಾವ್ದಾರು ಜಡ್ಜ್ಮೆಂಟ್ ಸಿಗುತ್ತಾ ನೋಡಿ, ಪಾರ್ಟ್ ಔಟ್ ಮಾಡಿರ್ತೀನಿ, ಥರ್ಸ್ಡೇಗೆ ಹಾಕ್ತೀನಿ ಆಯ್ತಾ, ನೀವು ನೋಡಿ. ಮಾಕರಿ ಆಫ್ ಜಸ್ಟಿಸ್ ಅಂತಾರೆ. ಏನೋ ರೀಸೆಂಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಏನಾದ್ರು ಇದೆಯಾ ನೋಡಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್. ಯಾಕೆಂದ್ರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನವ್ರು ಈ ತರ ಬರ್ದ್ಮೇಲೆ ನಾವು ಕನ್ಸಿಡರ್ ಮಾಡಕ್ ಬರಲ್ಲ. ಅರ್ಲಿಯರ್ ಐ ಹ್ಯಾವ್ ಕನ್ಸಿಡರ್ಡ್ ಜಡ್ಜ್ಮೆಂಟ್ ಆಫ್ ಜಸ್ಟಿಸ್ ಜಗನ್ನಾಥನ್ ಅವ್ರದ್ದು ಮತ್ತೆ ಇನ್ನೊಂದ್ 2-3 ಮಾಡಿ ನಾನೇ ಮಾಡಿದ್ದೆ. ನೋಡಿ ಮೇಡಮ್, ಹರ್ಡ್ ಇನ್ ಪಾರ್ಟ್ ಹಿಂಗೆ ಹಾಕ್ಬಿಡಿ. ಹರ್ಡ್ ಬೋತ್ ದಿ ಕೌನ್ಸಿಲ್. The council appearing of the state relied upon the judgment reported in 2015 within bracket 5 Supreme Court cases 182. The petitioner council seeks time to place the citation. And hence this matter on Thursday, fourth ಅಲ್ಲ, third ಆಗುತ್ತಾ? ಆಯ್ತು, third. ಮಲ್ಲೇಗೌಡ HP. PK, one time offense ಏನ್ರಿ? ಏನ್ ಮ್ಯಾಟ್ರ್ ಏನು? 138 ಯಾರು ಅದರ್ ಸೈಡ್ ಇಲ್ವೇ ಇಲ್ಲವಲ್ಲ ಈಗ? ಕಾಂಪ್ರಮೈಸ್ ಏನು ಇಲ್ವಲ್ಲ ಈಗ? ಯಾರು ಇಲ್ಲಲ್ಲ, ಅವರು ಅದರ್ ಸೈಡ್ ಇಲ್ಲ. ಆಯ್ತು. Petitioner counsel seeks time list this matter on 14th March. ಅವತ್ತು ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಇಲ್ಲ ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಇಷ್ಟೆಲ್ಲ ವರ್ಷ ಇಟ್ಕೊಂಡು ಕುತ್ಕೊಳ್ಳೋಕ್ಕಾಗಲ್ಲ. ಕೃಷ್ಣಮೂರ್ತಿ P.
I am ready to comment argument. I am ready to argue the matter. On the last date as well, I made this up. On the last date, it was recorded that if the petitioner counsel is absent or mistake, interim order was passed in their favor. Interim order states prison sentence of 1 year might not be back to the lower court. That has to be vacated and NPWP issued against the petitioner might not be.
Some order has been passed. 1 minute. Wait. Therefore, the petitioner counsel shall be present without fail until the order has been passed. But they argue the case, this court will consider the suspension sentence. Pendency of the case, it is made clear that if the learned counsel for the petition did not appear and argue the case, then this court will reconsider the suspension and sentence order passed earlier and proceed with the case. Accordance with law. But the stay agreement, earlier within court. The order sheet reveals that petitioner counsel is not pursuing the matter, but respondent counsel was present on 19/1/2022, and on 22/12/21 also none appears for the petitioner, and even on 4/12/2021, this court also with order dated 11/2/22, when the counsel not appeared, made an observation that looking at the pendency of the case, it is made clear that if the learned counsel for the petitioner did not appear and argue the case, then this court will consider the suspension and sentence order passed earlier and proceed with the case in accordance with law. And directed petitioner counsel shall be present without fail. In spite of this direction, counsel is not appeared before the court, and hence the earlier order of suspending the sentence is hereby recalled. Post this matter on 14th. K. Prasanna Shetty, Chandranath Ariga. ಏನ್ರಿ ಮ್ಯಾಟ್ರ್? ಏನಾಗಿದೆ ಲಾಸ್ಟ್ ಟೈಮ್ ನೋಡಿ ಪಿಟಿಷನ್? Divergent finding. Petitioner counsel ಏನಾಗಿದೆ ನೋಡಿ. ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದಾರಾ ಹಿಂದಿನ ಸಾರಿ ನೋಡಿ. This matter is listed at the request of petitioner counsel on several occasions. Today no representation. Respondent counsel for R1 is present. This matter on 14th. ಏನೋ ಸ್ಟೇ ಇದೆಯಾ? ಅಪಲೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಕ್ವಿಟಲ್ ಆಗಿದೆ. ಅಪರೇಟ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಕ್ವಿಟಲ್ ಆದ್ರೆ ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದ್ದಾಗ ಅಪೀಲೇ ಫೈಲ್ ಮಾಡ್ಬೇಕು. ರಿವಿಷನ್ ಹೆಂಗ್ ಫೈಲ್ ಮಾಡ್ತಾರ? ಹೌ ದಿಸ್ ರಿವಿಷನ್ ಇಸ್ ಮೇಂಟೈನಬಲ್? ಫಸ್ಟ್ ಕನ್ವಿಕ್ಷನ್ ಆಯ್ತು, ಅದ್ರಲ್ಲಿ ಅಕ್ವಿಟಲ್ ಆಯ್ತಲ್ಲ, ಈಗ ಕನ್ವಿಕ್ಷನ್ ಆಗಿತ್ತು, ಅಕ್ವಿಟಲ್ ಆಯ್ತು. ಅಕ್ವಿಟಲ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ರಿವಿಷನ್ ಹೆಂಗ್ ಬರುತ್ತೆ? ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದ್ರೆ ರಿವಿಷನ್ ಬರುತ್ತೆ, ಆರ್ ಅದರ್ವೈಸ್ ಅಗೇನ್ ಅಪೀಲ್ ಬರ್ಬೇಕು, ಮತ್ತೆ ರೀಅಪ್ರಿಶಿಯೇಟ್ ಮಾಡ್ಬೇಕಲ್ಲ. ಐ ಓನ್ಲಿ ನೋಟ್ ಆನ್ ಜಜ್ಮೆಂಟ್ ಬರ್ದಿದ್ದೀನಿ ನೋಡಿ, ಹಿಂದಿನ ಜಜ್ಮೆಂಟ್, ಡಿವಿಷನ್ ಬೆಂಚ್ ಜಜ್ಮೆಂಟ್ ಮತ್ತೆ ಗುಜರಾತ್ ಹೈಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ನ ರಿಲೇ ಮಾಡಿ ಐ ಓನ್ಲಿ ರೋಟ್ ದ ಜಜ್ಮೆಂಟ್. ಅಪೀಲ್ ಇಸ್ ಮೇಂಟೈನಬಲ್, ನಾಟ್ ದಿ ರಿವಿಷನ್ ಅಂತ. Because the matter was referred to the division bench based on the judgment of Justice Jawad Rahim. ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಮೇಲೆ ನಾವು ಒಂದು ಮ್ಯಾಟರ್ ರೆಫರ್ ಟು ದಿ ಡಿವಿಷನ್ ಬೆಂಚ್. ಡಿವಿಷನ್ ಬೆಂಚ್ ಆಲ್ಸೋ ಕಮ್ಸ್ ಟು ದಿ ಕನ್ಕ್ಲೂಷನ್ ದಟ್ ಅಪೀಲ್ ಲೈಸ್ ನಾಟ್ ದಿ ರಿವಿಷನ್ ಅಂತ. ಬಟ್ ದಟ್ ಆಲ್ಸೋ ಐ ಕನ್ಸಿಡರ್ಡ್ ಅಂಡ್ ಪಾಸ್ಡ್ an order, I think in the month of ಯಾವಾಗ ಮೇಡಮ್, ಅಕ್ಟೋಬರ್ ನವೆಂಬರ್ ಅಲ್ಲಿ ಮಾಡಿದ್ದೀನಿ ನಾನು, when I sat in criminal side before RSA RFA ಕೂರ್ಲಿಕ್ಕಿಂತ ಮುಂಚೆ. Not domestic violence, but anyhow it applicable to the both. Not on domestic violence. ನೋಡಿ ಒಂದ್ಸರಿ, you also examine it. 14th of March madam. Siddesh.
For me, one the adjournment for me, because we have to procure the lower court record illa summne adukoskara.
Petitioner counsel seeks time list this matter on 14th.
Oblige me.
Bhuvan. Varalakshmi. Madam, you are appearing for respondent. Petitioner counsel is absent, respondent counsel is present. This is the matter of the year 2015. If counsel doesn't appear in the next date of hearing, matter will be considered on merits in his absence. Is this matter on 14th. ಅಂಗಡಿ ಅವರು ಏನ್ರಿ ಇದು? ಏನದು? ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್. ಓಕೆ, ಬಟ್ ಇಸ್ ನಾಟ್ ಅವೈಲಬಲ್. ಆಯ್ತು, ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್ ಪ್ರಾವಿಷನ್ ಇದೆ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬೇಕಷ್ಟೇ. ಯು ಆರ್ಗ್ಯೂ, ಇಲ್ಲ ಪಾಸ್ ಆರ್ಡರ್ಸ್. ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಡೇಟ್ ಕೊಡ್ತೀನಿ. ಆಯ್ತು, ನೆಕ್ಸ್ಟ್ ಕೊಡ್ತೀರಿ, ಹಾಕಿ ಅದನ್ನ. ಬಟ್ ನೋ ಪ್ರಾವಿಷನ್ ಫಾರ್ ಬಿಫೋರ್ ದಿ ಹೈಕೋರ್ಟ್ ರಿಟರ್ನ್ ಸಬ್ಮಿಷನ್. ಬಟ್ ಅವ್ರು ಬರ್ದವ್ರು ನಾವೇನ್ ಮಾಡಕತ್ತೆ? ಆಲ್ರೆಡಿ ಡೆಪಾಸಿಟೆಡ್. ನೀವು ಇದ್ದೀರಾ ಅದರ್ ಸೈಡ್? ಇಬ್ರು ಇದ್ದೀರಿ. This court also passed an order. What is that order? Directed to deposit the amount. 138. So list this matter. Batavali madam, one meeting there. List this matter on 4th. I will hear 4th. 4th. Kodtira submission na. Petitioner counsel also submits return submission. Third.
I want to help my friend.
ಆಯ್ತು, 4ನೇ ತಾರೀಕು ಹಿಯರ್ ಮಾಡೋಣ. ಆಯ್ತು, 72 ಆಯ್ತು. 72 ಅರ್ಜೆಂಟ್ ಆದಂಗಿದೆ ಮೇಡಮ್, ಇಲ್ವಾ? ಹಾಲ ಶೆಟ್ಟಿ ಬೆಳಗ್ಗೆ ಯಾರಿಗೂ ಇಂಟಿಮೇಟ್ ಮಾಡಿ ಅಂದ್ವಿ. ಏನ್ ಮೇಡಮ್, ಯಾವಾಗ ಪಾಸ್ ಆನ್ ಮಾಡಿ? 4:45 ಮೇಡಮ್. ಆಯ್ತು, ಯಾವಾಗ ಬೇಕು ಹೇಳಿ, ಡೇಟ್ ಹೇಳಿ. ಯು ಕ್ಯಾನ್ ಗಿವ್ ಇಟ್, ನಾನು ಮಾಡಿದ್ದೀನಿ. ವೆನ್ ಡು ಯು ವಾಂಟ್ ಮೇಡಮ್? Petitioner counsel seeks time list this matter on 14th. P. Nataraj. petitioner counsel absent. This is the matter of 2019. Nodi. Yes, HCCP is present. List this matter on 14th March. Abhinav Ramanand.
I appear for the petitioner, my lord.
Yes, counsel. Thomas Vellapalli. You are for respondent. Are you ready? Are you ready? Other side is ready. Are you ready? I will hear both of you. What about your side, counsel? No parted. No parted. I 21 counsel Ramanand. Abhinav.
Any date that will be fixed by the court.
Next week, 14th, 7th, put in on.
14th ಹಾಕಬಹುದು ಸ್ವಾಮಿ.
14th ಹಾಕಬಹುದಾ? ಆಯ್ತು. Petitioner counsel present and respondent counsel says matter may be heard in part, but no such heard in part business. ಇಬ್ರು ಹೇಳಿದ್ರೆ ಇಲ್ಲೇ ಬರ್ದ್ ಬಿಡ್ತೀವ್ರಿ. ಮತ್ತೆ ನಿಮ್ಗೊಂದ್ಸರಿ ಏರ್ ಮಾಡೋದು ನಾವು ಅವ್ರು ಹಿಂದಿನ ದಿವಸ ಮರ್ತೋಗುತ್ತೆ. ನಾವು ಮತ್ತೆ ಅಗೇನ್ ರೀಕಲೆಕ್ಟ್. ಆಯ್ತು, ಲಿಸ್ಟ್ ತಗೊಳ್ಳಿ, ಬೇಡ ಏನು ಬರೆಯೋದು ಬೇಡ. This matter on 14th and 14th.
Lord, the judgment which my lords were referring to, my lord, passed in.
What happened in Supreme Court?
Supreme Court al pending ಇದೆ ಸ್ವಾಮಿ. Criminal appeal 309 of 2011 ಸ್ವಾಮಿ.
ಒಂದು ನಂಬರ್ ಅದು ಯಾರಿಗೋ ಹೇಳಿದ್ವಲ್ಲ, ಅದು 309. ಅವರೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದು, ಅದಕ್ಕೇನೆ ಅವರೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ದು. He has raised two grounds. ಒಂದು ಮೇಂಟೈನಬಿಲಿಟಿ ಮೇಲೆ, ಒಂದು ಆಮೇಲೆ ಇನ್ನೊಂದೇನಲ್ಲ.
ಹೌದು, ಅವರು
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ರಿಕಾಲ್ ಮಾಡಿ ಮತ್ತೆ ಆರ್ಡರ್ ಬರ್ತಿದೆ. ಸರಿ, 14th. ಓಕೆ. ಏನೋ ಸ್ಟೇ ಏನಾರು ಆಗಿದೆ ಆರ್ಡರ್?
ಸ್ಟೇ ಆಗಿದೆ ಸ್ವಾಮಿ.
ಹೌದಾ? ಸಬ್ಜೆಕ್ಟ್ ಟು ಡೆಪಾಸಿಟ್ ಅಥವಾ ಏನು?
ಸಬ್ಜೆಕ್ಟ್ ಟು ಡೆಪಾಸಿಟ್. ಅಂದ್ರೆ ಸೇಮ್ ಪಾಯಿಂಟ್. ಕ್ವೆಶ್ಚನ್ ಇಸ್ ವೆದರ್ a second appeal is made.
ಅದೇ appeal maintainable.
ಆ ಪಾಯಿಂಟ್ ಮೇಲೆ ಇಲ್ಲ ಅಂದ್ರೆ ನಾರ್ಮಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ will not interfere in
ಹೌದು
orders of the high court.
ಮೋಸ್ಟ್ಲಿ on that point ಇರಬಹುದು.
ಆ ಪಾಯಿಂಟ್ ಮೇಲೆ ಸುಮ್ಮನೆ.
ಯಾಕೆಂದ್ರೆ ಸ್ಕೋಪ್ ಎನ್ಲಾರ್ಜ್ ಆಗ್ತದೆ. ಅಕ್ವಿಟಲ್ ಆದ್ರೆ ಅಥವಾ ಕನ್ವಿಕ್ಷನ್ ಇದ್ದಾಗ, ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದ್ದಾಗ ರಿವಿಷನ್ ಅಲ್ಲಿ ಏನಾಗ್ಬಿಡ್ತದೆ, ಕನ್ಕರೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದ್ದಾಗ ಮಾತ್ರ ರಿವಿಷನ್ ಸ್ಕೋಪ್ ಲಿಮಿಟೆಡ್ ಇರ್ತದೆ. ಅದರ್ವೈಸ್ ಡೈವರ್ಜೆಂಟ್ ಫೈಂಡಿಂಗ್ ಇದ್ದಾಗ ಸ್ಕೋಪ್ ವಿಲ್ ಬಿ ಎನ್ಲಾರ್ಜ್.
ಅಲ್ಲ, ಮುಂಚೆ ಇಟ್ ವಾಸ್ ಅಕ್ಯೂಸ್ಡ್ ಓರಿಯೆಂಟೆಡ್ jurisprudence, now it is victim oriented jurisprudence. ಸೊ ಹಾಗಾಗಿ
ಏನಾ
10th August 2021. 10th August 2021
ಆರ್ಡರ್ ಆಗಿರೋದಾ? 10th August.
ಹೌದು.
ನೋಡಿ 10th August 21 ಅಂತ ಯಾರು ಅವ್ರು ಆರ್ಡರ್ ಆಯ್ತು ಕೌನ್ಸಿಲ್.
ಐ ಆಮ್ ಗ್ರೇಟ್ಫುಲ್.
ಥ್ಯಾಂಕ್ ಯು. ಅವ್ರಿಗೆ ಬರ್ಕೊಳ್ಳಿ ಮೇಡಮ್, ಅದು ಬೇಕಾದ್ರೆ ಯಾರು ಬಂದ್ರೆ ಕೇಳ್ಬಿಡಿ. 10th August ಅಂತ. August 21 ಅಲ್ಲಿ ಬರ್ದಿದ್ದೆ, ಬಟ್ ಮೋಸ್ಟ್ಲಿ ರಿಪೋರ್ಟಿಂಗ್ ಹಾಕಿದ್ದೀನಿ. ರಿಪೋರ್ಟಿಂಗ್ ಆಗಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ. ಆ ಜಜ್ಮೆಂಟ್ ಐ ಆಲ್ಸೋ ರೆಫರ್ಡ್ ಫಾರ್ ರಿಪೋರ್ಟಿಂಗ್ ಹಾಕಿದ್ದೀನಿ, ಬಟ್ ಯಾವ್ದ್ರಲ್ಲೂ ಬಂದಾಗಿಲ್ಲ, ನಾನು ನೋಡಿಲ್ಲ. ಮನುಪಾತ್ರದಲ್ಲಿ ಆಗಿರ್ಬೋದು ಅಷ್ಟೇ.
ಮನುಪಾತ್ರಲಾಗಿದೆ, SEC ಆಗಿದೆ.
ಆಗಿದೆಯಾ ಗೊತ್ತಿಲ್ಲ. ಆಯ್ತು ನೋಡಿ.